You know what? It's the CLE codes that I forgot. I'm so sorry. So at this time, I will be reading out the CLE codes and they will be displayed on the screen. And the first code is BPH25. And you may take down the slide. Now you can officially welcome our first panel.
Welcome, everyone. Thank you, Kaylee. My name is Thomas Lee. I'm the Leitner Family Professor of International Law here. My specialty that's relevant is actually warfare and the law of war. So it's particularly interesting for me to hear the comments of our illustrious panelists on this first panel, the historical and changing purposes of sanctions. Each of the panelists will speak for about 10 minutes each. I may then throw some rebuttal questions and then hopefully have some conversation among us and then open up the floor to questions. The panel will last until 10:30 a.m. And so the order, Professor Mulder, Professor Harrell, Professor Hovel, and then Professor Heath is the order that will proceed. And Professor Mulder, when you begin your historical scope, I'm wondering if you could start us off with the definition of sanctions, because I think that there's some ontological difficulties about what we're talking about. So I think it'd be the right way to get the day underway for us to sort of hear from the expert about what you mean exactly.
Great. Thank you very much to Fordham Law School and particularly to the organizers. It's a very nice gathering, a particular honor to be here as a historian at a law school also. So I will try not to bore you too much with too many things that have happened in the past, but I'm going to try and summarize things in broad conceptual terms, which I think will be helpful and recognizable to you, whether from an academic legal point of view or hopefully practitioners' viewpoints. So to address that question about what sanctions are, there are several ways of thinking about it, but my definition that I think is most useful is that it is an act of coercion that is aimed at some kind of economic exchange between countries that has the objective to really impede this interaction and block it and make it legally punishable or a violation if it were to occur. And I think that's important because that separates it from other kinds of economic coercion like tariffs, which make a transaction more expensive but don't actually impede it. Now, we bundle these things together today in terms like economic statecraft, but I think it's helpful to really recognize that there's a big gradation. Export controls are also part of this package, but that is really about controlling what firms domestically can and cannot export to other countries. So sanctions are really about interstate relations. They have an aspect of that. Of course, they do happen to be implemented through domestic law, but they have a much more significant international legal angle. I hope that that's helpful for
Excellent.
For working purposes. Yeah, okay, good. So I'll talk very briefly about the development of sanctions in the last 100 years. And I think with that definition, that sets us up nicely to go back to the First World War and the League of Nations, which is the organization that for the first time made it possible to undertake these kinds of acts of economic coercion, to uphold international law and an international order. And the final part I will say about sanctions is it is also very important to distinguish them from acts of economic warfare taken in an open conflict. Sanctions can be imposed by parties that are not part officially to a conflict. And so they happen in peacetime. And I think that's really key. What took place in the First World War was that a very large-scale international blockade effort was aimed by Allied countries against Germany and Austria-Hungary. That was perceived to have worked very well. And the people who ran that blockade effort went on to found the League of Nations. They were actually there at the Versailles Conference in 1919. So they wrote all these tools of economic coercion into the covenant of the League of Nations. And the original idea behind sanctions was that they actually were based on this blockade apparatus, and they were so frightening that they would not have to be used because blockade was associated with mass civilian starvation, very severe damage to the economic and social fabric of societies that were exposed to them. And the idea then strategically behind sanctions was as a deterrent. It was the ultimate enforcement mechanism, but one, the memory of the blockade had been so severe that hopefully it would not have to be used. So this bears some similarity to the way we can think about other coercive means that can be used in a deterrent fashion. And that scored some notable successes in the 20s, but in the 1930s, when the Great Depression happened, things got a lot more complicated. And the Second World War lifted that League of Nations sanctions model to the international level with US participation. So it's in 1945 that we really get something like the modern international legal order around the United Nations, where territorial aggression becomes the single most important thing that sanctions are used for, to enforce international law against it. And what is important there, however, is that a new set of objectives begins to creep into view. And this is why sanctions in the second half of the 20th century become much more wide-ranging, used for a much bigger set of purposes than just stopping war. Their early 20th century interwar goal was very simple. It was only about what states did to each other, and it was only about the supreme international crime, the crime of aggression. It didn't matter what political nature a country had. All sorts of domestic behaviors, domestic policies were not valid reasons to impose sanctions on another country. It's after World War II when we get the modern regime of human rights, but also the Cold War, of course, that sanctions really begin to be used to change the domestic behavior of states. And I think that's how we think of most sanctions cases today, right? They're for human rights violations, nuclear non-proliferation, the possession of certain weapons, but we can also think of all sorts of political behaviors, releasing political prisoners, and the right to protect, R2P. So it's the tendency across the 20th century in sanctions was a huge expansion of the purposes for which they could be used. And with that came also a switch, no longer as a deterrent, but as an actually applied instrument. So sanctions now were not something that was merely threatened. They had to actually be put into force in order to have some effect. And this, by the end of the 20th century and also into the early 21st century, I think has brought us to the situation where we are today, where we have a world where sanctions are used very widely for a wide range of goals. And there are many now areas of law that are implicated by sanctions that used to be domestic legal arenas that didn't necessarily have a sanctions angle to them. Sanctions have now entered it, so I think that's why we're all here. On the other hand, at the level of politics and international politics, the more sanctions have been used and the more they have become used as tools that you must apply, that you can't just threaten, the more countries have found ways of learning to live with sanctions. A lot of sanctions are imposed or are symbolic and are forgotten about. They somewhat impede international exchange, but they kind of remain in place. And what they do actually is signaling norms rather than try to change behavior. So it's also no longer necessarily accurate to try and judge all sanctions by whether they change behavior. Increasingly, I would say sanctions are functioning as a tool of demarcation in the international order. They're about which moral, legal, and economic community one belongs to. And with that has come a decrease in the effectiveness measured in terms of political effectiveness, right? Having the sort of political change that the architects of sanctions would like to see in the world. I think one of the things that is often missed is that with the increasing use of sanctions, the ambitions of countries using them have actually become more and more modest. A lot of times we impose sanctions also to show our domestic populations and constituencies that we care about certain norms, but not necessarily because we expect the targets of sanctions to always change their behavior. So this demarcation effect is now, I would argue, increasingly important, particularly because we are also in a different international economic order. And here I will put my economic historian hat on and say that one of the big shifts that we've seen in the last half century is a shift that we're in the middle of from a liberal international economic order to a more neo-mercantilist world order. What do I mean by that? Mercantilism in the 17th century was a philosophy that was based on the idea that resources in the world were limited, skills, industrial capacity, energy, food, etc. And I think in some important senses, policymakers around the world today are increasingly gripped again by the idea that resources, industrial capacity, etc., are limited and that countries are competing over them, and they will use a variety of tools in the economic statecraft toolbox to achieve that. And what we're seeing is a world of bloc formation, in a sense. Now, there's real limits to that, and this is not something that will replace the liberal world economy. There will still be globalization, there will still be large amounts of interdependence, but within these blocs that are demarcated by certain legal restrictions. And I think that particularly in the current moment, if we take a sober look at, for example, the way that the United States and the North Atlantic countries, the G7, relate to Russia and China, a lot of the more ambitious goals of sanctions have been given up. There was initially, for example, the hope that the sanctions imposed on Russia after the invasion of Ukraine would lead to a very quick turnaround or perhaps an economic collapse in Russia, financial crash. And while that did happen, the Russian economy recovered and is now 7 to 8% bigger than it was in 2021. Now, the sanctions have certainly been a drag on Russia, but they have not been nearly as successful as people had hoped. And I think that that is important because when we think about the history of sanctions, every few decades, we see that there had to be a major demonstrable success for this tool to continue to have some kind of normative force. In the early 20th century, it was the Allied victory over Germany in World War I. After World War II, there were a number of cases to do with decolonization, and particularly apartheid South Africa. And I think even recently, we can still point to some successes like the JCPOA deal with Iran as a success of sanctions for nuclear non-proliferation. So it is important to have large-scale successes in order to make sanctions viable and feasible as a tool. And here, I think the Russia sanctions that we are involved in the moment are a very high-stakes situation. They are significant and, in a sense, unprecedented for the size of the target. But this also comes with a number of built-in limits. The countries that have imposed sanctions on Russia represent almost half of global GDP. So that is very significant. But if we look at the number of sovereign states in the world that are participating, we see it's only about 38 to 40 countries out of almost 200 sovereign states. So it's about 20% of the global community measured in terms of sovereignty. And we can ascribe the non-participating or only partially participating 80% to all sorts of political chicanery. But I think the reality is that many countries do not feel like they are in a position to participate in sanctions on Russia for economic security reasons, for reasons of having secure access to food and energy. And in a sense, they see sanctions now as something that are a privilege of rich countries to be used because they themselves don't have a sense that they can expose their populations to this. So I think that that is a very important thing to keep in mind when we think about the broader normative background of the Russia sanctions. It is important to pay attention to the actual properly global foundation of international law there. And the final thing I will say also is that these sanctions are also going hand in hand with a very wide-ranging set of seizures or freezing of private assets owned by figures close to the Russian government. This also means that we have both public property, Russian central bank assets that have been frozen, and private assets, boats, real estate, etc., being exposed to sanctions. On the one hand, of course, this is simply taking the economic nature of Russia as the target and working from there. On the other hand, this poses a lot of important questions for the distinction between public and private property, particularly now that we're talking about discussions about confiscating assets. We need to be aware also here that there is still a lot of Western exposure to other economies where this argument is very easily turned around. And I think that the big hesitance in some G7 countries to agree to the full confiscation of Russia's frozen assets, for example, can be explained by this. What sort of precedent does it set when you can have third-party countermeasures that are irreversible and that are undertaken at this scope? I think it also conflicts in an important way with the international economic legal regime based on protections for investors and investor-state dispute settlements. There are all sorts of questions that are raised here. And so I think the Russia sanctions, for a variety of reasons, are a very important seminal case for where sanctions are today and where they might go. So the good news I'll leave you with is that there is no shortage of cases coming up in the future for people working in this area. It seems definitely like this will continue. But I would say, cautionary note is that the normative foundations and also the purpose in this world where demarcation rather than deterrence becomes the main goal are uncertain. Thanks.
Thank you, Professor Mulder. Fabulous. And I think that it's a good segue into Professor Harrell's comments, which are going to focus more on the private targeting as well that you just mentioned. So Professor Harrell, with that.
Yeah, well, thank you very much for inviting me to be here today. And I really should begin by congratulating the Journal of International Law on a symposium of this nature and this richness. I served on a Journal of International Law many years ago, and I was a law student, and I ducked out of organizing symposia. So I very much appreciate the amount of work that you guys did to get here, and it's great to be here on this very distinguished panel. I was going to offer some complimentary remarks around some of the U.S. use of sanctions, and as I think about it, the modern era. And I want to start by a little bit, you'll hear more about this from later panels, by laying out a little bit of the U.S. legal framework, and then talking some as a practitioner who's been in and out of government, as State Department earlier in my career as well, working on sanctions. There's a practitioner, sort of how we have thought about using this tool to serve policy purposes. So in an American context, the foundational statute in sort of the last 45 years for sanctions has been a statute called the International Emergency Economic Powers Act. You'll hear more about this later today. That was passed in 1977 as part of a package of kind of post-Watergate reforms. From the beginning, it was intended to be used as a sanctions statute, but not only as a sanctions statute. It was passed as part of a kind of a process. It was amending a predecessor statute that had dated to World War I, the Trading with the Enemy Act, still exists, but there'd been a view that it had been used too broadly, including but not limited for sanctions. And so there's some efforts to narrow TWIA, and then we're going to pass IEPA as a sort of an emergency power, including very much to be used for sanctions. So they're not only. It has been used for sanctions from the beginning, first use in 1979 by President Carter after the Iran hostage crisis. This was part of the American response to the Iran hostage crisis. And it's been used something on the order of 65 times since by presidents across both political parties for a wide range of sanctions purposes. So it's really been a very broad and very expansive use of the statute. The powers are quite broad. I mean, we think about sanctions, as Professor Mulder said, we think about them as kind of, blocking property, free asset freeze kind of sanctions. And IEPA provides an authority to do that. Also provides an authority to regulate imports and exports. You can use trade embargoes as a kind of sanction that you can use. And of course, it provides broad authorities to regulate international financial transactions, freezing bank accounts, but also regulating the flow of money around the world. Although that has been the foundational statute, we have seen, and I think this has been an important part of the American process on sanctions, we've seen Congress both formally enact other more target-specific sanctions and use the threat of target-specific sanctions legislation to prod the executive branch to do things under IEPA. So you've seen this long interplay between our Congress and our executive branch in terms of driving the purposes of sanctions. To give examples of some of the congressional statutes, back in the 1990s, Congress passed something called the Kingpin Act. It was, in many ways, the first targeted sanctions program targeting narcotics traffickers, narcotics kingpins. The Congress has also passed country-focused sanctions on Cuba, on Iran, on North Korea, on Russia. They're not in the last couple of years, as well as a variety of other sorts of individual statutes. Most of those statutes interrelate with IEPA. They might direct that something be done under IEPA, or they might provide authorization for licenses under IEPA. So most, but not all of them, do interrelate with IEPA. Now, when I think about kind of building on the modern, sort of stepping back from the legal framework and thinking about this as a practitioner to use these laws to achieve policy outcomes, I think we saw sort of a shift coming out of the 1980s into the 1990s. I think prior to the early 1990s, by and large, policymakers thought about sanctions in the way that Professor Mulder talked about it, as a way of targeting a foreign state. One of the big trends you really see in the 1990s and 2000s is a trend towards sanctions that target individuals. And this was being driven by a couple of things. First, there was a sense in the 1980s and 1990s that we are facing more non-state geopolitical threats in the world. We are facing a threat from international narcotics cartels. Obviously, we have the terrorist threat. So there's kind of a pull to say we should target individuals. There's also, I'd say, around the Iraq post-1991 Iraq war sanctions process, where there were very crippling sanctions imposed on Iraq that were widely seen as a failure, that also had major humanitarian adverse humanitarian complications. There was a very sort of desire in the sanctions community, well, rather than having these kind of dumb, countrywide embargoes, let's just go after the particular bad people we want to go after. Let's target regime elites. Even when we're targeting countries, we'll sort of do elite targeting and sort of bad actor targeting. And that paradigm kind of prevailed of individual targeting through much of the post 9/11 era, where we're using sanctions quite aggressively to go after terrorist groups in the wake of 9/11. Then there was this kind of conceptual breakthrough or shift, if you would say, by the late 2010s, when we are, United States in particular, is looking to put pressure on Iran, where we begin to realize we can actually use these individual sanctions, these sort of targeted sanctions against a particular person or particular company, to reinforce sanctions that are fundamentally targeting an entire country or a regime. And to give kind of a classic example of this in the Iran context, you look at the banking sort of the efforts to kick Iran out of global banks. So the U.S. had a trade embargo on Iran going back. Well, we'd had one early, and then it got lifted, and we had one going back to the 1990s. And as a result, we're there in the late 2000s, and there isn't a lot of U.S.-Iran trade that we can weaponize to gain leverage. But what we do realize is, because we have so much control over the international financial system, and Iran is using the international financial system to get paid for its oil exports and other things like that, if we target for sanctions the major Iranian banks and major Iranian government institutions, practically speaking, they're not going to be able to get paid for selling their oil, and it's going to be very hard for these third countries, whether in Europe or in Asia, to actually transact with Iran. And so the goal of this wasn't so much necessarily that we thought, the Iranian bank doing X was necessarily engaged in bad activity, although we would often argue that the Iranian bank was engaged in bad, and it might well have been. But the goal was, we've identified this as a node in the Iranian economic infrastructure. And as we put pressure on Iran, which was definitely engaged in bad activity, this is a way of putting pressure on Iran. And I think you have seen that process kind of continue, where many of the actions we have taken on Russia, though targeting Russian oil companies and things, sort of from a legal perspective, are actually about putting macroeconomic pressure on the country of Russia. There was an interesting legal shift there too, sort of in the late 2000s, early 2010s, whereas when we began targeting Iran on these kind of with these economic goals, we began that process often by arguing that this bank, even if we really were targeting for economic measures, from a legal perspective and a kind of moral perspective, we would argue this bank has done something bad. It accounts for terrorists or the Iranian nuclear program or something, and that would be the basis. By kind of the mid 2010s and later, we had actually shifted to more just from a legal perspective and owning what we were doing. So we started targeting the banks, legally speaking, rather than saying this bank has done something nefarious. Legally speaking, we started targeting them on the basis they are an Iranian bank. And the basis for the designation would simply be they're an Iranian bank. And that then gives a sort of a very clear-cut legal basis for that. And so that also kind of evolved over time. And I think you see that in Russia. Final couple of points I want to make have to do with the kind of conceptual purposes we were trying to achieve here. And I do think that with respect to sanctions that are fundamentally about targeting foreign governments, you have seen an ebb and flow, and as Professor Mulder said, you've seen a real diversity of purposes. I kind of break them into a couple of conceptual categories of purposes. There is a degradation purpose, right? We kind of recognize that sanctions are not going, have failed and will continue to fail to get North Korea to not have a nuclear weapons program. But we nonetheless think there is value to making it harder for them to advance their nuclear weapons program. And if we sanction the shipping networks and the procurement networks that are buying parts for that nuclear weapons program, we can slow it down and make it harder. So there's a sort of degradation basis. I would argue that then the next purpose I would say is a kind of classic behavior change purpose. You know, we want sanctions to generate leverage for negotiations with Iran over its nuclear program, and it's sort of a classic kind of leverage negotiation. And then I would say there is kind of a related purpose, and you see this in many cases, and occasionally successful, often not. You definitely see it used for sort of a regime change purpose, targeting foreign states. We want to see a new kind of government come to the fore. I think you saw that under the first Trump administration with respect to American posture towards Venezuela, where we're doing sort of maximum pressure on Venezuela with the goal of evicting unsuccessfully, ultimately, dictator Nicolas Maduro. I think those are kind of the three, when I think about states, the three big conceptual buckets. Obviously, within behavior change, sometimes you want a very small behavior change. I'd actually say one of the very most successful sanctions programs of recent year, which gets no attention because it was very small. President Trump, during his first term, sanctioned Turkey for 3 weeks. Turkey had invaded northern Syria. They were shelling some Kurdish allies of the United States. He sanctioned them actually quite heavily. Several of their ministries, the Turks said, you know what, we'll stop shelling these Kurdish allies of yours in northern Syria, and 3 weeks later, the sanctions were gone. It's like sort of historically will be long forgotten, but sort of an example of a modest but successful recent instance of sanctions. So behavior change can be big or small. Then a final point I want to make, I think there are sort of different goals, or the overlapping goals with the targeted sanctions, the sanctions against individuals that really are against individuals, not against a company because it is part of a larger program that is targeting a country. So here I'm thinking about, sanctions against narcotics traffickers because we are trying to interfere with their narcotics trafficking activities, or sanctions against corrupt foreign officials or human rights abusers. And here I think you see, a similar but also some distinct set of goals. So with individual sanctions, you definitely see a degradation effort. We'll sanction Colombian drug cartels because we want to make it harder for them to traffic drugs to the United States. You also see, actually interesting, and this happens every year. It doesn't, in the practitioner community, people pay attention to it. In the policy community, not so much. You do see individual sanctions for behavior change. Every year, the U.S. Treasury Department Office of Foreign Assets Control negotiates with various sanctioned individuals, including things like narcotics trafficker, and will remove them from the list. In exchange for some kind of cooperation that they have given. That might be cooperation in the sense of they will share information on their fellow narcotics traffickers, which can be useful. That might be cooperation when they've sanctioned, for example, a European company shipping oil from Venezuela to Cuba. The European company says, we're never going to ship that oil again, and we'll build a compliance program. So you actually see this quite active process of individual sanctions behavior change going on. And then the third thing you see a lot in the individual case is what I would call symbolic purposes. We're sanctioning somebody because we think they're bad. We know it's not going to have any impact on them. But we think it is nonetheless important to send a message. I have to say my thinking on this has evolved over the years. I think there are times when you need to sanction somebody to send a moral message. I think we often underperceive how that message is received by the target. I think if you're interfering with somebody's money and their actual business, they feel the pain. But if you're simply sanctioning them from an American perspective, you're sanctioning somebody for doing something we view as bad. I think we should be asking, are they going to perceive it that way? And I have a personal experience that has brought this home for me. I worked in the White House on Russia sanctions in 2021 and 2022. I'd worked on state, and I'd hoped to not work on sanctions when I was in the White House, but then Russia invaded Ukraine, and these things happen. A couple of weeks after we do our first sanctions, the Russians start counter-sanctioning people. And when the Russians start sanctioning American officials, the first group, there were about eight or 10, and everyone who's on that first list cheers. I'm not on the first list. I'm quite frankly disappointed. I clearly failed to get under the Russian skin enough. I was on the second list, and it was really one of my prouder moments in government when the Russians sanctioned me. But I think we have to take that seriously from the American perspective, too. If we're simply doing this as a symbolic matter, what is actually the message that they are receiving, which might be different from the message we are sending? I'll leave it there.
Okay, thank you very much. Professor Hovel, you want to talk about unilateral coercive sanctions?
Yes, or something like that.
Okay.
Yeah, so thank you. I just have to add my thanks to these amazing organisers. It's a real privilege to be part of this symposium and this panel, especially alongside such an extraordinary range of voices. So you'll see that today's event's bringing together people with deep hands-on experience. So we've got former White House advisors and Justice Department architects of the Russian sanctions regimes and barristers working on leading cases. The lineup reflects the sheer complexity of sanctions, from the courtroom to the corridors of power. But I come at this topic as an academic. So I'm less about drafting the next set of sanctions, working out how to block sanctions we don't like, than looking at a broader question, and that is what role sanctions play in the broader system of international relations. So I could give a textbook style talk, and perhaps certainly our law students might be asking for that, debating whether unilateral coercive sanctions meet the legal threshold for lawful countermeasures, looking at whether converting frozen Russian assets into reparations for Ukraine can withstand international legal scrutiny. And these are critical questions. But as Nicholas reminds us in his excellent book, the debate over sanctions has never been about narrow legality alone. And so he puts it in his book, economic coercion can find a place in politics if its goals and methods enjoy legitimacy. And I think there was something in that, in what Peter said or concluded with. And that's where things get complicated. So sanctions, as we've heard, were originally conceived as a tool for peace, a mechanism to prevent war, not to provoke it. So in the wake, as we've heard from Nicholas, of catastrophic world wars of the 20th century, sanctions were meant to serve as an economic deterrent, a way to pressure aggressors without resorting to military force. And Nicholas's work shows that sanctions emerge not just as instruments of statecraft, but as the world's attempt to avoid the devastation of total war. But here's the paradox, and it's something that Nicholas touched on as well in his remarks. Sanctions, once seen as a tool to prevent conflict, have evolved into one of the most aggressive forms of peacetime coercion available today. And they've become a central tool of foreign policy. And they're a tool that's wielded frequently for isolation and punishment, as much as for conflict prevention. So this brings me to my core question today. What happens when the most powerful state, not mentioning any names in the world, uses sanctions not as a tool to uphold international order, but as a weapon to bend it to its will? And forgive me, I'm now going to try and channel some of our hosts' eclectic personality in my remarks. Because you see, being an international lawyer can sometimes feel like being a librarian in the middle of a riot. You're deeply invested in the idea that there are rules, beautiful, impeccable rules, that if followed would make the world a better, more orderly place. You clutch your well-thumbed copies of Oppenheim, of Nicaragua case, of the Rome Statute to the International Criminal Court that explain exactly how everything should work if only people would stop upturning chairs and setting things on fire long enough to listen. So you try your best. Undeterred by flying books to the head, you release sternly worded statements, you quote precedents, you consult tribunals, you even ask councils to issue resolutions, sometimes some targeted shushing. I'll release your browser history if you don't do this. But the rioters persist in throwing around treaty texts like Molotov cocktails, and eventually the library itself is on fire. With a theatrical flourish, the doors fly open and in walks Donald Trump. He surveys the room, nods approvingly at the chaos and declares, "The librarian is biased. She's trying to enforce rules that don't benefit me. She is the problem." He then buys the entire building and turns it into a private club, selling memberships for $49.99, payable in cryptocurrency. Sensing an opportunity, as your librarian, you apply for entry. After all, you've got considerable expertise in regulatory compliance. Security blocks your path, giving you a look usually reserved for telemarketers and people who still cite the Kellogg-Briand Pact with a straight face. You don't accept librarians. You learn you're on a watch list for those showing excessive commitment to the rule of law. It's enough to make you swap your legal principles for a business card and rebrand as a corporate lawyer. Am I right, corporate lawyers in the room? So one obvious takeaway from this analogy is that international law has an enforcement problem, and that's true, it does. But I don't think that's at the heart of the issue here. There's something graver and more destabilizing at play. Another way to frame it is that the US has an international law problem. But even as I say that, I hesitate for many reasons. Because it's not quite right to attribute this to the US as we've come to know it in the international legal system. The US, that for all its contradictions, has often championed the very institutions that it is beginning to resist. What we're dealing here is something quite different. Trump's America, in many ways, is acting like a new country on the international stage. A country that doesn't just push back against international law, but can actively undermine its foundations when they conflict with national interests. And in my paper to be written, I want to introduce this idea of Fortress America, a state defined by insularity, transactional diplomacy, and a deep suspicion of global institutions. Fortress America, which I distinguish from the US, isn't interested in cooperation with those outside it, unless it serves immediate national gain, and it certainly isn't willing to submit to external legal scrutiny. Now, all of this is a way of introducing a particular sanctions mechanism that's been introduced more recently, and that's the sanctions against the International Criminal Court, which were introduced a couple of weeks ago on the 6th of February 2025. And yes, as you'll know, the Trump administration first sanctioned the ICC back in 2020. But this time the stakes feel higher, and I was inspired to use this quite recent set of sanctions because of a discussion I had with an ICC official last week over lunch. The thing about this is, though the sanctions were imposed back in 2020, this time the stakes feel higher. Fortress America is back stronger than ever, and President Trump's executive order ramps up the rhetoric and the seriousness. So I just want to explain to you a bit about that executive order and what sanctions it's imposing. So the threat it addresses, because as we know, sanctions are addressed in relation to a threat to national security, a public emergency in the US. The threat is any attempt by the ICC to prosecute residents or nationals of the US, and wait for this, or its allies. So it's significantly broadened the net. The targets themselves are both primary and secondary. The primary sanctions hit ICC staff directly and their immediate family members. So the prosecutor himself, Karim Khan, has been designated, and more names are expected in 60 days. But the secondary sanctions widen the net considerably. They apply to anyone who assists, sponsors, or provides financial, material, or technological support to a designated person. So you can read anyone who provides that support to the court. Anyone who makes donations for the benefit of a designated person, or anyone who provides funds, goods, and services to or receives them from a designated person. And the penalty, up to 20 years in prison and a fine of up to $1 million for willful violations. In hindsight, perhaps I should have issued a health warning for this presentation. Listening to this talk might just expose you to the risk of 20 years in a US jail. Because the net, and this is where I've had discussions with colleagues over more recent days, does expose many of us in this room to the threat. So can US nationals work for the ICC, even as defense counsel? No. Can US companies supply the ICC with goods and services? So that includes, of course, Microsoft, that includes anyone supplying the court? No. Can the ICC itself use US banking facilities? No. Can US nationals act as advisors to the prosecutors? Certainly not. But what about, for example, attending an academic workshop, also attended by ICC staff? And this was the interesting moment last week. I had an ICC official speak to my students who said in advance, do you have any US students in your class? You need to warn them of the risk of them hearing from me in this classroom. He'd been at a workshop the day before where US individuals had to consider whether they could be at that workshop where they were going to be engaging in a dialogue with ICC officials. So my broader point is that these more aggressive uses of sanctions, the coercive use of sanctions, if you like, that's culminated in this unprecedented targeting of the International Criminal Court, didn't just stretch legal boundaries. It signaled, and Nicholas brought this out, this broader ideological shift. So you spoke about that shift from liberal internationalism to neo-mercantilism. I'm suggesting it's one also driven by neo-isolationism, transactional diplomacy, raw economic power. So sanctions are without questions, as we've heard, one of the most powerful enforcement tools in the international system. But when driven by the wrong purpose, potentially the wrong ideology, they don't just punish adversaries, they can destabilize the very legal and political frameworks they were designed to protect. So here, the sanctions go beyond a mere legal violation. They deliberately weaponize US power against the international legal order. Their aim is to dismantle the International Criminal Court. But it also dismantles key principles deeply embedded in both the US constitutional identity and international legal norms. The principle of judicial independence, freedom of speech and association, post-World War commitments to prevent genocide, to ensure accountability for atrocity crimes, the core prohibition against aggression. So in concluding, I just want to briefly explore the risks this shift poses for the integrity of international law, for global governance, and ultimately for America's standing as a great power. Now, this is where I intend in my paper to look into, a framework as to how states interact with international law. It's a framework I'm going to call the Legal Integrity Index. Before diving into that, I just want to pause to note an important point. Not all violations of international law are created equal. This has been a recurring debate in international law. It might have come up in some of your classes, for example. So take the instance of the question of the US invasion of Iraq in 2003, whether that was legally equivalent to Russia's invasion of Ukraine in 2022. You might have heard this debate carry out. So both involved violations of territorial sovereignty, but the intent, context, and systemic consequences varied dramatically. So it's not to excuse either action, but to highlight a fundamental truth in international law. Violations exist on a spectrum. So this is why the index I'm proposing to call the Legal Integrity Index isn't just a binary of lawful, unlawful. I don't think that's sufficiently helpful for us in international law. Instead, it looks at how states relate to international law over time and the nature of their violations. So I'm going to do this very quickly, but I've got categories of states, okay? So my first category is the enforcers. Now, these are the great powers, states that don't just follow international law, but actively uphold it, using their influence to maintain order and accountability. Then there's the custodians, the reliable law-abiding states that support the system but lack the clout to enforce it. And we can think of this in the terms of sanctions. But the system and institutional framework isn't always so clean. Enter the avengers. So these are the states that work to enforce international law, but do so through extra legal means, illegal military actions for legitimate purposes, for example. Then we have the opportunists, or perhaps the pragmatists, who play by the rules only when it suits them, sidestepping their legal obligations when they become inconvenient. Worse still, the abusers, who don't just bend the rules, but actively distort them, manipulating legal frameworks to justify legal actions. We can apply that, for example, to Putin's justifications of the invasion of Ukraine, using international law, but clearly distorting it. Finally, we have the rogues, the states that reject the system altogether, disregarding international law and acting purely on unilateral power. So my final point is that what we may be seeing with Fortress America is that shift from great power to rogue. It's entering rogue territory with the ICC sanctions that don't just violate international law, but represent a systemic assault on the very institutions that are designed to uphold it. I'd argue that's what makes Fortress America so dangerous. Okay, thanks. I'll leave it there.
Thank you very much. Professor Heath?
Thank you so much. It's really great to be among friends in a difficult time. And Tom, with apologies for breaking a sort of panel norm out of medical necessity, after I talk, I'm going to step off the panel for a couple of minutes.
Copy.
And so you can plan your rebuttal comments accordingly. I am a lawyer, and both of my parents are librarians, but I actually like studying riots. So some of my comments come out of my research into a different kind of economic sanction, which is boycotts, particularly boycotts around the turn of the century, from the 19th to the 20th century. I guess we have a new turn of the century now that I have to get used to. In particular, my thesis from that talk is that economic warfare, sanctions, boycotts are not just sort of means to enforce the law, means to uphold norms, means to announce new norms or engage in symbolic behavior, but they are, in a sense, world-making projects. They are a means to assert and bring about new orders, right? And that can be both threatening and exhilarating, and sometimes both at the same time. And so, when I did my little detour into the turn of the century, this was the moment of sort of the establishment and solidification of what we might think of as the old liberal order, not the neoliberal order, but the old liberal order. This was an idea, this is based on sort of individual liberty, freedom of contract, circulation of goods, the first great era of globalization, et cetera. And there was a view prevailing at the time that, critics like John Dewey pointed out, that the principles of the liberal order, things like freedom of contract, were being sort of solidified into kind of a new natural law, that this was kind of being treated as like a, if you will, sort of a constitution for the legal order, these principles like freedom of contract. And if you found the possibilities of the liberal order somewhat constraining, then you might find the actions of folks on the margins of the liberal order to be somewhat exciting, perhaps, right? Because these were groups like labor unions that engaged in strikes and boycotts that were seen as directly threatening to the liberal order. Why? Well, because they announced new sort of organizational principles for structuring the global political economy, where goods and resources wouldn't simply circulate on the basis of who could purchase them and who could contract with whom, but would circulate according to certain moral principles, where the legislation of the labor union, terms of fair work, et cetera, would govern the circulation of goods and finance, right? But it wasn't just labor unions. Sometimes in cooperation with labor unions, you could find, and indeed they were rampant in the American West in the late 19th and early 20th centuries, racist, anti-Chinese, and then anti-Japanese boycotts that sort of organize themselves along the same principles, right? That the liberal order of formal equality before the law was not going to govern who could get a job and who could work for how much, but rather the color of one's skin. Right? Similarly, anti-Black boycotts in the South around the same time targeted small Black-owned businesses that were successful in an attempt to drive them under. But also we saw the rise at the time of civil rights boycotts. Things like streetcar boycotts, which were an early precursor to the Montgomery bus boycott 50 years later, to establish a right to use public infrastructure. And those civil rights boycotts in the United States actually took inspiration from anti-American boycotts happening at the same time across the Pacific in China. And these boycotts not only sort of announced new principles for the circulation of goods, but asserted new forms of social and political organization, because the anti-American boycotts organized by the Chinese were not just directed at the Americans, but were also in the service of establishing a Chinese national identity that transcended the formal borders of China itself, reached Singapore and the American West, and establishing that identity sometimes against the sclerotic late Qing Empire, which was soon to collapse, right? And so these boycotts call into being new forms and new orders. And what I've argued in some of my work is that economic sanctions also follow this pattern, even when they're sort of in the technocratic language of executive orders issued by the White House. That the prevailing order that we inherited at the beginning of this century is a neoliberal one that sort of exists on premises of liberal circulation of goods among sovereign equal states, and also the liberal circulation of capital. Economic sanctions challenge this by reaching directly into the plumbing of the international financial system and asserting new and different ways that, that goods and finance will circulate. Right? And they call into being new worlds that are completely unimaginable, in some cases science fictional. So in the 1990s, after the collapse of the Berlin Wall, there was a question of what was going to happen to US-Cuba relations, right? What's going on here? Is the United States going to normalize relations with Cuba? And in fact, what happened is the United States in 2 election years, 1992 and 1996, with limited pushback from the White House, but ultimately its cooperation, both times, a Republican and a Democratic administration, tightened the screws on Cuba and effectively created a new reality which persists today, where the Cold War still exists in the Straits of Florida. Right. And so if you talk to Cubans, they will talk about hoping one day for peace, right? As if it currently does not exist, because it does not. Right? They can also suspend the existing reality. And so this is a little bit far from technically IEEPA sanctions, but if we talk about arms transfers, and arms sales, you can see in the Biden administration, and ProPublica has done some excellent reporting on this, the way that that the administration sort of restructured and moved around decision-making power to prevent, to not simply decide that Israel was not systematically violating human rights in Gaza, but to suspend that determination from ever taking place, so that the State Department never made a formal determination about whether Israel was systematically violating human rights such that arms transfers might need to be shut off. And so the paper I submitted for this conference, which you can read if you have ample spare time, argues that sanctions do accomplish this world-making function. But in the United States, and my focus here is on the United States, the incentives are such that the worlds we make with sanctions are bad ones. They're dark and scary. And this is not just the case in the current Trump administration, though I'm going to get there in a second. So sanctions are largely an executive-driven process, and we sort of understand from other national security lawyers and law professors like Ona Hathaway and Beck Ingber, Jack Goldsmith and Ashley Deeks, among others, that that national security lawyering works different from what you're used to learning in your first year in law school, right? There's not like a sort of, there are canonical court cases, but they're few and far between, and regular litigation is the exception, not the norm. And so what you see instead is a lot of inside bureaucratic lawyering, which is fine, and it does actually lead to some constraints on overreaching executive behavior in the best of times. But in large measure, when there's a push for sanctions, for doing things like perpetuating the Cold War, that push finds an open door in the executive branch. And again, this is not just Trump, but what we're seeing now is that Over the past 20 years, under both Republican and Democratic administrations, as you heard from Peter, the White House has invented a series of very interesting new techniques for weaponizing the world economy against perceived enemies. And what's fascinating, as you heard from Professor Hovell, but you can also read from scholars like Henry Farrell and Abraham Newman, is that this is now being turned to interesting ways on enemies, both foreign and domestic. So you've heard discussions of the ICC sanctions, but what we're really seeing today in the United States, not to mince words, is a takeover of the apparatus of weaponized interdependence by you could say, let's call it a neo-Nazi cabal with Silicon Valley characteristics. That is using the levers of the internal payment system of the US government to attack not just foreign enemies, like perceived enemies like those who collaborate with the International Criminal Court, but also domestic enemies, which will include universities, intellectuals, anyone who engages in efforts to foster racial or gender equality, et cetera, right? And these will be not the same statutory authorities, but the same techniques to choke off access to resources and goods on the basis of new moral principles for their circulation. And so that's what we're living with now. And the question is, who else, what other power centers can we use to sort of counter this by conjuring into being alternative worlds that are maybe different? Unfortunately, Congress is rather weak in this, and not just because of it's the sort of uniparty control we have right now, but Congress has been notoriously a one-way ratchet in sanctions, largely pushing toward enhancing sanctions. I mentioned Cuba, that was largely Congress's doing. In fact, the embargo would have been unwound in the Obama administration had Obama had the statutory authority to do so, I believe. Meanwhile, judicial supervision is also relatively weak, although there is some hope here. We are seeing that both on the domestic front, and hopefully we'll see that on the international front, as we did a little bit in the last round of sanctions and Trump 1.0 against TikTok, where those sanctions were enjoined by the courts. But the courts themselves don't offer an alternative institutional imagination to what is coming out of the White House. And so I end where I began, where we have to think of other forms of economic coercion and direct action to imagine new and alternative worlds to the ones that are being proffered to us by the people in power. And in this, I ran across an article in The Guardian yesterday by Brooklyn journalist Judith Levine that said, the headline is, "It's time for Americans to withhold their taxes," right? And so when we think about economic coercion and economic warfare, it's actually a little too late to do it in 2025 for this filing season because you've actually already paid. But, you know, there are pressure points we have here. So whether it's through labor unions, whether it's through other forms of direct organization, or whether it's by all of us withholding our taxes, there are ways to resist this takeover of the tools of weaponized interdependence by a regime that is not likely, in my judgment, to engage in another peaceful transition of power in the United States. Thank you.
Thank you, Professor Heath. And I excuse you. So I'm going to ask one question of each panelist, and then I'm going to open it up to the floor. Professor Mulder, my experience is sort of limited to the US context, but let's say there's a problem, North Korean nuclear weapons, and in the US interagency, the president asks for different options. The State Department can't give much in the way of cutting off diplomatic recognition because we don't have any, but they could lean on Malaysia or some countries, or they could suggest certain PIP type lists, important person lists. Treasury can sort of suggest sanctions, and then they go to the Pentagon where I worked, and the DoD suggests blow them up options, right? And it seems to me that faced with that choice, you know, at least in my view, the blow them up options are the least attractive because it will certainly result in mass casualties. And so in many instances, the sanctions path seems to be the most humane option, right? And so in some sense, It's not necessarily about deterrence or demarcation. It's you have foreign policy issues. There's different tools in your toolkit, and so sanctions, just by the fact that there's sort of a middle option, ends up being chosen. And so I'm wondering that kind of dynamic. Yeah, I assume it operates at the international level too. Certainly it operates within the US. How does that complicate your account, reinforce it, conflict with it?
Thank you. Yeah, I think that's a very important thing to keep in mind, right? The constraints that policymakers work under. The example of North Korea is interesting, though, because I would say that North Korea, in fact, was integrated in the 1990s into international exchange through a highly successful agreement called the Agreed Framework.
1994 framework, yeah.
Yeah, and that held for 8 years,
Mhm.
and it involved the transfer of civilian nuclear technology to North Korea, which also strengthened cross-border scientific links. And it fell apart because the United States designated North Korea part of the axis of evil in 2002.
Because Clinton lost the Congress and couldn't proceed with the next step, which the North Koreans were expecting, right?
Yeah, no, but it was also, but afterwards, the kind of trust that was beginning to be built up through it evaporated. And so there, I think diplomacy, which was used first, we can debate exactly the reasons why it broke down, but I think that was the most promising road, and everything else has been worse, right? And like we're now in a much worse situation than the region and the international community. And I think that I totally, I used to work in government also briefly, and I totally understand these constraints. But one of the issues when you take a step back and try to think in the long run, how do these things add up together, is that the consequences of lots of least bad alternatives being chosen can still, in an unintended way, add up to a lot of sclerosis and pushing certain countries closer together. And I think here, the fact that North Korea and Russia, for example, have really strengthened ties is something that was not at all a given, but has been an outcome of many overlapping sanctions regimes. The fact that there is an oil price cap on Russia rather than a full out-and-out embargo on Russian energy exports has a lot to do also with the global oil market, with political dynamics, but also with the fact that there were already Iran and Venezuelan oil sanctions in place, the enforcement of which also had to be, let's say, walked back a little bit in the last few years in order to make pressure on Russia more effective and keep barrels flowing. So decisions taken for understandable reasons in particular contexts add up at the global level to, I would say still, a set of suboptimal outcomes, to put it mildly. And that's, I think, one of the other reasons why, I would echo the call that Ben Heath made to think about what other ways with economic tools we can improve things.
So Professor Harrell, my question for you involves, I think you accurately characterized the progress of U.S. sanctions regarding financial institutions, and particularly with respect to Iran, and the fact that we can leverage those sanctions because U.S. dollar denominated transactions that are such a prominent hegemonic form of financial exchange. But let's imagine, cryptocurrency, where the blockchain sort of it becomes an autonomous form of financial exchange. And let's say the Chinese develop their own digital currency. I know that they have, I don't know where those projects are, but let's say they become a financial exchange. And so every time we use this, and the extent to which, as Professor Mulder says, this kind of demarcation happens, ultimately that particular weapon, which is one of our most important sanctions weapons, will vanish into diminishing returns, and particularly, I think cryptocurrency is a particularly stark threat because it's not tethered to a particular sovereign. And so I'm wondering, are those concerns part of this? Do you believe the U.S. government is thinking like, well, this is an extremely powerful tool for us, but if we keep using it like this, then we're going to create the conditions under which the tool will become blunt and useless?
Well, thank you. I will make a moment of comment on that. I also want to react actually for a moment to a couple of comments that my other panelists have made. And I want to begin by picking up a little bit on the points that Professor Hovell made about the ICC. I'm actually a quite profound ICC skeptic. Don't think sanctions are the right solution, but I'm very skeptical of the ICC. But what I actually wanted to say, because I think it illustrates a broader point, we actually don't have a lot of litigation and good case law in the sanctions space. And there are many reasons for that, including the way in which sanctions have been used in instance of executive deference. But I actually disagree as a legal matter that you couldn't sit and hear from an ICC prosecutor. In fact, just in December, OFAC settled with an NGO, OFAC's our sanctions regulator, settled with a US NGO, which had invited a sanctioned person to a workshop in the Middle East. OFAC had tried to say that was could be prohibited under IEPA. The NGO sued, backed by the Knight First Amendment Center down the street here. And OFAC has settled on that and acknowledged that where there's no material payment to the speaker, a US NGO can have, because of the statutory framework of IEPA and because of the First Amendment, a US NGO could host a sanctioned speaker at a workshop. Can't feed them lunch, but you can host them. So I do think, but I think this illustrates a broader point, which is I actually think we need and should want more litigation in this area. We did, as Professor Heath said, we did in 2020 when the Trump administration tried to sanction TikTok, successfully see lawsuits, and the courts enjoined that ban very, very clearly. That's actually why the Biden administration had to get Congress to pass a new law, an entirely new statutory framework to try to get this divestment out of TikTok, which Trump is now kind of lawlessly ignoring because he changed his view on whether he liked or disliked TikTok. And I think we actually see this history too, back in the 2000s after we start sanctioning American NGOs for terrorist links, we actually see some of the NGOs sue, and we see courts find, maybe there are actually warrant requirements if you're sanctioning American citizens. So I think we've, as a practical matter, have not seen enough litigation in this area. I understand the deference, and courts will be deferential here, but we actually need more litigation and should have more litigation. I think this would be an interesting area for, law students to think about opportunistically bringing cases. And so I did just want to make that point. I also want to make a very brief point on this issue of, because you brought it up, Professor Lee, about force versus sanctions. I was in the White House when we were trying to deter Russia from invading Ukraine. And I think it's relevant to signaling. And we were sort of trying to get the balance right of, do we threaten economics against Russia? You invade Ukraine, you'll pay costs. Or do we threaten military retaliation against Russia? And it's important for, as I think about Professor Mulder and the signaling issue here, I think we overinvested in economic deterrence, because what we ended up doing very practically was saying to Russia, we were very clear on it, you will face very substantial economic costs if you invade Ukraine. But we were very unwilling to move military support to Ukraine prior to the invasion. We did a little bit, but we did not do much. And the message I think we actually sent the Russians was, if you invade Ukraine, you will take Ukraine and you'll pay 10% of your GDP to get it. And the Russians said, sure thing, I'll take that deal. And I think this is a kind of a risk as we think about it. We need to think about what are the messages that our audience is hearing, which might be different from the messages we're sending. And I think it gets to that kind of military balance. I for example, it comes up in policymaker circles, I think it would be completely futile to threaten sanctions to deter China from taking over Taiwan. Because if China gets to the point where they're going to take over Taiwan, they're just going to price in, some sanctions, but they won't really see it as a deterrent at that point. So then, finally, on your question about cryptocurrency, it's something I think about quite a bit, and I actually very much appreciate both Professor Mulder's reading your book, some of this, but also I would commend some of Abe Newman and Henry Farrell's work on weaponized interdependence, because the way in which we got to having this wonderful tool of dollar dominance was partly market forces and happenstance. It was also deliberate policy by the United States. We went out and promoted the US financial system in Eastern Europe and Russia at the end of the Cold War. The 1970s, even when the Arabs are giving an oil embargo on us, we, under Kissinger, strikes a deal with the Saudis so they continue to price that oil in dollars. So that we continue to have dollars. This is a deliberate creation of the international financial system that we control. On cryptocurrency, I think we face a choice because it's not actually, by and large, cryptocurrency kind of exists in the ether. Most of the cryptocurrencies being used are being managed by exchanges. There are things like stable coins, which are created by companies. I actually think we need to aggressively invest in making sure that American companies go out and kind of lead the global development of this architecture and this financial infrastructure, because then we will have leverage over it. I think where we lose this leverage is when it is non-American developers, exchanges, engineers who are developing it. If we can get our guys out there, others, I think we can maintain leverage on that going forward. I do think nonetheless, even with an aggressive effort to maintain leverage, I think we will probably see some diminution of leverage, which makes me think we need to think about other sources of leverage that are non-financial. Are there ways in which we use the control of technology sector as a source of leverage? And you see OFAC beginning to think about this. So a couple of years ago, there was an enforcement case against a Swiss company that was providing services for Iranian airlines that were sanctioned. And the basis for OFAC's enforcement was that the Swiss company was using a data center in Atlanta, Georgia, to process those transactions, giving OFAC a jurisdictional hook. And so we are clearly going to need to be thinking about, if we survive the next couple of years, how do we think about the other sources of leverage that we have in this interconnected world?
So it's interesting that you brought up the fact that maybe we're not considering the military options enough. I don't know if Professor Mulder, you'd have gone there. It's interesting. I mean, you replay the invasion. So suppose we'd sent a couple battalions of the 82nd Airborne and put them along the front line in Ukraine, or done ground assault with planes, like these kinds of military options. Maybe, I mean, I hadn't thought of it until you raised it. Maybe in some sense, part of what sanctions is doing is ironically making us more afraid of the military options. And maybe the point there is sometimes the military options should be the one that we're focusing on more than we are. I mean, that's an interesting thought. Professor Hovell, my question to you is I agree that, and I have to self-confess, I'm something of an ICC skeptic as well. But I wonder, like, there's no talk of ICJ sanctions. Hold my tongue. Maybe there will be one day. I don't know. But the ICC, so is there a real threat to the rule of law? Are the United States turning into rogues? The Biden administration, I'd say, had a policy of benign neglect. Democrats and the Republicans, when they hold the presidency, I mean, we haven't signed the Rome Statute, and to some extent, Afghanistan has. Why is, and I tell my students about the Service Member Protection Act. I don't know if you guys are familiar with the Service Member Protection Act, but there's a standing authorization for the United States to attack The Hague if they should ever prosecute an American service member. It's called the Service Member Protection Act. And so I wonder, to some extent, is it something about the ICC? And Professor Hovell, you're an advocate. And it's not really about the rule of law generally, because if you were to rank countries on a rule of law index, I mean, despite the problems the United States has, I'm sure that we're actually probably better than Afghanistan, which is a signatory to the Rome Statute, or a number of the other countries that are signatories, like Mongolia. So it really is an ICC problem. I'm not disagreeing with you that these sanctions seem mean-spirited, severe. But to what extent is the ICC problem the United States exhibits really a rule of law problem? I mean, if we do see sanctions against ICJ, if we see withdrawal from XLVIII and different types of investor state protections, I would agree with you. But I'm not sure that an ICC problem really is a rule of law problem.
Thank you very much. And while we're all in confession mode about being ICC skeptics, I should confess I also am an ICC skeptic. What I'm trying to say here is that is a different issue from whether the United States is entitled, being an ICC skeptic, not only not to sign or ratify the Rome Statute, but actually to destroy it for everyone else and impose their view as the world view. Now, your question, though, was, is this an ICC problem? And I'd say, no, it's not. It certainly is the case that it has been suggested that the ICJ may also be a target. And let's not forget that the appellate body of the World Trade Organization no longer exists. And for those of us who know, the reason for that is the United States.
Yes.
So it's about external scrutiny. It is about the legal frameworks and accountability frameworks in international law. And as I say, international law has an enforcement problem. That is a big issue, but it's not to take away from the fact that currently what we have is a quite aggressive attack against the institutions.
The WTO problem, it still exists, but the appellate body, which is the appellate chamber of the dispute resolution system of the WTO, the United States under the first Trump administration sort of procedurally halted the nomination of new members. And so the appellate body is officially dead. The initial dispute resolution system, which is the pre-GATT system, still exists. And so that's available, but by not effectively, by using this procedural stratagem not to enable the appellate body, the dispute resolution system at the WTO has been severely hampered. I think that's what Professor Hubel's talking about. So we only have a few minutes left, but I wanted to leave time for questions from the floor. Yes, Josh, for any of our panelists. Yes.
Let's get into this ICC debate, but because I think both Peter and Devika are slightly off, and I was general counsel for the Exchange Foundation for Property.
Yeah.
And the devil's in the details here. Oh, great. And there also was a case 5 years ago brought in the initial ICC round. So there's a good case from the Southern District that at least landed with a preliminary injunction. But on the details, holding political dialogues with designated people is not sanctionable according to OFAC at the moment. That's great. But getting training from an ICC official, from the prosecutor of the ICC at a workshop where that person is participating, an American is present, that would be prescribed at the moment. So we have to really focus on the details of what is and what's not. Whether the other things that Devika described are or are not prohibited under the terms of these sanctions, I think some we could probably confidently say are not prohibited, but there's a very wide range of activities for which we are uncertain, and that's precisely the problem. I'll talk more about that later, but just wanted to correct the record on those little bits.
Would you like to?
Yeah, I'd also just like to respond to two things that were said here, particularly what Peter mentioned about the need for more litigation. One of the clashes, or at least confrontations that I see coming up after a number, indeed now, of American challenges towards international criminal law, is also a major clash between sanctions and economic statecraft and international economic law. And to some degree, the jurisdictional optimization that is very common to arbitration and the way companies structure their incorporation has already been a kind of loophole in sanctions regimes, right? That's why the kind of OFAC enforcement is this whack-a-mole game between lawyers who can set up shipping companies and commodities traders in Dubai, Hong Kong, and Singapore, and then have them designated. But I think that the much bigger question, and that's why I think TikTok too is a very seminal case. If something like the TikTok bill, a bill where a company is forced to sell itself to a government-vetted buyer on pain of being banned, were to be instituted by basically any other country outside the West, this would immediately trigger cries of expropriation. And this would, under ISDS, be a very clear grounds for opening an expropriation case. The fact that we haven't really seen, indeed also in the US, people, I think, make this argument, to me, has been quite striking. But for the US, right, one can argue that if the US just pushes this through on national security grounds, it doesn't have to fear the consequences so much. But the reticence to do this is very important for the Russia sanctions, particularly, again, the frozen assets debate, because 190 of the 300 billion of frozen Russian assets are, as you probably know, in Euroclear, which is a private securities depository in Belgium. And Euroclear has, as a private company, made it clear to the Belgian government that if Belgium, as a member of the EU, were to participate in a full confiscation, it's the Belgian government that is doing that, and the Belgian government recognizes that it will probably be liable for a case under an ISDS or arbitration settlement. So this is the kind of problem for Belgium. 190 billion is a third of its GDP. If this is the sort of thing that they're exposed to, right, that's what causes some of this this reticence. So we have an international economic law regime that still benefits a globalized world, but we have now a set of coalitional policies around economic statecraft that are really beginning to test the boundaries of how far that can be pushed.
I think we have time for one more question. Yes, sir. Professor Janis, right?
Thank you. And with Eisenhower School, National Defense University, DOD, and adjunct here. So I'll preface any question I ask or opinion I express, those are my own, not the DOD or the government. Professor Mulder, in terms of sanctions efficacy, do you see any traction in other countries? You hear about Russia with the obfuscation reporting, the decrees were issued to mitigate sanctions imposition, and you have the unreliable entity list in China and similar activity. Do you see that taking place in other countries to mitigate sanctions? And I was wondering if there's more weaponization of the rule of law by malign actors like Prigozhin to get his mom off the sanctions list, if they're using the rule of law in the West to take advantage of that with beneficial ownership registries.
Well, we have, I think, other experts also here who are involved in litigation around the sanctions against private individuals related to Russia. What is clear is that the government there is retaliating against Western businesses. They are setting up a system of incredibly tight capital controls, effectively imposing a 50 to 60% exit tax, which is a 50 to 60% confiscation of Western corporate assets on all companies trying to leave now. And there is still more than 100 billion euros of European corporate investment stuck inside Russia. So this is, of course, not the same volume of money of the frozen Russian assets in the West, but it's substantial, particularly for European corporates. Yeah, I think I'll yield to people later, I think, who can hopefully comment.
Would anyone else want to comment? We have 1 minute left before my timer goes off again. So yeah, Professor Heath.
Yeah, I can jump in on a couple of things. The TikTok stuff, which I know folks are interested in. I was actually, I'm a fan of expropriation, so I was a fan of the TikTok bill. But the speech stuff I think is interesting. Does anybody? So sanctions are unfamiliar, but folks watch football. Okay, so what do they say at the beginning of every NFL game? Any unauthorized rebroadcast, et cetera. And what's the last thing that you can't do? You can't give any accounts of the game, right? So according to the NFL, every sports story on Monday morning is prohibited, right? Which we know is an overreach. And Jason Mazzone, a copyright scholar, has written on this as a form, he calls it copy fraud, right? It's an overbroad assertion of your rights that then, sort of chills behavior. And a lot of what we see with sanctions in this space, especially around speech or around humanitarian endeavors, is even though they're licensing for humanitarian deals, or even though there's a carve out in IEPA for speech, is you have an overbroad assertion of rights that then chills speech, which I hope we'll get into later today, because a lot of that over compliance with sanctions is actually where a lot of the teeth lie in the way that sanctions work on a day-to-day basis. And that's something we hadn't really gotten on the table yet.
Thank you very much. That was a terrific panel. Do I turn it over to you? Yep, okay. I turn it over to Kaylee. We're right on time.
Thank you guys so much. That was phenomenal. We are thrilled that you could all make it and speak. That was incredible. And I just want to note right now that we're going to have a 15-minute break before our second panel. So this is an opportunity to inject coffee into your veins or use the restroom. But our next panel starts in 15 minutes. So return promptly.
That was terrific. Yeah. I mean, I think I was. Yeah, framework agreement. Yeah.
ICC. If I was an American. Hey, how are you? Nice to meet you, Pam. They're gonna be muted until you.
Until I what?
Oh, it's me. Yeah.
I unmute that.
If they don't have music now. I still have time to grab a water.
Yeah.
No worries.
Oh, Eric.
Yeah, you gotta get there. All right. That's right, there's only like physically here.
All right. So I hope we're feeling sufficiently refreshed. I will be providing the comedic relief all day. So here's our second panel. We have today Associate Dean Pamela Bookman. She is the Associate Dean for Academic Affairs, and she's a professor of law here at Fordham. She's an expert in the fields of civil procedure, contracts, international litigation and arbitration, and conflict of laws. She was prior to Fordham, she was at WilmerHale, where she represented clients in complex commercial business disputes with a focus on transnational litigation and maintained an active pro bono practice because she is the best. Professor Bookman clerked for Judge Robert D. Sack of the United States Court of Appeals for the Second Circuit, clerked for Supreme Court Justice Ruth Bader Ginsburg, as well as President Rosalind Higgins and Judge Thomas Bergenthal of the International Court of Justice. And we welcome her today and thank her for moderating this panel. I would just note that two of our panelists for the second panel are joining us over Zoom. And we will expect to see them on the screen momentarily, but let me introduce everybody. In person, we have Thomas Fetto. Thomas is the founder of the Rubicon Advisors, where he provides strategic and national security related advisory services to multinational corporations, investment funds, startup companies, financial institutions, and law firms and their clients. From 2019 to 2021, Tom served as the United States Department of Treasury's first Assistant Secretary for Investment Security, leading the Interagency Committee on Foreign Investment in the United States and overseeing its national security reviews of cross-border transactions. Tom was previously a law partner at Alston & Bird's International Trade Practice. He also served as Assistant Director for Enforcement at the Office of Foreign Asset Control, where he oversaw the Treasury Department's economic sanctions enforcement efforts, and he was the Special Assistant to the General Counsel of the Navy, a Majority Oversight Council at the United States House of Representatives Energy and Commerce Committee. Earlier in his career, Tom was an officer in the United States Navy's Nuclear Submarine Service, and he was at the Naval Criminal Investigative Services Anti-Terrorist Alert Center. Also in person, we have Eric Woodhouse, a partner at Kroll & Mooring, and a member of the firm's International Trade and Financial Services Group. Prior to joining Kroll, Eric served as Deputy Assistant Secretary of State for Counter-Threat Finance and Sanctions at the Department of State, where he played a key role in the department's policy development and implementation related to all U.S. country-based sanctions programs and a range of global programs. Eric worked with counterparts across the executive branch to establish and implement new sanctions programs, coordinated U.S. sanctions policy with foreign governments, and engaged with private sector stakeholders on a range of United States sanctions priorities. His prior government experience also includes service in the Department of Treasury's Office of International Affairs. Remotely, we have joining us Christine Abele. She is an assistant professor of law at the New England School of Law, Boston. Her research focuses on sanctions and international trade. She is the author of The Russia Sanctions, the Economic Response to Russia's Invasion of Ukraine, which looks at the economic response to Russia's invasion of Ukraine. She has appeared on Boston Public Radio to discuss the sanctions against Russia, and her work on sanctions has been referenced in the Wall Street Journal. She has published opinion pieces on international trade issues in the Hill, Just Security, and other forums. Lastly, joining us over Zoom and from Japan, which means that this is a very inconvenient time for him, is Edward O'Callahan. Ed is a partner at Cahill, Gordon, and Reindel in the Washington, D.C. office. He previously served as the Principal Associate Deputy Attorney General of the United States Department of Justice, where he acted as the principal counselor to the department's second highest official, the Deputy Attorney General, and as a key advisor to the Attorney General. That would be the first highest official. During his most recent DOJ tenure, Ed also served as acting Deputy Attorney General, the Principal Deputy Assistant Attorney General, and the Acting Assistant Attorney General in charge of the National Security Division. In this latter role, he supervised all units and components within the NSD, including the Counterterrorism Section, Counterintelligence, and Export Control Section. Oh, and the Office of Intelligence, Office of Law and Policy, Foreign Investment Review Staff, and the Office of Justice for the Victims of Overseas Terrorism. So he did a lot. From 1998 until 2008, Ed was an Assistant United States Attorney for the Southern District of New York and the co-chief of the Terrorism and National Security Unit during the last 3 years of his tenure there. And at this time, I'm going to, before I hand it over to the panel, read out your CLE codes. If you could please display. Are we good? Okay. The code is S C E 2 5. Who has bingo? I'm kidding. Okay, I'll stop. With that, you may take down the codes. And now, here's our second panel.
Thank you so much. Thank you, Kaylee, and thank you to the Fordham International Law Journal, and thank you to all of you for being here and for joining us remotely. I think we're going to go in order of Christine, and then Ed, and then Tom, and then Eric to wrap us up. The panelists will again speak for 10 to 15 minutes, and then I'll ask some questions, and then we'll open it up, much like the last panel. Okay, so without further ado, Christine, do you want to go ahead?
Great, thank you. Thanks so much to the Journal. I really appreciate the opportunity to speak with you all today on this important and timely topic. I'm very sorry I couldn't be there in person. My family has come down with quite a bad case of the flu. So today I'm going to be speaking about the power of the judiciary to oversee executive actions taken with respect to sanctions under IEEPA. So the start of the new Trump term has made more salient calls to amend IEEPA to place certain limitations on the use of economic sanctions by the executive branch. And part of that is due to the limited role of the judiciary in overseeing executive actions in this area. So certainly the Trump administration, both the first term and the first weeks of this second term, and the Biden administrations use sanctions in a very robust manner. However, the two presidents' use of sanctions were very different in manner. The Biden administration imposed the most numerous use of sanctions in recent years in response to Russia's invasion of Ukraine. There were targeted in nature, smart sanctions. They were levied against individuals, entities, and sectors of the Russian economy. However, they were imposed against so many targets, Russian-linked and other targets, that they almost resembled a comprehensive sanctions regime in nature, in which a blanket prohibition is placed with certain exceptions relative to a particular geographic area. The Russia sanctions stopped short of a comprehensive ban, but many, many targets were in fact designated. The important point is that Biden's imposition of sanctions was taken as part of a joint effort between the United States and other sanctioning jurisdictions, including the European Union, the United Kingdom, Japan, South Korea, Australia, Canada, and others. Certainly, many countries across the world did abstain from sanctioning Russia, but the United States and President Biden undertook the sanctions as part of this joint effort. In contrast, the use of sanctions during the first Trump administration was marked by controversy on the international stage, a trend that seems to be continuing today. The first Trump administration saw the snapback of secondary sanctions related to Iran following the withdrawal of the United States from the JCPOA, the Joint Comprehensive Plan of Action. During his first term and again during the second term, President Trump imposed sanctions on certain persons associated with the International Criminal Court. And during the second term, President Trump has threatened sanctions on Colombia in order to coerce Colombia to accept deportees from the United States in the manner demanded by President Trump. And beyond the use of just sanctions, President Trump has cited IEEPA this term as the legal basis for an additional 10% tariff on imports from China, as well as a threatened 25% tariff on imports from Canada and Mexico. So the use of sanctions by these two presidents has been very different, although the use of sanctions has been robust. A unifying theme, however, of sanctions imposed by President Biden, President Trump, and indeed by other presidents is their resilience to challenge in the U.S. courts because of the expansive authority granted by Congress to the president pursuant to IEEPA. The statute allows the executive broad discretion to sanction foreign entities and individuals in the event there is a national emergency. It allows the president to address threats to the national security, foreign policy, or economy of the United States, which arise in whole or substantial part outside of the United States. And the power to declare a national emergency is very flexible. It's been declared to meet a variety of threats and has been used fairly frequently. Specifically, the president declared 69 new national emergencies pursuant to IEEPA between 1977 and January 15th, 2024. New states of emergency declared pursuant to IEEPA in recent years have included those related to the global illicit drug trade, sensitive data and protection from foreign adversaries, cyber-enabled activities, and specific states of emergency relative to China, Russia, Afghanistan, and others. In general, the executive has broad and sweeping powers to sanction pursuant to IEEPA, and the courts have noted that the president's ability to declare a national emergency pursuant to IEEPA is action taken pursuant to specific congressional authorization, and thus is supported by the strongest of presumptions and the widest latitude of judicial interpretation, and the burden of persuasion would rest heavily upon any who might attack it. And indeed, the vast majority of economic sanctions-related challenges in the U.S. courts have upheld actions taken by OFAC. For example, designations made by OFAC pursuant to IEEPA have generally been upheld. And in these cases, courts have described the various grounds upon which an action taken by OFAC might be challenged. For example, a designation made by OFAC can be challenged on the ground that the sanctions actions were not justified under the relevant regulation or statute, or perhaps because the decision was made in an arbitrary, and capricious manner, meaning that the agency did not engage in reasoned decision-making. The court reviews whether OFAC's decision is supported by substantial evidence, which requires more than a scintilla, but can be satisfied by something less than a preponderance of evidence. This is a difficult bar to overcome in the courts. Courts are generally required to be extremely deferential to executive blocking orders, and even the fact that a sanctions designation might have been removed by the European Council when it was made on similar grounds does not necessitate OFAC to take a parallel similar action. The standard of review in the APA context is, in fact, not demanding, and courts have noted that that's particularly true where actions under review involve foreign affairs and national security. There is the requirement that sanctions designations must comply with the requirements of due process pursuant to the Fifth Amendment. However, procedural due process requires that a law must give fair notice of conduct that's forbidden or required, but courts have held in certain instances that non-resident foreign nationals without substantial connections to the United States cannot assert successfully a due process claim as they lack standing to do so. And oftentimes, courts which do not deal with that specific issue often find that due process has been satisfied in any case. Certainly, it's not impossible that courts might find that a sanctions action is not, in fact, appropriate. And a notable exception to the general rule that sanctions actions are upheld in the courts was, of course, the Tornado Cash case, Van Loon versus the Department of the Treasury. But that case, in fact, was an outlier. It involved Tornado Cash, which is a virtual currency mixer involving smart contracts. And that mixer had been sanctioned by OFAC in August 2022. That action, in fact, was held not proper by the courts, but it was based upon the definition of property. And the court found that the immutable smart contracts of Tornado Cash were not property because they were not being capable of being owned. But there we see the sanctions power being used in a novel way against Tornado Cash, which is quite different from the targets that are traditionally made subject to sanctions. And so if the executive makes sanctions designations in a way that is traditional and is not creative in the way that the Tornado Cash sanctioning was, then generally speaking, even if it's policy which the US Congress might disagree with, even though it's a policy which some may disagree with in this country, so long as it meets the requirements of the laws I've just described them, then generally they will be upheld by the courts. As the court has stated, Congress granted wide latitude over sanctions to the executive, and it is not for the courts to say otherwise. So unlike other areas where there's robust judicial review of executive actions, when it comes to IEEPA, judicial review is in practice quite limited. So that perhaps makes more important the recent proposals to amend IEEPA to provide for a greater legislative role in the sanctions process. Such a case was the Countering America's Adversaries Through Sanctions Act, CATSA, and that was passed by the US Congress amidst fears that congressional action was perhaps necessary to have the executive sanction on a mandatory basis certain Russian-linked targets. And that was based on the fear that perhaps President Trump would be loath to do so. There have also been proposals. Peter Harrell, for example, has proposed certain reforms to IEEPA, including more robust and detailed reporting to Congress under IEEPA, that there be an improved notice and comment rulemaking pursuant to IEEPA, and that congressional vote be required on certain actions taken to IEEPA. So given the fact that judicial review is necessarily limited in this area, that makes more pressing and more salient calls for legislative reform to IEEPA if the goal is to achieve some sort of limitation on what the executive can or cannot do with respect to the imposition of sanctions. Thank you.
Thank you so much, Christine, and I hope everyone feels better soon. Ed, do you want to go ahead?
Sure. Thank you. Good morning, everyone. I think the first thing I should do is do a sound check from Japan, because we didn't do that. And I want to make sure I'm not just talking to myself here. Can everyone hear me?
Yes, we hear you loud and clear. Thanks so
Great.
much.
Thank you. Amazing what technology can do. So thank you, Fordham Law, for the invitation and for the International Law Symposium for putting this event together. I'll just start out by saying, while I didn't attend Fordham Law, I have a lot of friends who did, including the judge for whom I clerked in the Southern District of New York, Judge Kevin Thomas Duffy, who's a proud Fordham alum. Doing this panel for Fordham at 12:45 a.m. in Tokyo, I think would give Judge Duffy a kick. So I'm happy to do it in tribute to him. I will say that and start by saying that the note that I put together for the symposium really does try to describe how economic sanctions enforcement is, clearly one important tool in the overall toolbox of national security enforcement by the U.S. government. There is a position within the National Security Division at DOJ, which I led for a period of time in the first Trump administration, that our prosecutions and our enforcement in the National Security Division is apolitical, which of course it should be. And a lot of the cases that are investigated and brought through the National Security Division and the various U.S. attorneys' offices take a long time and span one administration to the other. And so really the national security enforcement and public safety implications of those cases are what's paramount. In economic sanctions, however, and kind of the theme of my note is there is adherence to a particular administration's foreign policy priorities in the implementation and enforcement of its economic sanctions program. The note goes through the history of the development of the sanctions and IEEPA going back to President Carter, and how it was developed in all of the Democratic and Republican administrations since then. And if you look at the focus of the sanctions, I would say in each of the administrations, they align with the foreign policy priorities of the administration in place at the time. And so I thought, instead of just going through my note, I would actually walk through some of my personal experience with the various sanctions in the different administrations, and how the development of it really did align with the foreign policy priorities of the various administrations at the time. And to do that, I was going to start actually in post 2001 world, when I was Assistant United States Attorney in the Southern District of New York. But Judge Duffy came to mind. I can actually say that when I clerked for him in 1995, 1996, Judge Duffy was the judge who was sitting over the kind of original New York terrorism cases, the first World Trade Center bombing, the Ramzi Youssef trial, where the conspiracy by Ramzi Youssef to blow up U.S. airliners over the Pacific was brought to trial there. And then ultimately, some of the Al-Qaeda and the Osama bin Laden indictment were before Judge Duffy. And I think the first lesson from that period, which of course spanned both George H.W. Bush's administration and then Bill Clinton's administration, was that the lack of robust sanctions enforcement really hampered the U.S.'s ability with respect to crippling the financial resources of foreign terrorist organizations, most especially Al-Qaeda at the time in the late 90s. The fact of the matter was, before Bill Clinton, foreign terrorist organizations were not included in sanctions enforcement policy by any administration, Democratic or Republican, and it took a Democratic president who was experienced various terrorist attacks across the world against the United States, including the embassy bombings in Africa in 1998, to understand that robust enforcement of sanctions could actually be another tool in the toolbox in the national security priorities of the country. And so we saw that start to happen. Unfortunately, 9/11 took place soon after some of that late 90s implementation of robust sanctions enforcement. And then post 2001, after 9/11, what we did as I was in the command post at the time of the attack, and we followed the money, of course, to identify the hijackers and where they were all connected in various parts of the world prior to the attack. Had there been a more robust sanctions enforcement prior to that, I dare say that some of that financial resource investigation could have been already started and perhaps helped us in tracking down some of those folks before the attack. When I was at the U.S. Attorney's Office in from 99 to 2008, sanctions enforcement was a big part of what we did in the National Security Unit in the Southern District of New York. And two of the cases that I worked on showed, they were large investigations, but showed really what we could do with sanctions enforcement. One major case goes back actually to the Iraqi regime of Saddam Hussein. And there were global, much like the Russia sanctions that we heard today about the combined effort of global countries to enforce sanctions against a particular individual or country. The world came together to enforce sanctions against Saddam Hussein and his regime. And when I was in the Southern District of New York, one of the cases, one of the main cases I worked on for over 5 years was the case involving the Iraqi oil for food program at the UN, which ended up being a $65 billion fraud on the Iraqi people and the world that had come together. It was a system rigged to allow Saddam Hussein to sell his oil, which was strictly prohibited under the sanctions that were imposed globally on him. And he got kickbacks from companies across the world that were willing to violate those sanctions to get oil contracts and supply people, the Iraqi people, with some humanitarian aid contracts. So we prosecuted U.S. oil companies and their executives who participated in that scheme. Sanctions was a big part of that enforcement effort and prosecution, and we repatriated hundreds of millions of dollars to the Iraqi people through those enforcement and prosecutions. Next, as I was part of the terrorism unit, we did employ sanctions, prosecutions, and enforcement against other terrorist organizations. One key one was Hezbollah, which had a network across the world again that would assist in the foreign terrorist organization designated by the state and assist them. And the sanctions that were imposed against them were implemented by the United States and enforced. And we did one prosecution against actually a cable company in Brooklyn who was violating the sanctions by selling cable access to a Hezbollah-run TV outlet. That case brought some interesting First Amendment issues with it. Under IEPA, there is something called the Berman Amendment, which protects against violations of the First Amendment by sanctions enforcement and prosecution, and that we were able to bring that prosecution nonetheless and convict the individuals who were here in the U.S. violating the Hezbollah sanctions in that case. When I left the Southern District of New York, I went into private practice based in New York, as you have in my note, I go through kind of the 2009 forward under President Obama and the effort to really restrict global financial institutions from violating sanctions in place against countries such as Iran, Burma, Sudan, and the financial institutions that were found to have violated the sanctions in processing U.S. dollar transactions that were strictly prohibited under the sanctions. But it wasn't just financial institutions. One of my representations while I was in private practice during that time was a representation of FACA Services, which was a Dutch-based aviation services company that was found to have violated the sanctions against Iran, Burma, and the Sudan for supplying refurbished commercial airline parts to Iranian entities in violation of those sanctions. That was a case where, in representation of FACA Services, I met one Tom Fetto. I had met him previously, but I had to deal with Tom Fetto as his assistant director of OFAC enforcement at the time. And ultimately, we did a voluntary self-disclosure. And this is actually a case study in the note, which is an interesting case study of how sanctions enforcement against companies need to take into consideration the overall national security role of perhaps the company, or again, the priorities of the administration at the time. So we were able to negotiate with a deferred prosecution agreement for FACA Services where they acknowledged their responsibility for violating the sanctions, paid a fine, and then completed the term of their DPA, enabling them to continue to be part of, at the time, this was in about 2012, I believe, part of the development of the F-35 Joint Strike Fighter that the U.S. was developing with some of its allies, and is now one of the most advanced fighter jets in the world, maybe the most advanced. So continuing through the chain, during the Obama administration, again, I represented a number of large in the implementation of some of the Russia sanctions that occurred after the invasion of Crimea. That was that was correctly highlighted as a big enforcement priority of the Obama administration, and we had a lot of clients who were trying to navigate the strict implementation of really unprecedented sanctions against Russian entities and Russian individuals, which led to a number of, again, large settlements with financial institutions. Then I went to NSD, the National Security Division, at the end of 2017. And that this is in the first Trump administration, of course. It is correct that I think while the Russia sanctions were not enforced as potentially as robustly, although as Tom and Eric and others know very well, it is a large ship to turn once the government has decided to implement sanctions and start enforcing it. So it's not like a flip of the switch. So the sanctions programs from the Obama administration, some carried over, but in the National Security Division, which is the DOJ component that oversees sanctions enforcement, there certainly was a pivot to a priority on sanctions against the Iranian government and entities that, again, were engaging in U.S. dollar transactions in violation of the Iranian sanctions, which had been relaxed under the Obama administration, again, consistent with the Obama administration's foreign policy goals. While at NSD, we saw a swing back to more robust sanctions against Iran, and also robust sanctions against North Korea and China, all of which aligned with the foreign policy priorities of the first Trump administration. Now I'm in private practice again. I left the department at the end of 2019. And again, I'm in private practice with sanctions, and for sure, the priority of the Biden administration was even more robust enforcement of Russia sanctions, particularly those that were implemented after the invasion of the Ukraine. I think that what we will see, and again, a loosening of the sanctions focusing on Iran and Iranian entities and financial institutions engaging in US dollar transactions in violation of those sanctions. But now with the Trump administration coming in, I do believe that the Iranian sanctions will again swing to a focus. I also think we'll see an uptick in sanctions against some other Middle Eastern countries. Like there are Syrian sanctions that are in place, and of course I'm focusing on some of the geographic related sanctions enforcement, because that is my particular experience. The economic sanctions programs go broader than just that, to individuals, to specially designated nationals, to kingpins. But the work that I have specifically been on relates to some of the more geographic focused sanctions. So I do think that, and the conclusion of my note is that it will be interesting to see, and probably difficult to predict with the Trump administration exactly how they go about their sanctions enforcement priorities. Secretary of the Treasury Bessent has indicated that he is prepared to continue and maybe even in certain cases enhance sanctions against Russia and Russian entities. However, there are statements by President Trump where he says that in his view, the sanctions enforcement of the Biden administration was quote unquote indiscriminate. I think that might be an overstatement, because I do see it was very Russia focused. But President Trump has indicated he's very concerned about overuse of sanctions because of the destabilizing effect it may have on the status of the US dollar. And we did see Russia take actions to avoid the real impact, the drastic impact on the Russian economy for the sanctions enforcement that were implemented post Ukraine invasion. And that was lessons learned by Russia from the implementation of the sanctions post Crimea invasion. So I think that we will see the Trump administration implement sanctions, but also loosen them and maybe pull them off more quickly than we've seen in the past. I think that is a likely scenario, at least in certain circumstances. So that is my run through the history of Ed O'Callaghan and sanctions involvement. Happy to answer questions after the other panelists go. Thank you.
Thank you so much. That was terrific and fascinating. Tom, do you want to go ahead?
Sure. Thank you, Professor. Thank you to Fordham. It's a pleasure to be part of this discussion. Given my experience as a leader at OFAC in the enforcement division, I thought it would be helpful to actually get in the weeds a little bit and explain a little about this idea, the topic of the panel about enforcement, because we often think that implementation, that imposition of sanctions is enforcement, but there's really sort of a distinction there in terms of how do we actually make these work? And a lot of policymakers, in the course of economic sanctions becoming a default tool in many instances for economic statecraft, the question is, do we really understand how they're effectuated, how we enforce them, and why policymakers think or expect them to work? And so I thought I'd get into a little bit of that, touch on some of the points in Ed's note that I've had the pleasure of reading, and then move on for the question and answer part of this. OFAC is actually, pound for pound, in my view, the most impactful national security agency in the US government. It is not a big agency. It's about 300 people. And yet everybody that is within US jurisdiction can be impacted by it. Major financial institutions employ thousands and sometimes tens of thousands of people to ensure compliance with economic sanctions. Just doing that, KYC, customer due diligence, and sanctions compliance, and anti-money laundering compliance. And so it has this major impact, but OFAC itself has only about 36 people dedicated to sanctions enforcement. And what does that mean? Well, it's only civil enforcement authority. We leave, or I shouldn't say we because I'm not there, I haven't been there for a long time, but the agency leaves criminal enforcement to the prosecutors. And so the enforcement division at OFAC, this amazing agency that has such an impact, is largely reacting to parties that are submitting voluntary disclosures or reacting to whistleblowers or reacting to reports from financial institutions that have interdicted property that they believe belongs to a sanctioned party. They submit a report to OFAC, and then the enforcement division starts to look at that to determine to what extent there's a violation of the civil regulations. They do that through subpoenas, administrative subpoenas that are quite robust for production of documents and emails and information. And then there's an analysis of a potential violation versus the facts and the regulations that prohibit certain types of conduct. There's an analysis of whether the conduct was egregious. There's essentially a discount on potential penalty if it's voluntarily disclosed. And then there's a thoughtful consideration of a series of factors that are in the regulations called the general factors, which determine to what extent national security was harmed. Was this the first time a party made such a transaction? Do they have a compliance program in place to comply with sanctions? All of that comes into the calculus for determining the extent and the scope of the penalty. The committee, the OFAC doesn't just issue civil penalties. They oftentimes issue private, they're not public, cautionary letters detailing how the conduct was violative, but giving the company or the person a pass. There are no action letters. There are findings of violation, which do not include a civil monetary penalty, but publicly disclose the conduct of the party. And then there are settlements or civil monetary penalties. The agency really doesn't impose very many penalties each year. On average, over the last 5 years, it's only been 16 civil penalties each year, and averaging only between, I say only, it's a big number, but not as substantial as some criminal prosecutions or some of the bigger civil penalties against large global financial institutions, but somewhere in the range of $20 to $40 million a year, with the exception of the Binance penalty, which was a multi-agency settlement, and OFAC's civil penalty was close to $1 billion. Its biggest penalty ever. And so that's part of the construct of how OFAC implements and enforces sanctions. The public penalties and settlements, there's an attempt to provide details on exactly what the party did that violated the regulations so that everyone else gets the benefit of understanding how they and their companies and their financial institutions can comply. It takes years in the bureaucracy at OFAC to see a case to closure. So there is some lag. If you read some of the violative conduct that's posted in, for example, in 2024, some of it dates back over a decade. And there's a great deal of coordination, as Ed alluded to, with criminal authorities. So oftentimes, OFAC will administer a civil penalty in a joint investigation with the Justice Department at headquarters and with a U.S. attorney somewhere in the country. I will say that while OFAC is supposed to be the repository of the knowledge of the construction and application and interpretation of the regulations, sometimes our prosecutors get a little robust in their interpretation and get out ahead of the of OFAC in terms of the scope and reach, and sometimes, as has been discussed, that turns to litigation. There are two. There's an important point about the scope of the penalties. It's 307. It's inflation adjusted, so right now it's roughly $378,000 per transaction, or twice the value of the transaction, whichever is greater. And so, to the extent you are a global financial institution and you've not been complying with the regulations, and you've been rolling through transactions that violate the rules, each of those is a substantial penalty that could amount to a potential maximum penalty of hundreds of millions or billions of dollars. And so that is sort of the forcing function that co-ops private parties into being part of the enforcement infrastructure that makes U.S. economic sanctions impactful. Now, I'm saying impactful, not necessarily effective, but impactful is an important point. Our economic sanctions, I think there's an important question, and it was alluded to quite a bit in the first panel, and I think it will go throughout the day in the other panels. There's a question on whether economic sanctions are appropriately or effectively tuned to national security or to something beyond national security. There are, as folks know in the room, there are different types of sanctions. There are embargoes, designations, secondary sanctions, which I interpret as some of the more creative things that Congress and the executive branch have implemented over recent years, where, for example, the threat of denying correspondent banking privileges in U.S. banks, in the U.S. financial system, if a foreign party or a foreign country does not comply with the prohibitions. Pre 9/11, sanctions were a tool in the toolkit. Post 9/11, they've become a huge default tool. Again, targeting and implementation, in my view, is different from enforcement. OFAC primarily focuses on deterrence and compliance after implementation. And I think there are a couple of things that will be helpful to understand why they've become such a default tool. There was a sea change in about 2009, excuse me. A U.S. financial institution, for example, many of the prohibitions in the regulations say a U.S. person, U.S. bank is prohibited from providing services to country X or dealing in blocked property of person Y. And in 2009, there was a small bank case, ANZ Bank, an Australian and New Zealand bank, where OFAC began to interpret the regulations that if a foreign bank caused a U.S. person to violate that prohibition on providing services, that was the jurisdictional hook to hold a foreign bank accountable. And between that and the 2007 IEPA Enhancement Act, which gave this huge, twice the value of the transaction power in the Civil Enforcement Authority, that's when we began to see a huge proliferation of massive penalties against international financial institutions that really snapped everybody's head and brought them and to focus on the importance of complying with U.S. economic sanctions. The other sea change, I think, is Congress's involvement. In 2009 timeframe, 8-9 timeframe, Congress passed the Comprehensive Iran Sanctions Accountability and Divestment Act, CISADA, which brought into concept this idea of secondary sanctions and denial of correspondent banking. And it was so effective in getting other countries to stop oil exports to, or oil purchases from Iran and isolating Iran, that Congress decided, wow, this legislation can work. And you've seen since that time frame, Congress increasingly legislate economic sanctions and direct the president to take certain action. Let me see if I've got anything else. I didn't promise eloquence. I personally am not concerned about a diminishment of the U.S. dollar being the preferred reserve currency of the world. But to the extent America's adversaries find and develop and refine ways to avoid U.S. jurisdiction, for example, new payment rails, crypto, we talked about earlier, then they obviously become increasingly hard to enforce, given what I've described as the mechanism and the resources dedicated to civil enforcement in the United States. Because while it may be that designations or implementation of sanctions may take on an extraterritorial nature, enforcement is, it's a tautology, but U.S. jurisdiction only extends to the reach of U.S. jurisdiction. And so if there's action that's outside of that, then from an enforcement perspective, it becomes incredibly hard to enforce those sanctions. Bottom line, I think it's beyond time to rethink the economic sanctions paradigm, their use, their application, their reach, their utility, and maybe even the United States government needs to think about developing, excuse me, and articulating an economic sanction strategy, not unlike the national security strategy or the national defense strategy, so that there's a clearer picture of the intent and objective of economic sanctions as a tool. Thank you.
Thank you so much. That was terrific and really enlightening too. And so, Eric, I'll ask you to take us on with the concluding remarks.
Absolutely. That's a great segue to the focus of my remarks. But first of all, I just want to thank Fordham for hosting us and everything that the organizers have done to bring us together. It's really a pleasure to be here with all of you today. There is implicitly and sometimes explicitly in several of the papers today and in the remarks, and certainly in frequent public commentary on sanctions, the contention that sanctions are being overused. One of the themes of today's symposium is limitations on the imposition of sanctions. And these play out in important ways in litigation and in the handling of specific cases. But I want to focus more on broader questions about the overall growth and expansion of the use of sanctions. Certainly, the numbers show a stark increase in the use of sanctions since 2000 in terms of overall designations and also in terms of ongoing declarations of national emergency and the creation of new sanctions authorities. Many explorations of substantive and procedural limits to sanctions start from the premise that U.S. sanctions use has exceeded some concept of a proper scope and needs some additional limitation. These observations come not only from academic discussion and others outside of government, but I think concern about overuse motivated, in part, former Treasury Secretary Jack Lew's 2016 speech that set out guideposts for the effective use of sanctions, as well as the 2021 Treasury Department Sanctions Review, which set out principles for sanctions policymaking going forward. I think these critiques are important, but it's valuable to pull apart different sorts of arguments and empirical assertions that sort of exist under this broader umbrella. whether you think there's a problem that needs to be addressed, and if so, then what sorts of solutions would be appropriate. Starts with the underlying issues at play. So in walking through these, I aim more to identify a set of issues and some thoughts on each of those. Many of them will raise complex debates that I will not try to resolve. Maybe we can get into more of them in the question and answer session or in other discussions. But I wanted to try to structure some of the discussion by covering a good bit of territory. And in doing so, I'll note that I now work as a lawyer in sanctions compliance and enforcement, helping companies figure out how to comply and how to deal with enforcement matters when they arise. In my experience in government, I did not work in OFAC. I was not part of the enforcement mechanism. I worked at the State Department, where most of the work revolves around thinking through how to use these tools to achieve foreign policy ends. So I bring a slightly different perspective from my time in government that you'll probably hear in some of my remarks today. So one version of the argument about overuse focuses purely on numbers, the ever-rising number of designated persons appearing on OFAC sanctions list, the growing number of programs and different purposes for which sanctions are used. I think these are helpful as raw data, and they tell us that sanctions use has grown consistently for many years, and they, to a certain extent, underscore that we may have to answer questions more urgently as we proceed and as that use continues to grow. But I think care is warranted to a certain extent in interpreting the significance of the numbers. Certainly, the Russia program was a stark and rapid increase in the numbers of designated persons and in the overall scope and reach and aggressiveness of sanctions use. But it speaks more to the state of the world and the challenges before the US government at that time than I think it does whether any particular action is warranted or not. Another critique that is advanced is that sanctions are being used without a clear or realistic objective. The Treasury Review implicitly notes this when it said that Treasury would adopt a structured policy framework to ensure that sanctions are linked to clear policy goals. This is good housekeeping, and certainly a strong policy process is something that we should always focus on in government, or that our government should always focus on. Sometimes I still say we when I should no longer say we. And I think this can help improve, outcomes on average, and head off ill-conceived ideas along the way. But I don't think it will really change the overall trajectory of sanctions policymaking. A related argument that we hear is that sanctions have increasingly strayed from a fundamental focus on changing behavior. As Andrew Adams notes in his paper, the oft-repeated mantra of sanctions is that they are not intended to be punitive, but to change behavior. That is correct, and at a fundamental level underpins all of our sanctions actions. But it has fed a perception, I think, that unless sanctions achieve behavior change in the near term or even over the medium term, they have failed. I think it's important to recognize that other policy goals exist alongside behavior change. And in some cases, such as when policymakers are aware that behavior change is not likely or not imminent, these other policy imperatives are more urgent drivers of policy decisions. So in the counterterrorism finance and proliferation finance sanctions programs, just disrupting financing networks in ways that delay funds, reduce resources, and raise costs to terrorism or proliferation networks are valuable. Those are important and urgent policy goals that drive sanctions policymakers within the US government. Even if ultimately there's an expectation that networks will adjust and find other ways to move funds, and the US policy apparatus will have to continue adjusting and continue seeking to disrupt those new avenues. In the Russia program, valuing disruption as a goal changes the debate a bit about effectiveness. A common critique of the program is that it failed to stop the invasion, and thus that sanctions have failed to achieve their objective. I don't think this is an entirely fair critique. The overall objective of a sanctions program is something that has to be worked on using all of the available tools, and ideally a combination of available tools. Sanctions need to play a helpful role in that. In the Russia case, sanctions have succeeded in disrupting Russia's efforts by reducing the resources it has at its disposal, disrupting its access to critical inputs it needs to sustain its invasion. Of course, those impacts were sometimes not as great as those of us in government would have hoped. And Russia has found ways to adapt and sought ways around these restrictions. And the sanctioning coalition of countries had to respond in a variety of ways over the course of the program. But along with other tools that were used, most importantly, I think financial and military support to Ukraine, the sanctions have played an important role in helping Ukraine resist Russia's invasion so far. A third argument focuses on objections that sanctions are or have become excessively extraterritorial. Here, I would distinguish, this is a particularly frequent and important discussion with colleagues and partners in Europe. And here I would distinguish between the reach of US criminal and civil jurisdiction, and then the use of sanctions authorities to designate actors abroad, even in contexts that are commonly referred to as secondary sanctions. Peter Harrell, in his paper, described the ways in which, and Tom mentioned as well, the ways in which OFAC and the Justice Department have over time expanded the reach of criminal and civil enforcement authority related to sanctions, including by exercising jurisdiction where, for example, extraterritorial conduct has caused a violation of sanctions by a US person or in the United States. Secondary sanctions in general operate differently. They involve designating a person abroad and thus are implemented the same way most US sanctions operate, by regulating the conduct of persons and property subject to US jurisdiction, by saying US persons may no longer engage with the foreign target. In this context, the critique of extraterritoriality is really about the effect of these actions. There's absolutely an extraterritorial effect to these actions that merits debate, but it's less so about an assertion of jurisdiction. One can certainly have a debate about the pros and cons of those effects, but that's what sanctions are. They are intended to have extraterritorial effects. And so, as I mentioned, the debate is less about jurisdiction per se, or even about starkly different types of measures, and more about a general discussion about the pros and cons of particular actions. A fourth argument rests on concerns that sanctions use will eventually threaten the role and status of the US dollar in the international financial system. Several panelists have commented on this. This concern has also been expressed in different ways by former Treasury Secretary Liu, former Treasury Secretary Yellen, and in the 2021 Treasury Sanctions Review. And seemingly every 6 months or maybe 3 months, there's another paper or piece in the media arguing for or against the risks to the US dollar. I won't recount all of the arguments in this debate, but I'll add one observation that I think is important. And Tom started to get into this, I think. There's a distinction that should be made between the role of the US dollar as a reserve currency and the role of the US dollar as a payments currency. Certainly, these are intertwined and they're not fully independent of each other. But the distinction is material in this context. Most of the data shows a modest decline in the dollar's share of global reserve assets from just over 70% roughly in 2000 to a bit under 60% by the early 2020s. And across other important indicators, such as the percentage of FX transactions that involve the dollar, international payments involving the dollar, trade invoices, and international debt and loans, the dollar remains near or above 50% of a share of global activity, sometimes substantially above 50%. But if you look in other areas, you see more market change. For example, the currency composition of cross-border payments, you can see notable change, for example, in the currency composition of Russia's imports and exports since 2022. With the ruble, yuan, and other currencies accounting for substantially more than they did previously. This does have important implications for US sanctions, as it requires establishing the financial infrastructure to support cross-border currency markets that exclude the dollar or don't involve the dollar, and thus would be less sensitive to sanctions risk. From the perspective of two non-US countries, there are, of course, many logical reasons to denominate trade in their respective currencies. There are also substantial economic and financial reasons why so much activity does and has taken place in dollars and a few other currencies, such as the euro and the British pound. But from the perspective of the effectiveness of US sanctions, this is a trend to watch. It's difficult to build alternative payments infrastructure, but once built, it can be used for a variety of purposes at odds with US foreign policy and national security. But again, payments infrastructure that's of sufficient scale to insulate certain payments from US jurisdiction may still not be and probably won't be of sufficient scale to erode the broader use of the US dollar as a payments currency, let alone to affect the value of the dollar as a US reserve, as a reserve asset. A fifth argument about sanctions overuse is that sanctions have excessive unintended impacts. Of course, sanctions are meant to impose real and substantial costs on their targets. What is unintended or excessive can be subject to a lot of debate in particular cases. Without going too far into those debates, I would offer a couple of observations. One is that the US government does have important capacity to assess short-term impacts and to consider what is intended and not intended, what sorts of impacts should be mitigated via general licenses, and when sanctions actions potentially impose costs that require serious additional policy consideration. The Treasury Department has reinvested in this capacity by establishing a sanctions economist whose job, among other things, is to focus on assessing economic and financial impacts. The Biden administration undertook a broader reform to standardize general licenses across programs in order to facilitate important humanitarian work, and went to great lengths in particular cases to mitigate broader economic impacts, such as following the fall of Kabul and the Taliban's takeover of the government of Afghanistan. One can debate particular cases, but there is a lot of capacity to analyze, investigate, and address these sorts of issues. And this capacity should remain an important part of sanctions policy and implementation going forward. Long-term consequences are more difficult to apply in particular cases. Broader long-term trends that may be affected by sanctions, among many other factors, are harder to weigh when it comes down to making particular policy decisions. Should we designate target X? Should we take sanctions decision or action Y? It's harder to think about the overall, trajectory of the US dollar and turn that into a decisive factor when making those decisions. So it's difficult to translate those things overall, and it requires, to the extent it needs to be addressed, it requires something more akin to an overarching strategy. The last observation I'll make is that the debate about sanctions is taking place in a broader context that's changing in important ways. And I'll just highlight two of those. The first is that we're several years into an era in which we're using sanctions to address issues involving other major powers. This started with Russia in 2014 and obviously more so in 2022. But we're also using sanctions and other tools to address a variety of issues with respect to China, obviously in a very different context, but that has been a notable development in recent years. These cases both pose challenges and implications for the use of sanctions that are different than in previous eras when the targets were smaller nations or non-state actors. Major powers have greater capacity to absorb costs, greater capacity to mitigate and adjust to the impact of sanctions, and greater capacity to retaliate in ways that are important. They're far more difficult to isolate than compared to earlier targets, especially when you consider that in cases like counterterrorism, Iran, and North Korea, we had not only some level of cooperation from Russia and China, but also the broader foundation of UN Security Council action. The second change is that the economic toolkit is expanding. So we're not just talking about sanctions, but about export controls, investment restrictions and screening, supply chain requirements, and also tariffs. This is occurring while broader trade policy is being reconsidered in important ways. I personally am still skeptical that we are obviously in a period of deglobalization in material ways, or that we will end up there. But if you consider all of these developments, I do think we need to consider questions about how far the fragmentation of the global economy may go, with implications far beyond the discussion of just sanctions as an individual foreign policy tool. Thank you.
Thank you so much. Thank you. That was those were all so interesting. I learned a lot from this panel already. We have about 20 minutes for questions, and I'd like to get us started by asking one to everyone on the panel, and then depending on how many questions we have, I might open it up to the audience. Also, remember for those on Zoom, if you you can write the questions into the chat function, and we can collect them on our end if you do that. So looking forward to that and giving you some time to collect your thoughts. I will ask my first question, which is for everyone on the panel, although I'll tailor it. They say that it's hard to make predictions, especially about the future. But sorry, that took a minute. Okay, so but I did want to ask each of you about the areas in which you spoke, or other areas you have, about what you think, what you expect the second Trump administration to do differently going forward, right? So I see this, Christine, for example, do you expect a different kind of judicial moments of potential judicial restraint? Like what might cross, what if anything might cross align, and if anything that you expect where we might see more judicial constraint on, if any, right, on the executive use of sanctions. And another question to is a question about how companies may respond or anticipate changes in what might be coming in the sanctions regime. And Ed, whether you think that there's anything what you expect to come from the next couple of years. And then the changes also in terms of enforcement within the government. I'm very interested to hear if you have any insights into even just the personnel within OFAC, if that's being what's the word? Rethought, perhaps, not in terms of who's there, but also whether there are any firings going on within the industry, within the agency administration, and how if that's all being changed. And then finally, of course, the question of policy generally and how that's being thought through. Eric, if you have thoughts about changes there. So, I mean, it's really anything you want to say. I'm really opening it up, anything you want to say, but I'll offer that as sort of potential guidance, since the future is a big question. Should we go in the same order that we started? Go ahead, Christine.
Great. So I think that one area in which we might see a greater judicial role is with respect to the use of IEPA to justify the imposition of tariffs, right? Because that's something that's somewhat different from President Trump's first term, where he used trade authorities like Section 301 or Section 232 in order to establish or to implement tariffs, and the use of IEPA with respect to the 10% tariffs on imports from China and the threatened tariffs on imports from Mexico and Canada. The legal justification for those tariffs is instead IEPA. And so that's rather unusual. And I think that there is a role for judicial oversight in those areas. And that's something which we might observe where the judiciary might not be willing to go so far with respect to the imposition of sanctions under IEPA. That might be an area of deference to the executive, but the use of IEPA to impose tariffs might be an area that's subject to greater scrutiny.
Thanks.
I could, I'll just say, as you said, it's very difficult to predict with this Trump administration. But I think that what we will see, which will probably drive Tom Fettle crazy, is the administration further blurring the lines in terms of sanctions implementation and enforcement, and just trade policy generally, including tariffs, as Christine mentioned. I think that President Trump will use the threat of more strict sanctions frequently, and we've seen that already with regard to Colombia and the migrant airlift. But I think that it's going to be more of in the immediate what we'll see is the threat of sanctions being used and blurring the lines in overall trade policy. And then, of course, look, it is the case that this Trump administration has a pretty stout national security advisors who believe the Iranian regime still poses a huge threat to the U.S. national security and global security generally, and the Iranian sanctions program will be ramped up again.
So I haven't heard of any firings or resignations affecting the Office of Foreign Assets Control. I don't expect the number of penalties, the average number of penalties or their size to dramatically change. If you look back over almost, since the early 2000s, those numbers through multiple administrations have largely stayed pretty steady. with the exception of what I mentioned about the size and the legal theory behind some of the penalties related to large financial institutions. Other than that, and the Binance outlier, it's been very much and there was conduct in the Binance case that was disclosed that was egregious or deliberate or willful in the way transactions were executed. But other than that, I think the numbers will stay largely the same in terms of size and frequency of penalties. It's I don't expect regulatory interpretation to change. That would be the biggest surprise to me in terms of scope or reach. I wonder, to Christine's part of the discussion, whether recent Supreme Court cases that have diminished deference to rulemaking and regulations provide an opening for more robust litigation on some of these sanctions authorities and other parts of the economic statecraft toolkit. I would expect, as Ed said, that Iran sanctions will be ratcheted up. Again, the question is, how do you enforce those? And is it something where SASADA and denial of correspondent banking becomes something that's leveraged to make things tougher on Iran? And I would also expect we'll see in this administration a more robust Commerce Department. There are a number of tools in the economic statecraft toolbox that have been given to the Commerce Department, whether it's the ICTS rule, more work with the entity listing, a specific call out by the president to Secretary Lutnick to be involved heavily with trade policy and tariffs in a way that is pretty interesting. And so that might be an ascendancy of the Commerce Department and its toolkit and less emphasis on Treasury.
Thank you. So, I mean, I'll echo some of the comments that have already been made, but add a few others. There obviously will be a different focus in sanctions implementation. We've seen some of this. The Iran program has been highlighted, and the new administration has been very clear about that. I think it'll be interesting to see, as Tom mentioned, kind of what form that takes in terms of the types of actions that are pursued. Another interesting new element was the designations earlier this week of drug cartels as foreign terrorist organizations, which I think changes from a sort of compliance perspective. It does increase the risks for various entities that will now have to be looking for exposure to those cartels. So I think that's an interesting new development. Someone I think earlier mentioned in the first Trump administration, the dynamic with Congress, where Congress passed laws to push the administration to take action. And I think it's an open question whether that will continue in this administration. I don't know. It may. I don't know that it will. I think one change that I'm watching is the extent to which the new administration engages with allies and partners on sanctions policy and implementation. The Biden administration emphasized this from early on. This was something that was emphasized, before Russia, engaging with partners and allies, seeking to act together when possible, and in general, staying in touch as we developed sanctions policy. I haven't seen many early signs that this habit will continue under this administration, but we'll have to see. I think there are important reasons why it's helpful to do that. And one example I'll highlight is China. There's a big difference if you're going to think about using sanctions in the China context. There's a big difference between the United States doing something by itself and the United States taking action in coordination with Europe. And so I think this is an important question for the sort of ongoing use of sanctions, and one that we'll have to see what direction this administration goes. For compliance, as we kind of sit here talking about the current focus of the administration, for companies, the fact that, priorities can change, in any administration, but for companies and for those who have to comply with these restrictions in particular, the fact that the statute of limitations just expanded from 5 years to 10 years means that it's going to inevitably cross at least two different administrations. And even within administrations, priorities can change. So I think, echoing a bit Tom's point about the continuity in the enforcement workflow, which I think, the enforcement mechanism at OFAC is a slow twitch muscle. It can have priorities, but it's not a quick twitch muscle like new programs and new designations and new authorities. And so it moves a little more slowly and it has a long pipeline. And sort of in an analogous way for, companies and others who have to comply have to be paying attention, not just to like the active front edge of sanctions policy where the new stuff is happening, but everything, all of the restrictions that exist. And so I think in the compliance community, there's a lot more that's continuous and stable than is changing right now. I guess an exception to that can be a sort of very sudden, abrupt severing of previously permissible economic activity, like what happened with the Russia program in 2022. But otherwise, a lot of the work is just the ongoing work of compliance that can be driven by any of the extant sanctions programs. The last thing I'll say is, I think for reasons that have to do with President Trump and the priorities of his administration, but also the developments over the last 10 years where the toolkit for economic statecraft has grown. I think he has shown he's expressed skepticism about sanctions to a certain extent. He was a vigorous user of sanctions in his first administration, so I wouldn't expect him to hold back if he decides to move forward. But I would expect an ongoing mix of all of these tools. He obviously, favors using tariffs pretty aggressively. We haven't seen yet much on kind of what the direction will be on export controls and CFIUS and the outbound investment rules, but I would expect that those will continue to be part of the mix going forward, and we'll have to see how they all come together. I think that's it.
Thank you. Are there any questions in the audience or go ahead. Oh, sorry. We'll start with you. Sorry.
Thank you so much for this really illuminating panel. I learned a lot. I think this is for anyone, but I'm just wondering, as a descriptive matter and then perhaps as a sort of normative matter, what is the jurisdictional limit of the sanctions regime? Is it anywhere the US dollar circulates, or is it something more modest than that? I guess I just would like to hear a little bit more. And I think, Tom, your comments really sort of brought that up for me. And then I think, Eric, your first point about if it's not if the sanctions didn't prevent the invasion of Ukraine, they achieved other things. What if we sort of stipulated that they're just not effective in terms of deterring behavior, but they're really just, as Nick sort of talked about, norm setting? I guess, do you think it's, should we endorse sanctions if they're just punitive, I guess? Because I think maybe people would disagree on the empirical question, but undoubtedly it is a norm setting expressive kind of function. And is that something, how should we think through that critical piece of it, even if it's not sort of the reason for why they are put forward in the first instance?
Sure, I'll do my best. I mean, most of the sanctions programs and the related implementing regulations are grounded in the U.S. person or the U.S. financial system, and so if there's the prohibitions are essentially no U.S. person may provide services to X country or X person, or import services from X country, or no U.S. person may deal in the blocked property of a designated entity. And so then it comes down to the interpretation of OFAC and federal programs at the Justice Department on what that really means. There have been recent civil penalties from OFAC where a foreign entity had dealings with a sanctioned entity and relied on services back in the United States for purposes of freight forwarding, for example. And that involvement, again, goes back to this causing a U.S. person to violate because those services of the U.S. person were exported in support of a transaction. Not going to hold that if that U.S. person had a compliance program in place and had no ability to discern that it was involved in a transaction with a prohibited person or entity or country, then you can expect the United States to attempt to exercise its jurisdiction with respect to the party that did that. Whether or not, defer to Ed on this, but from the Justice Department perspective, but whether or not the U.S. government can reach that person and hold them accountable is a completely different question. And that was to part of my point earlier about implementation versus enforcement.
Yeah, but Tom, can we just to the questioner's first point? I mean, the jurisdictional reach on the U.S. dollar transactional side is fairly broad and robust. And some of the financial institution resolutions that occurred, principally in the Obama administration and spilling over a little bit to the first Trump administration, were foreign-based banks, some of whom I had, I guess, the fortune and misfortune of representing, who had just failed in implementation of compliance programs to prevent transactions that, on the strict reading of whether it was a U.S. financial transaction, did it actually enter the territorial boundaries of the United States, the answer would be no, right? But the fact that it was in the overall transactional flow of the U.S. financial system was enough to trigger jurisdiction. And also, as Tom said, a lot of those cases are ones where there are voluntary disclosures by these financial institutions, because even though they are not typically thought of as being U.S. Financial institutions, they know it's important that they maintain their ability to participate in the U.S. financial system. So they will bring the violative conduct to OFAC and then start the process of trying to resolve their past transgressions.
And I suppose you could take that to an extreme. If a foreign person has a briefcase full of cash, U.S. cash, and hands it to a blocked entity, somebody that has been designated by the United States and is on the SDN list, is that a violation, and how do you enforce that? And those are two key questions.
So I would also add that because of correspondent banking relationships, effectively the use of the US dollar in a non-cash manner attaches to the US dollar. And that's because because of correspondent banking relationships, there is a jurisdictional nexus with the use of the US dollar transiting through the United States. So US sanctions prohibit foreign parties, even when no US party is involved, from using the US dollar in a non-cash manner. Susan Emenegger has a good piece out in the recent book, Secondary Sanctions in International Law. It's called The Correlation Theory is the article. And so that's really helpful on this topic, I found.
Thank you so much. We have probably more questions than we have time. So maybe we'll group a few questions. I see the gentleman in the back has his hand.
The discussion has assumed that the institutional order remains in place. Are there any concerns that the realignment of who our allies are and who our adversaries are, which has been in the news lately with this current administration, what are your concerns, if there are any concerns?
Okay, so we have the question about realignment, and then Maya, did you want to?
Thank you. Recent statements trying to remove Russia as an aggressor from G7 statements on sanctions are now US government policy. Is that problematic for the legal basis for US sanctions on Russia, which are all premised on Russian aggression in Ukraine? And secondly, is there any thinking already in government? There must be, about what sanctions relief might look like. So what are the panel's guesses on parts of US sanctions on Iran that might be lifted, assuming there is some sort of deal to end the war?
We take, that does seem related, but do you want to take those and then we'll, okay.
So on the first question on realignment, I mean, I think that's obviously a major foreign policy question. I don't know, I don't have immediate thoughts on kind of how, other than a realignment in foreign policy is going to have implications for obviously the implementation of sanctions, but I don't have anything more tangible on that front. On Maya's questions, I haven't thought as much about your question on the G7 statement, but I mean, if you look at the executive order, I have to check if the executive order say aggression, but they wouldn't necessarily have to, right? They're not necessarily tied to the concept of an Article 2 violation. They're tied to the president declaring a national emergency with respect to a threat to U.S. national security. And so I'm shorthanding there a little bit, but I have to remind myself if the EOs actually say aggression, but there's not a necessary link between an Article 2 international law violation and the ability to maintain that there's a national emergency under US law for purposes of creating and sustaining the sanctions programs. On your question about sort of sanctions relief, I mean, your guess is as good as mine as to what the current administration is thinking. As a data point, you could look to, any of the other contexts in which the US has offered sanctions relief. I mean, Iran is one context. Venezuela is another, where there was a sort of staged process of offering certain sanctions concessions in exchange for progress towards democracy, which obviously did not work out as planned. But there was an effort to use sanctions as a way to encourage, particular steps, and it was staged. It was, there was not the entire program. It was, the U.S. government took certain actions to relieve pressure in certain areas, if that had worked, potentially would have considered more actions. So I think in the Russia context, one way to think about it would be that sort of staged, okay, for a ceasefire, we may be willing to encourage a ceasefire by offering certain concessions, and then for ongoing negotiations, there would be other concessions. I don't, whether he would take that approach or whether there'd be a different approach, I don't know. But I think in a sort of normal policymaking context, I would expect to see something that would be staged and tied to progress in a process that would inevitably be very complicated and difficult to get all the way through.
I suspect that's right. That it would be, if Russia do this, then this sanction or this group of sanctions will be relieved. The challenge is some of those are statutorily mandated, and so Congress will have to be involved to some extent. But I would expect that would be the kind of approach that they're thinking about.
Okay.
I agree. I think
Yeah.
that's all well said. I will just point out on the last point, there is going to have to be two parties to any type of deal. And so I think you might have great intentions on staging that, but Russia might not think it's worth the candle to do it. But there's a lot in place for that type of staged lifting of sanctions to be implemented.
Just one footnote on that too. I think as we watch the headlines, it's interesting. I think there's a real challenge ahead to see where Europe and the UK and other sanctioning jurisdictions go, because there's I guess some value in the US lifting, obviously, both symbolic and in other ways for Russia. But
Yep.
you know, if ideally there would be a coordinated approach to how they're taken off.
So with apologies to those who have more questions, and with deep thanks to our panelists, thank you. Please join me in thanking them for sharing their expertise.
Thank you all.
And I'm back. First of all, thank you to our incredible panel. Particularly shout out to Ed, who is joining us at 2 o'clock in the morning. So really lovely of everyone to make it here today. So here's the plan for lunch. The first thing that I would ask is lunch will be served in the room next door. You can enter through Soden Lounge or through the door that is facing the window wall right outside. One thing I would really ask is that if you are somebody who noted a food allergy or dietary restriction, please stick to that. And those who did not note that, please don't touch. So that said, I also want to note two other things. You know, it's hard for me to say this because I wanted everything to go perfectly. However, I hope our kosher guests can afford us some grace. There has been a delay in the delivery from Holy Schnitzel. So with that said, I'm so sorry, and it should be just a couple more minutes. Last thing, we plan to have our keynote address during this lunch. So I would encourage everybody to be sort of ready to go, having eaten by probably 1:10, because we are thrilled to be joined by Adar Levy, the former acting general counsel of the United States Treasury Department. She's phenomenal. You won't want to miss it. So I'll obviously be annoying outside and make announcements and tell everybody to get back in and sit down. But, you know, just bear that in mind when you get food. And again, please don't touch something that you have no business touching. All right. Thank you.
Thank you. Oh, wow. Particularly.
Oh, yeah.
love so younger than the sun. And the bonnie boat was one as we sail into the mystic.
If everyone could just take their seats, please. All right. So I'm thrilled to be introducing our keynote speaker for this symposium. Aside from being entirely lovely, Adar Levy served as the acting general counsel of the United States Department of Treasury until January 2025. In that role, she led the Treasury Legal Division and counseled the Treasury Secretary and other senior Treasury officials on a wide range of issues, including banking stability and banking regulatory issues, international economic affairs, investment security, terrorism finance, and tax policy. She played a leading role in the United States government's sanctions response to Russia's 2022 invasion of Ukraine, spearheading the ERA loan program, which closed a $50 billion G7 loan leveraging immobilized Russian sovereign assets for the benefit of Ukraine. Adar also led the team that established the Afghan Fund, a first-of-its-kind trust fund to preserve Afghan assets and promote Afghanistan's economic stability. Prior to joining Treasury, Adar was general counsel at the Obama Foundation and general counsel of President and Mrs. Obama's family office. She served as a member of the Executive Management Committee overseeing all legal and compliance functions. Earlier in her career, Adar served in the White House counsel's office and practiced at an international law firm based in Washington, D.C. She's a member of the American Law Institute. She earned her Bachelor of Arts degree from UCLA and her JD from Harvard Law School. Please welcome Adar Levy.
Good afternoon. Thank you for that lovely introduction and to Fordham Law School for hosting this important symposium. I left government a little over a month ago, which means that I had to write these remarks on an Amtrak napkin on the way up, but it also means that these views are truly my own. I'd also like to acknowledge that many of you here have written extensively about current practice in the sanction space. And as a government practitioner who often had to make decisions very quickly with imperfect information, I just want to acknowledge that to have this ongoing conversation with academics and others who think deeply about these issues is really important and matters. So thank you. I think it's fair to say, and as this morning's panels have shown, that this event comes at a critical moment for sanctions and economic statecraft tools more broadly. I'll focus on sanctions today, but many of the points I'll make can be extended or analogized to other tools of economic statecraft, including export controls, tariffs, foreign assistance and lending, and investment security. My basic message to you today will be that we're at an important inflection point for sanctions, geopolitically, economically, and legally. Economic statecraft tools today are being used pervasively across administrations, but they're also being used in increasingly novel and interconnected ways. They're being used against a backdrop of increased geopolitical conflict, increased pressure on the financial system to decentralize and de-dollarize, against growing judicial scrutiny of administrative action in the US, and a broader fraying belief in the established international order. And as the costs of using other tools and of armed conflict increase or remain high, I would submit that sanctions will remain in the sweet middle, optimizing impact and leverage against speed and political downside. These forces combined form the inflection point and mean that how we approach sanctions today and in the medium term will set important precedents that bear on foundational questions of executive power, international relations, foreign relations law, the functioning of the administrative state, and the structure and strength of global financial markets. I'll offer some thoughts today drawn primarily from my experience implementing these tools in the real world about how to think about the future of sanctions in a way that takes into account these different forces. In structuring these thoughts, I'll share some causes for optimism, a few areas of concern, and then some concrete proposals for reform for Congress and the executive branch to focus on. So first, on why I'm optimistic. Sanctions can accomplish incredible things that go way beyond freezing assets. As many of you know, sanctions in their modern form were pioneered by the Treasury Department's Office of Foreign Funds Control, which was OFAC's predecessor, in 1940, right after Germany invaded Norway and right before the beginning of World War II. So another inflection point for our country. Then as now, sanctions are a powerful tool. But today, fast forward 80 years, we know that they can be used in ways that go far beyond asset freezing to direct strategic transactions, establish new regulatory regimes, and even extract economic value from frozen assets. When I think of the power of sanctions, I think about a specific day in late December. On this day, I found myself sitting in a small conference room at the Treasury Department next to Janet Yellen. We were there for a ceremony set up to watch a transfer of $20 billion to the government of Ukraine, a transfer that had been negotiated by Secretary Yellen with the G7. Across the G7 around the same time, similar transfers were taking place for a total of $50 billion that were being transferred to Ukraine. This was known as the Extraordinary Revenue Acceleration Loan, or ERA loan, in which G7 countries provided a $50 billion loan to Ukraine that was to be repaid entirely by interest earned by sanctioned assets. So we were in this tiny ceremonial room because we were really excited to watch this transfer, which gives you a flavor of what passes for a party at the Treasury Department. But we were also there because this was an incredible achievement on the part of sanctions. A team of dozens across the US government and the G7 had come up with an innovative sanctions-based solution to a really hard problem, which was, how do you get a needle-moving amount of money to Ukraine without taking legal title to Russia's frozen assets, without action from the UN Security Council, without appropriations from Congress, and without increasing Ukraine's debt burden? To answer this question, we essentially leveraged frozen Russian assets located in the EU, which were throwing off about $5 billion of interest a year, and combined it with the liquidity of the entire G7 to pull forward future years of that interest earning and provide money to Ukraine today. Stated otherwise, the ERA loan demonstrated for the first time that sanctioned assets had a purpose beyond just being frozen. There was a way to extract present economic value from the sanctioned assets, in this case, for the benefit of Ukraine. And I'm very proud of the work that Treasury and state and other parts of the US government did on the ERA loans, which were truly government ingenuity at its very best. The ERA loan offers an important case study on the power of sanctions. And it offers a case study on how sanctions can be used to address the most intractable foreign policy problems. When you look at the way sanctions were used just in the time that I was in government, you can see the implementation of a wide range of foreign policy solutions, often in coordination with allied countries, that were targeted and nuanced enough to achieve foreign policy goals while balancing a difficult set of competing interests. So for example, sanctions tools were used to set a ceiling for the price at which Russia could sell its oil, regulate broad swaths of the US economy regarding transactions that risked revealing bulk data with sensitive US person information, prohibiting or requiring reporting of investment by US persons into certain foreign technologies, and laying the foundation for a transfer of Afghan assets subject to US-based litigation. A few things were notable about these policy solutions. First, these were all ultimately about leverage and about bringing bad actors to the table. For example, immobilizing $300 billion of Russian sovereign assets and extracting present-day economic value for Ukraine was and should continue to be an important negotiating tool. Second, these policies had to balance competing interests. So when you look at the Afghan fund, we were balancing the interest in preserving Afghan central bank reserves for the people of Afghanistan, one of the world's poorest countries, against the interests of victims of terrorism who had legitimate claims in court against the Taliban. Similarly, the oil price cap sought to limit Russia's revenues by capping the price at which it could sell its oil products, but minimize broader disruptions to the global oil markets. Third, all these solutions entailed extensive consultations with Congress and other impacted stakeholders throughout the sanctions design process, which helped avoid unforced errors or legal barriers being thrown in the path, and ensured that there was a tight fit between the measures being imposed and the national security emergency that had been declared. Finally, with the exception of Russian sovereign assets, which relied on European sanctions, these solutions, although very different from each other, all use the same legal authority, which is the IEEPA. IEEPA permits the executive to declare a national emergency, as we've heard already this morning, for any unusual or extraordinary threat to national security, foreign policy, or the economy of the United States, if the source of the threat is wholly or substantially outside the US. It's traditionally been thought of as a sanctions tool that results in asset freezes, but the declaration of a national emergency unlocks a really broad array of authorities the president can use to deal with the emergency, which I'll come back to a little later. Another separate reason I'm optimistic is the power of multilateralism. This is not a popular position anymore, but at the Treasury, we found that coordinating our actions with allied countries led to significantly larger impact. For example, when setting the price of oil for the Russian oil price cap, working together meant fewer alternative buyers for Russian oil and much more squeeze on Russian revenues. When executing the ERA loan, working together meant access to a base of $350 billion instead of just the $5 billion that were frozen in the US. It also meant the ability to send a strong, coordinated message, in this case to Putin, about a global coalition standing behind Ukraine. Given the increasingly global nature of threats, from Russia's aggression to fentanyl to cyber threats, I still believe that there are very few issues today where the United States going it alone will ultimately be more effective than forging alliances. I don't mean to suggest that multilateralism is costless or that unilateral action isn't at times the best path. In fact, I know firsthand that multilateralism requires US leadership and often significant compromise, both in substance and on timing. But in the long term, it magnifies the real-world economic and political impact of sanctions and enhances the credibility of US international leadership. So the successes of our recent sanctions actions provide reasons to view the sanctions glass as half full. But these efforts and others also highlight a few causes for concern, and I'll touch on just three. First, I would say, is the importance of coordination, both within the US government and with our allies and partners. From the US government perspective, I was struck by the practical challenges of there being no single Department of Economic Statecraft. Instead, these tools are spread across a wide range of agencies and equity holders, including Treasury, State, Commerce, DoD, DOJ, various White House components, including the National Security Council. Russian sovereign assets were a good example of a cross-functional issue with different owners, both within the US government and across different foreign systems. So sometimes when interacting with our foreign counterparts, we'd be talking to finance ministries and central banks, other times foreign ministries, and other times justice ministries. This seems like an obvious point, but at the most basic level, cross-functional issues require clear channels of communication, clear leads, and sometimes the creation of new lanes to get work done. Russian sovereign assets are not unique in this sense, and I would say many other emergent economic issues, you think of AI, payment systems, cybersecurity threats, have a similar cross-functional aspect. Another cause for potential concern is that in the sanctions space, and I know this was raised in the prior panel, the US's ability to lead turns in large part on the strength and primacy of the US dollar. The importance of interfacing with the US financial system, and conversely, the threat of being cut off, are important levers that we pull when we impose sanctions and when we encourage others to do so. Policies that have as their intent or effect weakening the US dollar or moving payments away from a centralized payment system may have benefits, but those benefits should be weighed carefully against the costs of potentially weakening these sanctions levers. To be clear, I'm not a de-dollarization alarmist, but increased use of sanctions and other tools in novel ways may provide impetus to countries pursuing de-dollarization, which then poses a threat to the efficacy of sanctions in the long term. Finally, I worry that IEEPA, while a powerful tool, is actually both too broad and too narrow in its current operation. We need a sanctions architecture that is fit to purpose and tools that, just like our adversaries and our threats, modernize and adapt. IEEPA is a 50-year-old statute with very few constraints on executive power. IEEPA was intended as an emergency power, but has become over time an everyday measure of first resort. Still primarily constrained, in my experience, by executive branch norms and a sort of internal to government common law. At the same time, the executive branch is leaning understandably increasingly heavily on this single statute to pursue a wide range of national security and foreign policy goals, which puts more and more pressure on these uncodified norms. As a statutory matter, IEEPA has very few formal checks on the president's power. Of course, the statute requires that an emergency be extraordinary, that it emanate from abroad, that it threaten some aspect of national security or foreign policy, but these have become largely pro forma requirements, both with respect to congressional and judicial oversight. When IEEPA was enacted, I was reading the House of Representatives report the other day, and it was interesting. It made clear that Congress intended for IEEPA emergencies to be, and I quote, rare and brief, and not to be equated with normal ongoing problems. Over the years, IEEPA emergencies have expanded to include non-geographically bound issue areas, issues where the national emergency was quite broadly interpreted. And I'm not making a partisan point. So for example, in 2015, President Obama issued an executive order declaring a national emergency with respect to Venezuela. And the Obama White House used that EO to impose sanctions on President Maduro and his regime. The way the EO signing was reported led to widespread public concern about this national emergency relating to Venezuela. And in response, the White House had to explain, and again, I'm quoting, that the United States does not believe that Venezuela poses a threat to our national security. This is just how we describe the process of naming sanctions. And there are 20 to 30 other sanctions programs we have. In a more recent example, in January, the current White House declared a national emergency with respect to energy production, broadly defined, and high gas prices. And in February, the White House used IEEPA for the first time to impose global tariffs on Mexico and Canada for their role in fentanyl trafficking, even though, at least in Canada's case, in 2024, only 19 kilograms of fentanyl were actually seized at the US-Canadian border. So there are ways in which IEEPA has been construed and is increasingly construed very broadly. But at the same time, IEEPA is also too narrow, I would submit, unduly limiting the president's authority to go after national security threats in their most modern incarnation. Last month, the Fifth Circuit held that US sanctions authorities could not sanction the use of a cryptocurrency mixer and its immutable smart contracts created by a group known as Tornado Cash. These smart contracts, which OFAC had sought to designate, were being used to support North Korea's drug and human trafficking activities and to evade US sanctions. The court in that case held that IEEPA just didn't reach the smart contracts because IEEPA permits the regulation of property. And immutable smart contracts and cryptocurrency mixers were not capable of being owned and therefore not subject to US sanctions. In its opinion, the court acknowledged the legitimacy of Treasury's concerns about illicit foreign actors laundering funds, but maintained that congressional action was necessary to fix the gap. Similarly, we should acknowledge that the so-called Berman Amendment to IEEPA, which is intended to constrain the president's ability to regulate certain types of information and informational materials, is outdated and has led to confused case law about the demarcation between Berman and the First Amendment. It also regulates materials such as microfiches and phonograph records, which I would guess half of you don't even know what those things are in this room. Berman, most importantly, ignores the realities of the way malign foreign actors today use information and data to threaten our national security. So I've just laid out a bunch of problems. What do we actually do about it? Over the years, there have been a large number of proposals to either narrow or expand IEEPA. And my thesis is that we actually need both. And the most important reforms that I would focus on fall in three buckets. The first is increasing oversight of the declaration of the national emergency, making it more difficult to unlock the IEEPA toolbox while not limiting the toolbox itself in cases of real emergency. The second is clarifying IEEPA's domain as a tool to be used against foreign policy threats, not foreign persons for foreign policy threats. And the third category is modernizing IEEPA to make sure it can go after the threats of today, which includes reforming Berman and some of the issues with scope that came up in the Tornado Cash case. So on the first bucket of reforms, they would involve strengthening congressional oversight of never-ending emergencies and emergencies that are tied to normal ongoing problems. And I would say focusing congressional energy at the national emergency stage rather than on targeting or on back-end reporting, as some proposals seek to do, would strike the appropriate balance between ensuring that an emergency tool isn't overused while preserving its full power and executive prerogative when a real emergency exists. Congress should also clarify that IEEPA must be used to address truly foreign threats and stipulate if and how IEEPA can be used to supplant other tools, such as trade remedies and tariff imposition tools. This is particularly important now because other trade tools often have more procedural protections and administrative requirements that require the executive branch to go through a regulatory process in order to impose measures. As those processes become increasingly burdensome and subject to litigation in the wake of Loper-Bright and related cases, I would think it's very likely that IEEPA becomes an even more appealing alternative, and the need to clarify its sphere of influence becomes even more important. In addition, Congress should address the direct use of action against US persons, which raises a separate set of constitutional concerns, but as a statutory matter, the text of IEEPA does not directly limit these actions today against US persons. As a matter of practice, it is unusual but not unheard of for the US government to sanction US persons, but IEEPA could be used to sanction broad swaths of US persons, which would have the effect of imposing severe punishment on Americans, such as causing banks and other institutions to disassociate with the person and making financial transactions in day-to-day life extremely difficult. For these reasons, it's important to provide more clarity around when this powerful tool can be used and who it can be used against. Finally, legislative amendments to clarify IEEPA's ability to go after the tools that illicit actors actually use today could be relatively surgical. They would avoid tying the executive hand when it comes to threats like malicious cyber-enabled activities and cryptocurrency mixers, but would leave important First Amendment protections in place. These concerns about getting the scope of IEEPA right are not academic. When I was in government, we were able to use IEPA to achieve foreign policy objectives, but it's fair to say that the intersection of national security issues and administrative law is very much in flux. The basic reaction to Loper-Bright, the recent Supreme Court decision overturning Chevron deference, is that courts will likely continue to show significant deference to executive branch determinations in the national security space. I tend to think that optimism is somewhat rosy, particularly with respect to economic statecraft policies that look more like domestic regulation or place a significant burden on US persons rather than discrete, traditional foreign policy actions. To that end, Congress would do well to focus on proposals in this space that seek to modernize or expand IEPA to meet today's needs. I'd like to end where I started by emphasizing the importance of the moment we're in and the long tail of any precedent we set or decline to set at this time, and suggest that this inflection point is the time to take stock of the toolkit we have as we enter the next phase. When I was in that conference room with Janet Yellen in December, the best part happened right at the end. The Treasury employee executing the transfer entered a 20 and then 9 additional zeros, filled out a few more pieces of information, and then with everyone leaning forward, the photographer and the confetti poppers ready, he hit the transfer button. Then a fraud prevention screen popped up. Warning, high dollar transaction. Are you sure you want to proceed? It was, and we did. Thank you very much.
Thank you, Adar, for that wonderful address. At this time, we are going to, have another short break. And if you guys need to, grab some more coffee, etc., go for it. Our next panel starts at 2:00 p.m. So be back by then.
and.
All right, if everybody could take their seats, please. So welcome to our third panel, and also my third comedy act of the day. The third panel features Professor Harlan Cohen as the moderator. Harlan Cohen is a professor of law at Fordham, us. His teaching and research focuses on international law, international trade, international legal theory, global governance, and U.S. foreign relations law. He's a member of the board of editors of the American Journal of International Law and a member of the American Law Institute. Prior to joining the faculty at Fordham, Professor Cohen was the Gabriel Wilner UGA Foundation Professor of International Law at the University of Georgia School of Law and faculty co-director of the Dean Rusk International Law Center. At the University of Georgia, Professor Cohen was also an affiliated faculty member in the Department of International Affairs. Professor Cohen came to Georgia from New York University School of Law, where he was a Furman Fellow. Prior to that, he worked at Cleary, Gottlieb, Steen, and Hamilton and served as a judicial clerk for Judge Wilfred Feinberg of the United States Court of Appeals for the Second Circuit. Before entering law school, Professor Cohen worked at the Washington Institute for Near East Policy and the Journal of Foreign Affairs. On our panel, we are pleased to have Dr. Joshua Andreessen. He is an associate professor of national security and foreign relations law at the University of Surrey Law School in the United Kingdom. He is an international lawyer working in national security and human rights law. His areas of expertise range from the law of armed conflict and international human rights law to anti-money laundering and countering the financing of terrorism, including sanctions compliance and the regulation of cryptocurrencies and exchanges. He has been called upon to advise states, provide expert opinions for international tribunals, and contribute to the work of the UN Special Rapporteurs. Prior to joining the faculty at Surrey Law School, Dr. Andreessen was a senior policy advisor for Europe, Russia, and Central Asia at the Office of Terrorist Financing and the Financial Crimes at the United States Department of Treasury. He was also an attorney advisor at the United States Department of State, where he worked in the Office of the Legal Advisor for African and Near Eastern Affairs and in the Office of Legal Advisor for the United Nations. Professor Zora Ahmed is a Fordham graduate, and we are very proud, is an associate professor of law at the Boston University School of Law. She writes and teaches about the United States carceral state and United States militarism. She examines how law and political economy shape the distribution of state violence, and she studies the social movements that have risen up to challenge criminalization and militarization. She started her legal career as a public defender at the Legal Aid Society in New York City. While working in criminal court, she also co-founded a community court watching project. She has represented individuals on death row in Tanzania and in the United States and collaborated with groups in both countries challenging life and death sentences, focusing on cases of incarcerated survivors of gender-based violence. She also oversaw the United Nations advocacy of the only human rights organization in the occupied Syrian Golan. She is an advisor to the Community Justice Exchange, the home of the National Bail Fund Network, where she supports grassroots social movements challenging criminalization. And did I note that she's an alum? And last but not least, we have Dr. Alexandra Hofer. I think I said that right. Joining us. She is an assistant professor of international law, international and European law at Utrecht University in the Netherlands. She's a member of the Utrecht Center for Regulation and Enforcement in Europe. She received her PhD in international law from Ghent University and remains a member of the Ghent Roland Jacquemin International Law Institute. And I know I've said that wrong, but we don't need to go over that. She first completed a master's degree in international relations in peace, conflict, and security studies at Université Libre de Bruxelles. I don't know if I did that right. I apologize. I said it was a comedy hour. She frequently conducts interdisciplinary research combining both international relations and international law. And her research interests include the law of international responsibility, sanctions, the use of force, principles of non-intervention, peaceful settlement of disputes, integrating international relations and international law to address common issues, such as the utility of coercive practices, stigmatization, and international punishment in enforcing international norms, and the hierarchy in interstate relations and its impact on international law. And with that, thank you for putting up with me, and please welcome our third panel. Again, you know what? By the end of this, I might get the hang of it. I am going to now display and read the CLE code for this panel. And the code is F A S 25. I read it slowly. All right, here's our third panel.
Thank you, Kaylee. I really appreciate the fact that you keep introducing these panels because it gives each of us an opportunity to thank you once again for all the work that you have put into making this happen. Welcome everyone to Fordham Law. Thank you again to the Fordham International Law Journal for pulling this together. Thank you to all of you for coming today. I mean, the extraordinary group of people we have, not just on our panels, but in this room, it is quite a brain trust. And I hope that we all take advantage of the opportunity to learn from each other on all of these issues. It really is. It's been amazing for me. I hope you're all having the same experience. Now, this panel is on foreseen and unforeseen consequences. But one of the things I think we've all been learning over the course of this day, going back to the very first panel, is that thinking about sanction gives us an opportunity to actually get some traction, thinking about the impacts, effects, abuses of economic coercive tools generally, right? This gives us an opportunity to really think about why, when and why the use of economic pressure and pain is justifiable or justified. Our panelists are going to talk about a wide range of different kinds of impacts, some unforeseen, some long noted but underappreciated, some intentional but perhaps ignored. And at the same time, focusing on sanctions, I think you will see, allows us to highlight the moral and ethical questions that are often obscured by the tacit comparison, as you've been hearing all day, of economic coercive tools with more military ones. I think all of our panelists we have today are really well situated to help us to think these kinds of things through. We're going to start with Alexandra and then move on to Josh and then to Zora. This will allow us, I think, to kind of build on each other, but also to kind of slowly expand our horizons as we start to think about what are the actual effects of economic sanctions and economic coercion more generally, and how should we be thinking about how to approach this, something that we will begin to talk about, but then will be continued in the next panel as well. So without further ado, Alexandra.
Okay, thank you very much. Of course, I would really like to extend my gratitude to Keely for everything she's done to put this great event together, and also to Fordham Law School for reaching out and inviting me. I really appreciate the fact that you took the trouble to fly me over from the Netherlands to the US. I have to say this is my first interaction with the US Law School, so it's also really nice experience. So perhaps what Harlan has already said, or perhaps implied, but I think now we're going to take a more critical approach to the use of unilateral sanctions. And as I say this, so like as Keely mentioned, I have a background in international relations, but I got, pulled into international law. And I'm always interested in what is the goal of a certain policy? How is it justified in legal language? What is the normative objective? And then how does that transfer in practice? And very often sanctions are justified as a normative moral tool. If we think about the language that sanctioners use, it's very often, against bad actors, our adversaries, enforce norms, our values, so on and so forth. right? So sanctions very much enable actors, whether we're talking about the US, the EU, their allies, to frame themselves as normative actors. We're upholding norms. Okay, that's my starting point. And then there's the other question of, well, what is a sanction? I think what came up in the first panel and also what Nick Mulder discusses in his book is, well, sanctions, especially after the First War, when we wanted to, create the League of Nations, we needed a deterrent. And so, well, thought, well, why not have a tool such as sanctions? And so sanctions there was this kind of semantic shift where sanctions or embargoes were conceived of as a tool of warfare to actually know it's a peacetime tool. So I kind of find that interesting how we conceptualized it as a peacetime tool, kind of suggesting like this isn't a tool of warfare, suggesting, well, it's more humane, it's less violent. But all that is just about language and framing, because how does a sanction actually work? For the local population, sanctions are actually quite destructive. So that's what I'm going to discuss is the structural violence of sanctions. And what does that mean for, actors who wish to be normative? I should probably be, it's important to be specific when we're in law. So what kind of sanctions am I talking about? Sectoral sanctions, so sanctions that are directed against a specific sector of a state's economy or an important financial sector. These are the ones I'm concerned with, and I'm more concerned with unilateral sanctions adopted unilaterally by the US, which we've heard a lot about, but especially thinking about the EU. I've had interactions with, European officials, especially with the Dutch Ministry of Foreign Affairs, and I'm really struck by how they think about these things in the sense that they don't really. And why am I saying? Because I was invited to an event, just anecdotal, and it was, co-organized between a think tank and the Dutch Ministry of Foreign Affairs, and I was put on the last panel to talk about the human costs of sanctions, the unintended consequences of sanctions. And so I'm at the last panel, so I'm sitting there during the day, and I was really struck by the first panel was talking about, well, the costs of sanctions against Russia, are sanctions working? And the whole rhetoric or the whole justification, of course, we can always talk about what's the purpose of sanctions, so on and so forth. But in that first panel, it was, well, we want to use sanctions to cripple the Russian economy, to prevent Russia from being able to finance the war, so on and so forth. So we're really, treating the entire Russian economy as a target. And how do we know they're working? There's all this concern in Europe whether or not the sanctions against Russia are working. But don't worry, they're working because inflation is going up. And before you know it, the ruble is going to collapse, so on and so forth. That's the goal. That's what they're looking for. That's their metric to see if the sanctions are working. And then I'm supposed to say that the humanitarian consequences of sanctions are unintended. Because, of course, if there's inflation that goes up, if the economy crumbles, so on and so forth, who are the ones that are going to feel that impact? The civilian population that has less resources available to it in order to protect or shield itself from sanctions. And that's not a new argument, a new issue. We knew about this issue. So whether it's foreseen, unforeseen, I think that it's sufficiently documented that it's kind of predictable. So that's why there's this discrepancy between, okay, we want to impose maximum costs, whatever your foreign policy objective is, sure, but then you cloak it in this normative language that just doesn't add up. So that's kind of this discrepancy that I'm raising today and saying, okay, so it's not only about the human costs of sanctions on the target, but also how does that reflect on the sanctioner? And maybe you have normative objectives, but is, the pursuit of more humanity coming at the cost of your humanity? So it's kind of like this more kind of circular reflection, broader reflection that I want to bring. Now, Russia is perhaps a very difficult country to sanction, given its position in the global economy, also because it's more easily able to turn towards other actors and engage in trade. So Russia, even though there have been some shocks, is able, I think, to more or less buffer itself from the impact of unilateral sanctions. But that's not necessarily the case of a country such as Syria, which has been under extremely stringent sanctions regimes since at least, well, it started in 2012, and then it was just amplified, especially when there was the Caesar Act that was imposed by the US. At the time in 2014, the EU had adopted its most unprecedented sanctions package against any, foreign state, with commentators such as Erica Moret saying, well, basically, this is the recomprehensivization of sanctions. So, okay, supposedly these sectoral sanctions are targeted because we're not targeting we're not in placing a total embargo on the country, but at the end of the day, you have so many sectoral sanctions that are loaded against the country that it amounts to a comprehensive regime. And so all that to say is, I think if you read reports on the impact of sanctions on the Syrian population, I mean, and also it's always complicated to talk about causation because of course Syria went through an internal conflict which had huge consequences on the standards of living. But sanctions didn't help the population recover from that conflict. Of course, after everything that happened, reconstruction was really important. Well, they couldn't import concrete in order to simply reconstruct. There was huge issues of food security. People were not able to have medicine. You couldn't import baby formula. So living for some Syrians, and this is based on interviews that a colleague of mine conducted in Utrecht, living under sanctions was worse than living under war. And now, so the whole rationale behind imposing the sanctions against Syria was, well, we want to respond to the brutality of Assad's regime. But it turned out that the population no longer had to, deal with the regime, the war, they also then had to deal with sanctions. So from the population's perspective, it didn't really make a difference, where the hardship was coming from. And now what's interesting is there's this reluctance, Assad is gone, so you could say, okay, there's no more reason to have these sanctions in place. But then the EU decision is like, okay, sure, we'll eventually consider lifting the sanctions if certain conditions are met by the new government, but they're very vague about what those conditions should be. So it's almost as if, there's this reluctance to release the screws that have been imposed on the Syrian society. And Syria is one example, but there's other, reports that come out of the impact of sanctions on Venezuela, on Afghanistan. Very insightful research has been done on Iran, a book entitled How Sanctions Work. And it was this sociological, political study of, how sanctions have affected Iranian society. So all these consequences, if we allowed, I think we should reframe sanctions essentially as a form of structural economic violence. So structural violence, interestingly, is a term that was coined by Johan Galtung. And I say interestingly because Johan Galtung had this important critique in international relations about, the naive theory of sanctions. And so what does he say about structural violence? It's essentially emerges from policies that lead to an avoidable harm. So for example, if you're preventing somebody from having access to medication, when all you have to do is kind of change your policy, make it perhaps easier to have a humanitarian exemption or a general license, because that should be noted is, okay, these regimes include humanitarian exemptions for, essential goods. But if you talk to anybody who's in an NGO or civil society, it's incredibly, incredibly difficult to get these licenses. So there's an effectiveness issue with these humanitarian exceptions. It's also, structural violence also leads to a reduction of potential. So if you think of the fact that, there's a whole population that doesn't have access to education anymore, you have the lost generation, let's say. And importantly, also an unequal distribution of resources. Which also emerges, if you have sanctions and then, there's, not everybody has the same access to food, same access to, economic resources, so on and so forth. All these things can basically lead to increased poverty, social exclusion, and economic inequality. Now, what's important to know is that structural violence doesn't need to be intentional. But it is maintained through unequal power relations. And that's also something to note, how sanctions are used. It's very often when we talk about it. If you're able to sanction, it's because you have the power to do so. So it's tools that are often used by more powerful states against weaker ones, although perhaps, Russia is a bit of an exception there. So essentially, if you see the consequences that sanctions have, I think it puts sanctioners in a difficult position. And oftentimes they'll either say, well, no, we have, the humanitarian exceptions, the general license, already, issues with that. And then also one thing that should be noted is like, well, it's not us, it's the companies, the private actors that are over complying or that are de-risking. So this is an issue. There's so many, if you think about Russia or Syria, it's so complicated for private actors to know what transactions are allowed and which ones are not allowed that they prefer to not engage with those transactions at all. And so that is why, some practitioners are generous, I would say, and say, well, this humanitarian impact is unintended because it's because of the private actors that are over complying. But the thing is, the EU, for example, doesn't provide sufficient guidance or clarity in order for us to no longer have this issue of overcompliance and de-risking. The EU, releases these FAQs on how to properly implement restrictive measures, but still they're very complicated to navigate in order to know, well, what's allowed, what's not allowed, and not everybody's versed in how to deal with sanctions. So I think it's not such an easy, straightforward exercise, and there's more that can be done, at least from the EU side, in order to provide more transparency. Another thing I think is interesting to note is that if you read some work, well, I think Richard Nephew, I don't know, you might know his book, The Art of Sanctions, or Agathe de Marais, who wrote the book Backfire. So they're sanctions practitioners kind of explaining, in the case of Richard Nephew, is how sanctions are supposed to work. And Agathe de Marais is like, well, how sanctions are implemented and how they kind of might restructure the world against US interests. But they both point out the fact that, okay, sure, humanitarian impact of sanctions is unpopular, right? It's not really good for PR purposes, but they say to the extent that you want to impose costs on a jurisdiction, well, you're going to have a humanitarian impact. So for their perspective is, well, the humanitarian consequences of sanctions is demonstrative of the fact that the sanctions are working. And okay, you can include your humanitarian exemptions, but you're kind of reluctant to do so because it means you're not imposing the type of cost that you want to impose. So again, it's the question of, is this really an unintended consequence or is it a desirable one? And what does that mean as sanctions, as, whether you want to talk about them as foreign policy tools or global governance tools. So I'll just briefly on maybe two final points, is some people might say, okay, well, the types of human rights, sanctioners don't have human rights obligations, extraterritorial human rights obligations. So that's something they sometimes invoke, will often invoke in order to say, well, we're not responsible for any potential human rights violations. That's a whole debate in and of itself. But from what I'm talking about is like, it's not even an issue of what are your actual legal responsibilities. It's more a question of, well, what is your legitimacy? What kind of legitimacy are you giving yourself as a normative actor? And so if you're going to say, well, I don't have these type of obligations, so therefore, I'm kind of off the hook, from legitimacy perspective, it doesn't really matter. It's more like you shouldn't really be a hypocrite. If you want to improve human rights standards, well, you shouldn't adopt policies that make those worse. And then the final point is like, okay, but the type of human rights you're talking about are about social and economic rights, and we're seeking to defend civil and political rights. And I think that if you see how sanctions actually affect civil society, or, a society in reality, is like, you can't really neatly separate one from the other. So you see in the case of Iran, in the book I mentioned, how sanctions worked, it's essentially how sanctions against Iran stifled political activism and enabled the state to become more securitized and more militarized. And also people, they had less resources, so it was less easy for them to, mobilize, to organize themselves, so on and so forth. So it's also taken into account, okay, we want to know, are sanctions working? Do we have the costs going on, so on and so forth? But we don't sufficiently measure, well, what are the long-term consequences of our actions? So I think that that's kind of my plea to people who work in this area. It's like, well, okay, it's all good and well to know who's complying. If you're not complying, how are they being implemented? But also like who really is being impacted by your sanctions and what kind of, mediums are you giving them to be more relief from this beyond these humanitarian exemptions or these licenses that, are very difficult to implement in practice. So thank you very much.
Thanks so much, Alexandra. I think you've laid out some really powerful questions that we'll continue to think through over the course of this panel.
All right, well, thanks so much to Kaylee and to all the organizers for this great conference. It's real pleasure and honor to be with such great panelists and audience in general. So my presentation today, at least the working title, is Targeting Speech, the Myths and Unintended Use of U.S. Sanctions. I guess I'm hesitating a little bit because, of the power of Alexandra's presentation just now. And I'm going to focus on just kind of a very narrow effect of sanctions around speech. And primarily for U.S. actors, but I think it leads into some of the repercussions that Alexandra was also touching on. So basically, taking up a suggestion that Ben Heath gave us this morning to talk about the speech implications of sanctions. So the core argument in any case is that U.S. sanctions directly or indirectly restrict speech that should be protected both by statute and the First Amendment of the U.S. Constitution, and chill a great deal more speech. And this is alarming, I think, if for no other reason than sanctions weren't designed in the first instance to restrict speech. Their aim is rather to apply economic pressure in the service of foreign and security goals. So I'm going to go also back to the House Committee report, which is quite rich. The House Committee that drafted IEPA, that we're now fairly familiar with, stated that the scope of the authorities should be clearly limited to the regulation of international economic transactions. And that committee was concerned to make sure that IEPA did not include the authority to control non-economic aspects of international intercourse, such as personal communication or humanitarian contributions. And indeed, most of our sanctions regimes explicitly state this in some form or another. So for example, from the Iranian transaction and sanctions regulations, the prohibitions contained in this part do not apply to any postal, telegraphic, telephonic, or other personal communication, and does not involve the transfer of anything of value. So this exception is baked into most sanctions regulations, but they are conspicuously absent from terrorism sanctions, which do not contain these exceptions. And indeed, OFAC's frequently asked questions state that certain exemptions under IEPA relating to personal communication or humanitarian donations do not apply to transactions involving persons designated under terrorism authorities. And it's sort of a mystery. Okay, so why not? And OFAC doesn't actually tell you why that's not the case. Well, how is it that it could bypass these IEPA speech protections in terrorism sanctions? Well, that's because these terrorism sanctions have been promulgated pursuant not just to IEPA, but through another statutory authorization, which is the UN Participation Act, or the UNPA. We want to sing a little song. Where the UNPA, the UN Participation Act, allows the president, when enforcing a UN Security Council resolution, to regulate or prohibit in whole or in part postal, telegraphic, radio, and other means of communication between anyone from the US and anyone from a foreign jurisdiction. Now, in reality, it's more than debatable whether compliance with any of the relevant UN Security Council resolutions actually require the suppression of speech. And some of the relevant Security Council resolutions seem to suggest precisely the opposite. That is, that their implementation should be done consistently with human rights law and in a manner that does not unduly burden humanitarian actors. But even if one of these Security Council resolutions required the suppression of speech, and the UNPA allowed for that in some way or another, I think it's certainly the case that neither one of these would circumvent protections in the First Amendment of the US Constitution. But as we'll see, where exactly the First Amendment comes down in this domain is still unclear. All right, so that's Security Council, that's sanctions regulations on the one hand coming through IEPA and perhaps also from the UN Participation Act. Running in parallel to that regime is the Material Support Statute, right, which adds an additional source of restrictions on speech and association, at least insofar as it restricts training and expert advice and assistance to designated terrorist organizations. And although for the greater part of the existence of the Material Support Statute, the statute and OFAC sanctions have been running more or less in sync when it comes to the restrictions they impose in the terrorism context, since December 2022, so a little more than 2 years now, OFAC has accepted a significant body of training and expert advice and assistance, particularly for things like democracy building, education, peace building, and conflict resolution, that are specifically captured by or restricted under the material support statute. So why does all this matter? I suggest there are at least two broad answers to this question. I mean, first, free speech and association rights have been undercut in the name of national security, particularly since the landmark case of Holder v. Humanitarian Law Project in 2010, which was decided under the material support statute. And this means that our basic rights under the First Amendment have been curtailed after a very long period of progressive augmentation. But this, I don't think, is just an abstract concern, which brings us to our second set of reasons we might give. In many of the most fraught places on the globe, like Syria or Gaza or Yemen, peace building and a whole range of other humanitarian activity is simply not possible without engaging prescribed groups. And perhaps more concretely still, and Alexander touched on this, if organizations negotiating or giving advice to prescribed groups, if that constitutes material support, then banks and other financial institutions are not going to want to touch those NGOs. And most simply, most concretely, if the NGOs can't pay their staff, then they can't do their work, and none of this vitally important work gets done. So these speech restrictions generate, I think, a cascade of negative effects. So how did we get here? And why, perhaps, or where were we before? Well, I already mentioned the speech interest that Congress took itself to be protecting under IEPA, essentially in 1977 when it created IEPA and amended the Trading with the Enemy Act. It set out to protect the First Amendment rights as were defined, as they took them to be defined by the Supreme Court of the United States. So what did the First Amendment actually look like then? Well, before the Humanitarian Law Project case, there were a couple essential principles that were protected. I mean, first, that the advocacy of lawful activity was almost always protected, with the exception of time, place, or manner restrictions. But you could always advocate lawful stuff. Even the advocacy of unlawful activity was protected, so long as there was no specific intent to incite imminent unlawful activity and an actual tendency to do so. And with respect to association with groups that engaged in both lawful and unlawful activity, as many prescribed terrorist groups in fact do, that was protected as long as the person engaging with that group didn't intend to further the unlawful aims of that group. Perhaps most critically, these protections were articulated by the Supreme Court specifically in the face of government arguments that association with such groups, like the Communist Party that advocated the violent overthrow of the US government, would contribute to their unlawful aims, right? So the government had argued that active support of any kind, even for lawful purposes, would aid the organization in achieving its own illegal ends. But at least by 1961, in the Scales versus United States case, the Supreme Court had rejected that principle and said that you can associate with these groups so long as you do not intend to further their unlawful aims. The Humanitarian Law Project case in 2010 changed all of this. Right? It stood these long-standing precedents on their head. In that case, a set of NGOs sought to provide training to two designated foreign terrorist organizations, the Kurdistan Workers' Party, or PKK, and the Liberation Tigers of Tamil Eelam. And they sought to teach these groups how to use humanitarian and international law for, amongst other things, for peaceful dispute resolution. When the material support statute was enacted, they ceased their activity and brought suit to challenge it. They brought suit under both the Fifth and First Amendment, but only the First Amendment challenge really gained a great deal of traction. Finally, and it was a 12-year-long lawsuit that went through many, many phases. But when it finally reached the court, the Supreme Court agreed with plaintiffs that the material support statute was, in fact, a content-based restriction on speech, warranting strict scrutiny insofar as it restricted expert advice or training. But contrary to the plaintiff's argument, the court found that only a narrow category of speech was in fact prohibited, and thus the statute was sufficiently narrowly tailored. The court then examined the government arguments to see whether they had met their burden to justify the prescription. And here the court crucially accepted, practically wholesale, the government's argument that all support to terrorist organizations is fungible and will redound to their benefit of their unlawful activities. And they found that this was true even for things like training for peaceful dispute resolution. So this fungibility argument that I think makes sense when if you give money, if you donate money to a prescribed organization for their humanitarian work, okay, well that then relieves some money that they would have to spend on terrorist activity, right? That makes sense, but how exactly does training in peaceful dispute resolution enable them to do more terrorist activity? That's not clear. It sounds like it's a burden on that organization rather than something that they can use for their nefarious ends. But in any case, the upshot of the Humanitarian Law Project case was that even the advocacy of lawful activity was not protected by the First Amendment if it was done with designated terrorist organizations. So although the Humanitarian Law Project case greatly weakened, and I suggest overturned longstanding First Amendment precedent, it appeared to leave untouched pure political speech, as well as the advocacy that was not coordinated with designated groups. But recent action, both by OFAC, the government, and Congress, have all reached into this pure political speech space, and I want to just talk through a few short examples of that here. So one instance which has come up already today involves an NGO that I happen to work with, the Foundation for Global Political Exchange. The organization organizes political dialogues throughout the Middle East and North Africa. In 2022, we were organizing our 21st Beirut Exchange, which was to take place in Beirut, Lebanon. And we sought to include 5 speakers who were designated under various different, or 3 of which I should say were designated under various different sanctions regulations, and 2 of which were members of Hezbollah, which is a designated terrorist organization. So one of whom was a member of parliament and the other was their international relations lead. We wrote OFAC stating that we didn't believe we needed a license to organize political dialogue with these individuals and that it was protected both by statute, namely the Berman Amendment and the First Amendment of the Constitution. And we sought assurances from OFAC that we were correct, that we could go ahead. And the alternative, we said, if you don't think we're correct, could you please give us a specific license to go ahead and conduct these political dialogues? Some 9 months later, after we submitted our application, I think, and this timeline is important, as we'll see, OFAC responded that our activity constituted a prohibited service by giving designated individuals a platform from which to speak, and that it was contrary to their licensing policy to give us a license. Okay. So having worked very closely with OFAC and having also followed the Humanitarian Law Project judgment closely, this was, to me at least, quite a surprising outcome. OFAC had gone far beyond what had been recognized as legitimate prohibitions in the Humanitarian Law Project case, and in our instance had prohibited political dialogue, or what seemed to us to be pure political speech. So we brought a legal challenge together with great people from the Knight Institute up the street, and almost immediately the government backed down and sought to settle the case with us. They didn't want to defend the position that they had staked out. And eventually in November 2024, so just a couple of months ago, we did receive a favorable outcome. OFAC admitted in writing that organizing political dialogue was not a service prohibited by US sanctions, and thus no license was required. But although we did eventually win a favorable outcome, I want to highlight at least 2 aspects of our experience. First, it took us nearly 3 years to reach that favorable outcome, during which time we had to limit our operations, cease organizing political dialogue with designated individuals, and thus suffer a curtailment of our rights. Secondly, OFAC's licensing process, although extremely time-consuming, simply didn't work. Right? It returned a position that OFAC itself was not actually prepared to defend, which they only admitted when we pressed them with a legal challenge. And I think this demonstrates at least some tendency to try to restrict more speech in the name of national security than they could in fact justify. Another example that calls into question the safety valve of OFAC's licensing involves the sanctions that have just been reinstated against the ICC, the International Criminal Court. Right. So 5 years ago, when plaintiffs challenged the ICC sanctions, so these are various law professors and one organization that regularly work with the ICC, they won a preliminary injunction in the Southern District here against enforcement of that regime against those individuals. The government, however, had argued that plaintiffs need not worry about these sanctions being enforced against them because they were not, in fact, as broad as they appeared. Right? Although the language of the sanctions regimes then as now suggested that any activity in support of the Office of the Prosecutor, such as educational workshops, amicus briefs, or student clinical work was prohibited, OFAC insisted that only direct transactions with the prosecutor were prohibited. They further suggested that any doubt could be clarified through the licensing process, but as we've just seen, this process can take the better part of a year and even then not function to recognize protected speech. So one of the upshots of this, for me at least, is that the OFAC licensing in its current form is hardly an adequate safety valve. Finally, I want to mention one other fairly alarming development, and this is House Resolution 9495, which recently passed the House of Representatives and would bring the material support statute squarely into Treasury's orbit for the first time. If HR 9495 were to become law, it would grant the Treasury Secretary the unilateral authority to designate NGOs as terrorist supporting and thereby strip their tax-exempt status, putting many of them out of business. Right? Under the terms of the bill, the Treasury Secretary would apply the definition of material support from the material support statute in making these terrorist supporting determinations. And amongst the many possible problems with this, as I've mentioned earlier, there's a direct conflict between the carve-outs from December 2022 and what the material support statute would restrict. So this means that the Secretary of the Treasury could effectively take back with one hand what it was giving with the other, making it particularly susceptible to discriminatory enforcement. So in conclusion, and I just have a minute left, I want to just make a suggestion for a couple, I think, relatively low cost but substantial reforms that the government and OFAC in particular could undertake. I mean, first, very simply and importantly, OFAC could amend the material support statute, requiring specific intent to further the unlawful aims of a terrorist organization, which is that requirement of specific intent is already required. And the other half of the material support statute, when there's specific intent to further a crime, I think it should be there with the terrorist organizations as well. With respect to OFAC, I think it would be fantastic if they were to develop a fast-track system for sanctions applications that involve free speech and association rights, or maybe First Amendment rights across the board. If, say, OFAC could just commit to returning a license answer within 3 months rather than 9 or 10 months or a year, that would have the effect of making that licensing process a real safety valve and also would, I think, chill far less speech than it currently does. Finally, with respect to HR 9495, I think we just need to keep pressing to make sure this bill doesn't pass. Over 350 charitable organizations have already organized to defeat a first version of the bill, and I think we need to continue that in the version that we presently have. So thanks so much.
Thanks so much, Josh. I think we all appreciate having the spotlight now on these issues.
Yeah, so I'll just reiterate my thanks to the symposium planners and really to Harlan for also convening, I think, again and again, kind of really rich research agenda for all of us to try to contribute to on economic coercion. So I'm really delighted to be here. That said, I am the odd person out on this panel because I don't write about sanctions, but I was told that I should still speak. So here I am. What I do think about is sort of the blunter end of the coercive spectrum. I think about where the lines start to blur between market compulsion and state aggression. I really think about the carrots of statecraft as opposed to the sticks, or sometimes when the carrots become so irresistible, so necessary that eventually their withdrawal can in fact be a stick. And my work emerges out of trying to understand how the United States put in place the essential elements for its counterterrorism strategy after 9/11 with military bases and with drone strikes. And that led me to sort of investigate the conditions under which states grant consent for drone strikes, for example. And in perhaps one of the most extraordinary kind of case studies that I
developed is in Pakistan, where quite literally the arrangement was debt for drones. But I think there are other more opaque and perhaps more complicated scenarios that I remain interested in thinking about. And of course, this is nothing new. As others have gestured towards, we all know the Nicaragua case as a prohibition against intervention or against the use of force. But of course, the backdrop of the intervention in Nicaragua was a capital strike orchestrated by the United States against with multilateral banks and investors not to invest in Nicaragua. So of course you have both the reward piece of with sovereign lending, and then you have the punishment piece. Sort of these forces of these kinds of pressures have mostly escaped the attention of Western legal institutions. Although advocates for a new international economic order from the global South, like Mohammed Bejawi, pushed that economic coercion be the basis for vitiating treatises, we don't have a firm or robust prohibition against economic coercion, which is why we're here. And the best, most ambitious proposal is the 1970 Friendly Relations Declaration. But generally, that proposal has been sidelined in importance. Of course, there's been sort of a real reversal in fortunes. And as a result, the West and Western scholars and Western institutions are interested, as Harlan's work has sort of traced kind of the political economy of that intellectual interest. There's sort of revitalized interest in paying attention to economic coercion, in particular because China has emerged as a critical piece of the global financial safety net. And so there's a concern in particular, and the concern that I want to focus on is on Chinese debt trap diplomacy, a concern that China is lending in order to ensnare poorer countries into its net and to be able to use its precarity and dependency on Chinese lending for its geopolitical aims. Now, so, you know, I wish, I'm not sure if Peter is still here, but sort of his report was really helpful sort of in clarifying one of these positions, that the Belt and Road Initiative, a colossal infrastructure project that covers Africa and parts of South Asia, is a precursor for economic coercion. Now, I want to set aside what you might see as hypocrisy or inconsistency, but what I want to think about is sort of, let's take seriously that the BRI, Belt and Road Initiative, is debt trap diplomacy, and what would it mean as a matter of international law to prohibit it or try to prevent the worst outcomes of it. And generally, Sri Lanka is used as the example where the kind of the full kind of harms of Belt and Road Initiative have come to fruition. But really, I want to focus on Pakistan, where we have reports from last year, where after years of negotiation between China and Pakistan for China to place military, have a military presence in the province of Balochistan, Pakistan finally relented in the course of very difficult and protracted negotiations for debt relief. And so the question is, how should we think about this? Now, the accusation of debt trap diplomacy, I think underlying that is a question. Underlying that is a claim about Chinese intentionality, that the loans are uniquely predatory, uniquely unsustainable, and that there are necessary territorial concessions made in the course of that. Now, those are empirical claims, and I won't go into greater detail, but there's a lot of scholarship to suggest that Chinese motivations for the Belt and Road Initiative are multivalent, that actually the Belt and Road Initiative externalizes domestic crisis of overcapacity and overaccumulation, and that with regards to the contracts, Anna Gelpern's work suggests that the contracts really exhibit a difference in degree, not really in kind, from the commercial and creditors and other bilateral lenders. And so I'm happy to sort of get deeper into the empirical issue, but I really want to get into kind of, I think, a more interesting question, which is that I think it is more interesting and I think more revelatory to treat Chinese lending as being part of a larger sovereign lending regime rather than to treat it as exceptional. And if we were to treat the outcomes of the BRI as sort of a feature rather than a bug of the sovereign lending regime, I think that could take us in more interesting and I think more clarifying directions. So at the heart of the Belt and Road Initiative and the heart of the concerns that the Belt and Road Initiative is really
the sovereign lending regime and the construction of sovereignty underlying the sovereign lending regime. And what I mean by that is that obviously, sovereignty, as we know it, is a formal and negative right. And sovereignty does not come with any material guarantees over the means to control social reproduction. And so NIEO advocates at the dawn of decolonization did ask that sovereignty come with a share into the material resources or a share of global wealth. Of course, those proposals were discarded. And advocates like Mohammed Bijawi identify that actually the global south should not be treated as a debtor, as he foresaw, but really as a creditor, given that the extraction of essential goods was necessary for the industrialization in the north. Nonetheless, the legal framework that was created in the sovereignty that we have is a negative right that basically enshrines a particular form of compulsion where states have to earn and compete for the means of social reproduction by going onto the market or earning their keep, so to speak, by going to the lenders of last resort or bilateral creditors. So in some ways, sort of the basis for the compulsion and the relations of domination that we might see in BRA projects is really the first ingredient is a legal arrangement. So once you've enshrined as a legal matter the absence of any control over the means of social reproduction, then states go to the market, right? And so the sovereign bond market is where states finance. It's how they guarantee their future. And then there are two really key tracks in the sovereign lending in the sovereign bond market, where US treasuries are indispensable to the functioning of financing, and whereas many states in the global south do not have demand for their bonds. And this is where you see an interesting parallel between the sanctions regime and the sovereign lending regime. There are two groups of states that are completely precluded from financing on the market. And those are states that are under sanctions, and those are states who are so risky that there is just no investor demand for their bonds. Now, those states that can sell their debt on the market as a sort of systematic level, there's debt overhang for low and middle income countries. There's debt overhang, and I think even a non-economist would understand that when interest rates are greater than growth, that poses a sustainability problem. And so this unsustainable debt load is a feature of the sovereign lending regime, which Chinese lending contributes, but certainly is not the only ingredient. Okay, so once states can sort of exhaust the market, they go to the lender of last resort, which is the IMF for most states, and then just for an exclusive group of states, it's the Fed. And so for states of the global south who are not allowed to access swap lines and repo facilities extended by the Fed, the IMF is their lender of last resort for short-term crises of liquidity. But oftentimes the problem is solvency, not liquidity. And that lending, those funds only come under conditions. And the structural adjustment programs are notorious for actually putting forth pro-cyclical policies that hinder rather than further growth. And then domestically, the structural adjustment policies have really led to the concentration of resources where an elite class really claims resources to avoid resource mobilization. This is sort of evidence that's been gathered by Nicholas van der Waal and other scholars of countries that are prolonged users of IMF resources. So, the debtor-creditor relationship really reshapes domestic politics when states in the global south approach the creditor of last resort, that is the IMF. And ultimately, what you see is that it reproduces precarity rather than delivers the possibilities of escape, which is by definition a debt trap. Okay, so the one problem with the lender of last resort is that, and it's been a criticism from many, from many sides of the political aisle, but someone like John Bolton criticizes the IMF for not providing enough financing. And if the IMF does not expand its issuance of its currency, SDRs, then the United States is going to lose to China. And that policy, those proposals have not actually been enforced. And as a result, the IMF's funding is pretty meager. And so then one direct consequence of that is that countries have to go to bilateral lending, which is the which the Belt and Road Initiative is an example of bilateral lending. And so generally the law treats the kind of unwritten political promises that come from bilateral lending as just part of statecraft, right? There's nothing wrong with one country negotiating a debt contract and saying, we'll lend if you make these concessions, if you do X, Y, Z. That's sort of treated as kind of a natural and expected feature of bilateral negotiations. However, right, the concern of economic coercion that has been raised by policymakers in the West around the Belt and Road Initiative does require sort of a rethinking of bilateral lending. So to prohibit, debt trap diplomacy would fundamentally require us to rethink sovereignty, would require us to rethink how sovereignty institutionalizes market competition and how it makes social reproduction contingent on the bond market and bilateral lending and the conditions imposed by the lenders of last resort. So if you take the China-Pakistan example, after years, Pakistan in 2024 gave up some territory to China so that China could install its military in Balochistan as part of the really ambitious and I think almost impossible corridor that connects the port on the Arabian Sea in Balochistan to the historic Silk Route, Kashgar in Xinjiang. It would have to go through the Karakoram Highway. It would have to go through the Himalayas. This is an incredibly ambitious project, but China, and it's nowhere near completion, and China would like to have a military installation there. Initially, Pakistan said no, it did not want it for very obvious reasons. It did not want a permanent Chinese installation on its territory. But as a result of teetering on the edge of default several summers in a row, Pakistan gave way. And the question then is, or sort of, we can presume that Pakistan caved in because China can credibly menace an existential financial threat. And China enjoys that power because it's engaged in lending practices over which it has can gather asymmetric benefits, because the sovereign lending regime has a tendency in its current iteration to reproduce hierarchy, and because Chinese patronage has served venal elites in Pakistan's short-term ends, right? It's a combination of all three. Now, to actually meaningfully address this kind of territorial concession, which I think we could see as a problem to the extent that we think territorial integrity is important to sovereignty, and I haven't seen proposals that would override that in this room yet. It would require us to really, none of those three contributors are sort of categorically illegal. And if anything, the only contributor that existing law cares about really is the predatory lending practices. The sovereign lending regime that it enshrines compulsion is generally sort of taken up, as I said, normalized and is institutionalized within our construction of sovereignty. So to have a different rule might require holding China accountable for making it difficult for Pakistan to say no, right? That something would be, that the difficulty of saying no would set a threshold for consent, a threshold for coercion as incredibly high, would mushroom the ambit of liability. And so ultimately to outlaw pressure and inducements like the Belt and Road Initiative allows would really require us to reconceive of consent and to consider the force of interstate economic inequality. Now, I'm all game for that, but I'm not sure, however, that those who are most concerned about BRI have the same interest. But I do think that this could be a moment to actually have a more serious conversation around how economic asymmetries shape the possibilities for coercion.
Great. So I think, you were saying you're the oddball, I think, but actually we can hear many echoes in your presentation of things we've heard before, both echoes of on this panel, Alexandra's remarks about kind of the ways in which sanctions represent kind of the unequal economic power between different players in the system, but also echoes going back to Ben's presentation at the beginning about how in many ways these different uses of economic power are themselves efforts at world and lawmaking. But more importantly, I think, Alexandra, you started off by kind of asking for context. you have now helped us provide some context. So a few questions for the panelists from me that hopefully will start a conversation, and then we'll open things up. I'm going to ask each of you a question, but it's really a question for all of you. So hopefully you'll be able to engage in it a little bit. So Alexandra, at the beginning, right, you were, I think in some ways you might say that your main point at the end of the day is that we have the moral calculus that we are performing with regard to sanctions wrong. So I wonder, to what extent, what would be the proper moral calculus that we should be applying, right? Are there moral calculuses that we can borrow from somewhere else that you think we should apply here? But more broadly, and this connects up to Zora's point at the end, right? To what extent do we need to be thinking about the other side of the coin, right? So to the extent to which we are taking on what we are causing certain kinds of humanitarian pain, do we need to take more seriously obligations with regards to humanitarian aid or development as part and parcel of the same project, right? Do we need to bring those in? To Josh, right? So, I can hear hints in your story of a story whereby this isn't actually unintended, right? So if there seems to be perhaps a development here from Humanitarian Law Project to today, where if it was unintended there, when you look at some of the sanctions you've been talking about now, like the ones on the ICC, arguably the actual target is speech. To the extent to which this may now be a target of sanctions, to the extent to which we're now thinking about kind of different kinds of targets of sanctions, and that's, again, I think connects up to Ben's presentation at the beginning, does that force us to rethink sanctions more broadly, right? What does it make us think about sanctions if we now think the targets aren't some sort of changed behavior with regards to human rights abroad, but are actually about perhaps containing some kind of harmful speech, or what some might perceive as harmful speech. And then Zora, at the last part here, right? So I think you do a really nice job of showing us how all of these different tools are really on a spectrum, right? That they are part of a spectrum of economic coercion or the use of economic inequality to achieve various goals. The difficulty is figuring out where on that spectrum the problem lies, right? So we have some sense that some of that might just be okay. We have some sense that others might not. Do you have a kind of a suggestion as to how we might start to define what would be, if not yet unlawful coercion, perhaps it should be unlawful coercion, but what might at least be problematic coercion, right? How we might think about kind of these things and figure out what might actually be the problem. But more broadly, and again, all these questions are for all of you, I mean, I think you nicely lay out that the problem here is not just a doctrinal one, but a structural one. Do we need a structural solution? Right? What would be the structural solution to these kinds of questions? How should we be rethinking an international law that could actually confront these problems in a serious way?
All right. I don't know if I really understood your second part of your question on should we take into account providing humanitarian aid?
I mean, if the concern is that the harm is being caused, I mean, we have this about figuring out the moral calculus. I mean, should we take more seriously that perhaps states have some obligation to rebuild? States have some obligation to provide aid to certain actors, that it's not just a matter of limiting or minimizing the harm, but actually providing some positive.
Actually, your question reminds me of something I forgot to mention, which maybe Nathaniel will mention, is the UN Security Council Resolution 2664. Which kind of supposed to prevent asset freezes from affecting humanitarian aid. So there seems, I think the fact that this resolution was adopted seems to suggest that states are conscious of the fact, well, there's certain activities that we cannot legitimately prevent from taking place. But how do we, allow for that without really hurting, the policy goal, whatever that is of our sanctions, if it's imposing costs or whatever. I don't know. I think it's just how do you justify saying, okay, maybe I don't have to give you humanitarian aid, but I'm not going to because, I don't know. I feel like that's really hard to justify, depending on the person. But maybe for your first question, like the moral calculus. So I think honestly that sanctions are really, I think maybe the first point that's kind of related to sort of what you're asking Zora is, well, we should start by saying, well, what is a sanction really? and not like all the things that we say it is, like whatever I would call it almost a belief system or a narrative. But what are these tools? Are they a form of coercion? Are they a form of punishment? I know within the EU, they say, well, our restrictive measures are preventive, but I mean, I'm not really fully convinced when I see how they're adopted, on what basis, and so on and so forth. So it's really like just like a more practical, pragmatic approach. What are sanctions? And then I think maybe just owe up to what they are. If they're maybe, okay, we say, well, actually, you know what, they're a tool of coercion. Okay, do we want to regulate that coercion, yes or no? Or do we want to leave it unregulated? But I think there's kind of a tension between, you know, if we talk about the rules we have in international law, we don't want to have, we want certain forms of coercion to be prohibited, others not, so on and so forth. And also, I think what's also very prevalent in sanctions, which I also didn't mention because I kind of assume it's common knowledge, but when we shifted from, we don't want these comprehensive bans anymore, but we want more targeted measures. And the whole idea behind targeted was, well, they'll be like, it's this underlying idea, like they should be proportionate, they should be necessary, they should make the distinction, so on and so forth. And yet in practice, that hasn't played out. So I think there's a tension between, what we want. We don't really want all this collateral damage, but at the same time, we think that we need it to achieve policy goals. So I think we should just kind of maybe have a discussion. What are sanctions? What do they do? So on and so forth. And then where does our moral calculus come in? And can sanctions actually abide, for example, to principles of international humanitarian law? I think personally that it would be really, really difficult to define a sectoral sanction regime that would meet IHL principles. But that's just my opinion. Maybe, someone else disagrees, but yeah, that's how I would approach it.
Josh, welcome here on your question or any of the questions.
Yeah, I'm really thinking a lot about Alexandra's presentation, and yeah, not to answer a question by posing more questions, but yeah, I guess my intuition is that we kind of have to look case by case, regime by regime, and also ask the question, what's the alternative?
Yeah.
And what is, Russia invades Ukraine, you're afraid of nuclear war. Do you do nothing, or do you impose, or do you like try to negotiate with Russia, or do you impose sanctions? I mean, I think that's like the very simple logic that might be at work, which isn't to say there isn't fallout, but then yeah, what's the alternative? But on the speech bit, so one thing I didn't mention is that early on in the HLP, the Humanitarian Law Project case, which wound through the courts, so, as I mentioned, over 12 years, the government admitted what they were trying to do is make these organizations, quote, radioactive. So it's quite clear that they wanted to cut off all possible interaction with these groups. And again, from a certain perspective, well, that makes sense. These are terrorist organizations, after all, doing horrible things in the world. But on the other hand, they hold political power. They are in war-torn regions. If you want to deliver humanitarian aid or relief work or negotiate to try to bring about peace, then you have to interact with these folks somehow, right? So I think in essence, a lot of this is intentional, as with, friends in law school and in some in government, you say, well, if you're not, brushing up the chalk lines, if you're not going to the line, to the edge of the rule and maybe a little bit past it, well, then you're not doing your job. That strikes me as an unfortunate attitude when basic rights and lives are at stake. Does that mean we need to rethink sanctions more broadly across the board? I guess I'm small-minded enough in this area to think that, some changes around the edges would make a significant difference and improvement rather than rethinking them from the ground up. But I'm open to be convinced that, I'm wrong there. But I do think we have to start somewhere, and, relatively low-cost reforms would go a long way.
Yeah, I'm going to sort of try to also answer the question of sanctions, because to me, at least in this room, when we're talking about sanctions and the harm of sanctions, they're effective because they work on asymmetrical and non-reciprocal, like, sort of backdrop. And so sanctions would look very different if countries could sanction, other countries besides the United States could sanction
the United States and have equal effect, right? And so I think that's sort of the backdrop of all of this conversation. And so the moral calculus of whether to do it or not, I think shifts depending on what is the structure of the global economy and the background and the background architecture, not simply of monetary sovereignty, but also just in terms of who has control over real resources. And so I think that I think is like a key sort of part of our of thinking of like the whether a country like the United States therefore has more responsibility in devising these sorts of interventions. In terms of kind of like what is the sort of solution for, broadly speaking, the kinds of economic coercion where you have sanctions sort of at the most extreme kind of edge, and then the other side is sort of the carrots, right? And sort of like what to do with that and where to draw the line. And I think as a doctrinal matter, or at least I'm less invested in coming up with the right rule of consent and coercion, because I think that there are some that's very important. I've been reminded by friends that formalism is not good or bad, right? Nominal consent, formal consent is sort of can be a good thing. It just depends on the context within which and the arrangement of resources on which these legal arrangements are made. And so to me, the real problem is that the purse strings are so, like, who controls financing, who controls the distribution of resources that are essential for just planning, budgetary planning throughout the world, that those decisions are sort of concentrated in certain places. And so certain people have control, as a result, can use the carrot more than others. And so I think actually the fix here does not really lie in having consent more attentive to asymmetry of power between states of the global south and global north. That I don't think is the fix, or to have a more perhaps robust theory at a doctrinal level of coercion. To me, the fix is actually to look at the international financial institutions, for example, and to make multilateral lending far more robust, and to go back to an imagination of multilateral lending that maybe that, you know, in the fight of the architecture of the IMF, the US won in having a system of payments or system of funding that was based on condition, and that would be restricted to certain in very sort of small installments. There were proposals put forward by the UK and Keynes to have an automatic system of financing and to expand the issuance of currency and to change the governance of the World Bank and the IMF so that sovereign lending cannot be weaponized in the way that it is. And I think those are, I think those are far more impactful solutions that would have, I think, downstream consequences for kind of maybe addressing the murkier area. I think the problem with some of the, you know, addressing coercion writ large is intentionality, and like to what extent are states declaring openly, I'm doing this to achieve this goal. I mean, China's goal in the Belt and Road Initiative is multivalent. And, you know, the key problem, again, is that like these lending arrangements, if they do set up for forms of economic coercion, the reason these lending arrangements exist is because the debtor states are initiating the arrangements. So we have to address why the debtor states are so dependent on other countries. And I think unless we address that, then we're just going to sort of come up with doctrinal fixes that will have a lot of, I think, very serious trade-offs if we were to change kind of the vision of sovereignty.
Which reconnects us to this question about reviving some of the maybe positive obligations economically that states might have in the international system. So we've got more than 15 minutes. If we can open things up for questions, please just as you ask your question, if you could state your name and affiliation, that would be great for everybody.
Hi, I'm Ben Heath. I spoke earlier. I'm at Temple Law School. So this question is actually for Josh, because there's a way in which maybe you are the odd one out on the panel. And maybe I detected that in your hesitation. I want to sort of see if maybe I can bring you in, because the other, so Alexandra and Zora are both talking about material sides of sanctions, and you're talking about free speech, which has this expressive valence. And something that I've been thinking about a lot is the way that sort of our current First Amendment imagination is broken in a very severe way, which is not your fault by having litigated First Amendment cases, by steering us directly to expression and submerging the freedom of association, which you did mention. But I think actually if we think about that, to use a word that's been flying around a lot lately, more robustly, we could actually get back to building material power and thinking about the First Amendment as a way to build countervailing power outside the state. And so you mentioned some cases, but there's actually a case from 1982 called NAACP versus Claiborne Hardware, which is what I think of as a high watermark for really protecting what was a boycott institution, an organized boycott in southern Mississippi affiliated with the local NAACP chapter that had elements of threats, coercion, and violence, right, used against the white members of the town. But it establishes a very high degree of protection for affiliation with that boycott organization, and really establishes in that case a beautiful vision, I think, of like these organizations as countervailing power, which then, you know, and I mean this is only a provocation for further thinking, because that gives us a vocabulary then to talk about these kind of groups. And I don't want to go so far as to say the Ku Klux Klan or Hamas are national liberation organizations that we should encourage people to, you know, adhere to, right? But there's an idea that our law, that this kind of robust First Amendment protects association with institutions, even if they are wielding political coercive power, even if they occasionally leverage violence. And it's really, it's the law's obligation is to peel off the few people who are doing the violence, not to sort of throw everybody else in the pot with them. And I think that gives us a lot of traction to articulate a moral vision that's very different from what either First Amendment lawyers are currently doing or from what the current regime is doing. So, and maybe that brings you back into a more materialist conversation with the others.
So Ben, thanks. And of course, the NAACP case is huge in this regard. And I mean, HLP is probably more about association than speech, and in a real respect. And you know, one could describe the upshot of HLP is that it bars association of any kind, because the court's essentially saying any kind of association at all redounds to the illegal aims of these unlawful aims of these organizations. And that's clearly false in reality. And not only that, and has real material effects, right? With things like peace building, with democracy building, with education, with just humanitarian relief work that the Doctors Without Borders, other groups are performing at great risk to themselves, and which nobody else is going to do. And Doctors Without Borders, although a charitable organization, doesn't work for free. You know, they need funds to do what they do, and if they're ostracized from the economic system because they are associating with prescribed groups, then that work again can't happen. You know, and this goes for many, many, many other NGOs, and we're seeing this in slightly different contexts now. So absolutely, this has a material element, and this affects lives. So it's not just, and that's what I was trying to push toward. This isn't just an abstract concern about, well, do we have the right to speak or not to speak? No, it just says, do we have the right to associate and promote good things, lawful things in the world or not? And by trying to prevent the bad things, are we also intentionally or unintentionally throwing in a lot of the other necessary things in there? And I think the sanctions regime in this sense is short-sighted insofar as they think, well, we just we cut Hamas off altogether, or we cut other groups off altogether. Can't do anything with them. But I don't know that means a wholesale rethink of it. And you may share that view more than I do, but I do think it does require significant changes.
So I'm wondering about the asymmetry and the moral legitimacy of sanctions. Like, what if so does that mean that if you're, and I agree with you, sort of, I think of a situation like Cuba, we're almost on zombie sanctions, right? And you mentioned Venezuela, Iraq, they've been disastrous for these countries. But what if there's no asymmetry? Like, what if the EU decides to take a stand on Uyghurs in China and says, like, look, we know we're the David here, but we're gonna condemn China for this and issue sanctions, right? I mean, does it all depend on the economic, political economy of it, or is there really something about morality here, right? And so would you say those are amazing sanctions, right? Those are the sanctions. Those are heroic sanctions, and we should do more of those. And the other point I was thinking about is in the law of war, of course, we don't use these doctrines, but the doctrine of siege and blockade does have a humanitarian exemption. And it's kind of ironic if you sort of think that economic warfare is a kind of warfare that doctrine doesn't necessarily have as robust of these humanitarian exceptions, which the law of war does, even though it's, we can argue about whether it's more honored in the breach than the honoring. Sanctions, how much does it depend on the economic asymmetry? So if you have a David going after the Goliath, would you be all for that?
You're looking at me because I think Zora also answered the asymmetrical point. So my part of the presentation wasn't so much about the asymmetry of sanctions, but it was, just to say this is often how they're adopted. Whether or not the sanctions are heroic, I think in the case of the Uyghurs, because the EU did sanction some Chinese officials, but those were targeted sanctions. So those would be targeted sanctions against individuals, right? And so presumably they wouldn't lead to the structural violence that I'm discussing.
Hypothetical sanctions against China, not targeted.
So you would complete sectoral sanctions against China. Yeah. So again, I think if it leads to a situation where, the Chinese population is pushed into poverty, where there's really a reduction of resources and potential and so on forth, then it would be structural violence. It doesn't matter if, okay, maybe China's a powerful actor and Europe's a powerful actor. If you really want to compare sanctions to force, it's well, you use bombs on one country or the other. It's well, what's the impact on the population? So I think what you bring in is you compare it to siege. Yeah, there's people who write about the impact of sanctions on societies and refer to them as societies under siege. And so like you say, it's really interesting that we have these kind of regulations in IHL and warfare, but economic coercion or, economic warfare has completely escaped that area of international law because I think and this is something I think that Ben mentioned earlier, it's because it's so political. And we just kind of want to leave it into the realm of, national security and foreign policy interests and stuff that for the moment, international law has escaped that, but there's a lot of discussion elsewhere. It depends on who you read as well. We talk about in one way here, whether we're in the US, we have similar conversations in Europe, but then, of course, if you're in Iran, they're going to talk about economic coercion in a completely different manner and say, well, it's unlawful, it should be regulated, so on and so forth. So I think it's also, countries' experiences with it as well.
One interesting thing that this question kind of raises is the fact that just as we're thinking about analogies, right? Under the law of armed conflict, right? We had this idea that jus ad bellum and jus in bello are completely distinct, right? The mere whether or not something is a justified war does not change what your obligations are.
You still
Interestingly have no concept of that here. And in fact, it seems like the opposite, right? Everything is justified by the normative justification.
Yeah, exactly. Yeah, that's true.
So
Yeah.
interesting to think about the analogy. So I see a number of hands up. So maybe we'll group a couple of questions, at least, so maybe two at a time and see how that goes. Perry.
Yeah, hi, I'm Perry Betschke with Berliner Corcoran and Rowe, and I'm a sanctions practitioner in Washington, and OFAC licensing is a big part of my practice. And so I wanted to make a comment to Joshua. Very sympathetic to a lot of what you had to say. Believe it or not, 9 months is actually probably faster than average. The slowest one I ever personally worked on took almost 4.5 years. And so I totally get what you're saying, that it's not an adequate relief mechanism because it's too slow to be practical. But I wanted to encourage you not to prioritize First Amendment rights over a range of other interests that are at stake. Just in recent years, I've worked on license applications concerning human life, human health, medicines, medical devices, environmental technology, climate change, due process rights, rights to access to counsel, just a whole range of other important priorities. So I actually think instead of trying to come up with a fix for one subset of rights, we need a fix. And I would suggest that that probably involves two things. One is there's no legal deadlines on how long OFAC has to respond to license applications, unlike various other proceedings in various agencies. I think a deadline would help, even if sometimes it's honored in the breach. And second is budgetary considerations. And I know that OFAC looked into this in recent years. A proposal was made, like how much it would cost if they committed to do all license applications within 6 months. And it basically involved tripling the licensing division's budget. And maybe that's necessary and should be done. But that's what I wanted to suggest for your consideration.
Then we'll take 3 right now.
Thanks. Thanks so much. The speech restriction element, Josh, what you talked about, that struck me, but I wanted to comment on something that Alessandra, you might also jump in. I might be stretching things a little bit too far, but I'm suggesting a hypothesis whether you agree with it or you want to comment on it, because I think the speech dimension is not really a US thing only. It's also applicable in the European context as well. Not only in the context of counterterrorism as well, but particularly in Europe, it's gotten expanded in the sphere of disinformation, Russian media, etc. And so sanctions restrictions going into those kinds of liberty domains as well. So the hypothesis is, this half-baked hypothesis is perhaps sanctions. Is it helpful to think of sanctions as not just tools at the disposal of sovereign states trying to ward off external threats, but rather tools at the hands of certain defenders of an established order, global order, for whom the threat might arise either internally or externally. So it's not just about the foreign element, but some of that threat to the established order could also arise internally, and there might be a tendency to use these exceptional measures going forward to suppress dissent internally as well. So this is the thing I wanted you to comment on.
Okay, yeah.
Thank you. I'm a law student here in Fordham. And I have short comment and question to Alexandra. The comment is, I'm pretty sure it's gonna be some international law in the future about indiscriminatory sanctions, economic sanctions, as it was before League of Nations time. And I like your representation, and but I feel like this missing part, that how sanctions actually have consequences of people, for example, in America, in Americans. Me, for like, I see difference between Russia and America. I'm Russian American, and I see that sanctions harm American people, American business a lot. And could be even debate which more. And last year alone, the exports from Russia was 3 billions, and pre-war Ukraine was export 1 billion. So, and it like fertilizer, for example. So they still sell. And so how this consideration, like what legal effect would you, if you can answer this question, how it's supposed to influence decision maker, especially in US, we have a president and Congress. We don't understand their power in the sanctions, that they have no obligation to reconsider. It can be indefinite, and how they measure how American people suffer from the sanctions, and like who suffers more, like what mechanisms should be imposed maybe here. Thank you.
Thanks. Andrew Larkin, acting assistant professor at NYU. For Dr. Hofer, I apologize if I missed this, but I was wondering if you could address individualized sanctions briefly, and whether those solve the sort of concerns about sectoral sanctions that you have, or the extent to which they do. And for Professor Ahmed, I was wondering whether there are opportunities for debtor nations in the competition between major creditors to sort of end in the sort of arguably declining dollar hegemony for changes to the international financial system and what the obstacles to that sort of strategic individual or collective action might be. Thank you.
Almost a time. Right, if you have any responses to any of that.
So Nathaniel, thank you so much for that question. Very quickly, yes, I definitely agree with you. And also just very quickly about how sanctions can be used internally. I think when the Canadian government kind of froze the assets of protesters, when was it, in January 2022, I was personally shocked. They invoked the Emergencies Act and then froze the accounts of protesters or people who had contributed to it. And what shocked me is like nobody talked about it. But it was really like the reversal of having this tool that we use against external enemies being used against protesters, whether or not you agreed with them wasn't really the point. In the meantime, there's been a case, and the judge ruled, okay, well, it was basically an unlawful invocation, but the harm was already done. So it did set a dangerous precedent. Yeah, so I guess, of course, if we talk about the human costs of sanction, an obvious question is, well, how do sanctions they're not only costly for the target, but the question is also like, what's the actual impact, for the country that's sending the sender or the sanctioner. You referred to the US, of course, in Europe, there's been consequences, especially in Germany. And I think honestly, like I haven't personally studied it, and I think that's an area, as far as I know, hasn't been thoroughly studied or commented upon. But I think it's an important point. I kind of missed your question on the second question, but maybe we can talk about it after because I'm trying to go quick. And then the last question on would targeted sanctions to the extent. So I guess if we think about structural violence, maybe targeted sanctions against individuals would, respond to this concern. But of course, and I think this is what the next panel will discuss, is, how are those targeted sanctions adopted and implemented? Because of course, there's been a lot of work, and I think it's Maya Lester who will discuss this. It's like, what are the procedural guarantees or the procedural limits in adopting targeted sanctions to make sure that there's some consistency with human rights that are owed to individuals? So thank you all for your questions.
Or do you want to add anything?
Yeah, I mean, just to thank, sorry, I missed your name, but I'll get it in the break, for your comment. Yeah, so I mean, I was focused on speech here, and I actually have an opportunity to speak to OFAC about, the speech things that was part of our settlement. But absolutely, yeah, I think it should more broadly, also be fast tracked for humanitarian, medical, access to counsel, these sorts of things. And one could query, how long does ExxonMobil wait for a license versus, some random NGO in Yemen? So, but yeah, no, I fully take that on board. And, with HR 9495, absolutely, this is going to target domestic actors, not just actors overseas. So I think we are living in a time where we'll see much more aim at internal versus, the almost the almost sole focus on external actors that we've had. Yeah.
Last words are.
I'll just say, I think the question of whether multipolarity can reduce economic coercion just depends on certain states. So some states who are like geopolitical swing states can pit creditors against each other. For other debtors, it's a cartel of creditors who actually coordinate activity. And I think it really depends on the risk profile of the individual country. So I think for low and middle income countries, this situation is very different. A country like Morocco has been able to work it. So I think it depends, I think. And I think also the evidence is not in yet.
So we leave you with lots of problems on the table, but have no fear. The next panel is going to solve all of it. But please join me in thanking our panelists.
Thank you all so much. That was wonderful. Just so everybody is on track, 3:45. No, is it? Yeah, it is 3:45, I think, right? Okay, 3:45 is the next panel. And yeah, be back by then. I understand there are some snacks out where you got coffee. So if you need some sugar for your brain, go get it.
That was great. Thank you.
Yeah, I mean,
All right. Welcome everybody to our fourth panel. I know it's been a long day, but it's been a great day. And this is the last panel. So Professor Kent has asked me and so
Just for me, please honor our guests.
of course. Okay, we are thrilled to have for this final panel Dr. Nathaniel Tillahun. He is an associate professor of international law at the University of Essex Law School in the United Kingdom. He studied law in Rotterdam and Mekelle, Ethiopia. His research interests are in the areas of international law relating to economic sanctions, peace and security, and financial crime. He's published on the use and limits of sanctions in promoting international law norms, on the European Union Global Human Rights Sanctions Regime, the accountability of the Financial Action Task Force, and on the emergence of dynamic and experimental governance in global security. He currently serves as an advisory board member for the Swiss think tank PolySync Center for International Policy Engagement and a core expert group member of an international multi-stakeholder, governmental and non-governmental sanctions reform project called Advancing Humanitarian Sanctions Reform. We're also pleased to be joined by Andrew Adams. Andrew Adams is a partner at Steptoe LLP in the New York office, where he works in areas of government internal investigation, corporate governance, white-collar, and regulatory matters. His practice includes a particular focus on anti-money laundering compliance, U.S. economic countermeasures, and national security crisis response, drawing on his experience as the inaugural director of the Department of Justice's Task Force Kleptocapture, a multi-agency response group focused on the economic sanctions and export controls imposed in response to Russia's invasion of Ukraine. Prior to joining Steptoe, in addition to serving as the director of Task Force Kleptocapture, he was the acting Deputy Assistant Attorney General for the National Security Division at the Department of Justice, with oversight of the division's sanctions, export control, and national security cyber investigations. Prior to these roles, he joined the U.S. Attorney's Office for the Southern District of New York and served as lead prosecutor on several prominent money laundering and racketeering cases. He also became the co-chief of that office's Money Laundering and Transnational Criminal Enterprises Unit and served as one of the district's asset forfeiture coordinators. And last but not least, we have Maya Lester, KC, which I learned stands for King's Counsel this year. Maya Lester, KC, is a renowned English barrister at Brick Court Chambers in London. She specializes in sanctions law as well as administrative law, international law, and antitrust. Her website, globalsanctions.com, is a leading online resource for sanctions information worldwide. A member of the Bar of England and Ireland, Maya is described by legal directories as the, quote, star practitioner, unquote, and, quote, queen of the sanctions bar without a doubt, who owns the world of sanctions. She advises on all aspects of United Kingdom and European Union sanctions law, including the UK Sanctions Act, the Iran nuclear deal, the JCPOA, an EU blocking regulation, trade, sectoral, and targeted sanctions, sanctions clauses, delistings, investigations, litigation and judicial review, the implications of United States secondary sanctions, approaches to regulators, reporting obligations and licensing, and human rights and Magnitsky sanctions. Please welcome our final panel. And now I'm not going to forget to do the CLE code, but welcome them first. So now I will ask this, yep, the CLE code is up. All right, so the code is E O L 2 5. And now I will ask you to take it down. All right, here we go. Last panel.
All right, thank you, everybody. Obviously, the last panel on a Friday afternoon might not, be the preferred spot just in terms of energy level. So I ate some gummy bears for the first time since I was about 3 years old. But I think the more important thing we can draw from this is you have to put the best panel last. So, that's I think that's our expectation here. You need a strong finish. So we're gonna go first to Maya, and she's gonna I think start talking about the evolution and current state of due process protections for sanction targets in EU and UK law, but perhaps going a bit further in initial remarks and certainly in Q&A. Then I'm going to go to Nathaniel next, where to talk, I think, largely about his work on thinking about how humanitarian protections can be built into sanctions. Coming out of his membership on the AHSR working group that you heard about, and then to Andrew third, where now of course he has experience from the private sector side of things, but you'll be talking to us at least in part about thinking about from the prosecutorial role, both as a line prosecutor and also as a sort of policy setting managerial level, thinking about sort of the prosecutorial toolkit in a variety of ways. And the topic of the panel is existing and emerging limits on sanctions. So I think we're going to sort of move from kind of directly judicially enforceable type limits with Maya to thinking about how as a policy matter, greater limits might be able to be built in, whether whether required or potentially required by law, or just as good policy for protecting humanitarianism. And then the paper that Andrew's writing for the International Law Journal here is an interesting way of looking at how prosecutors might engage in more communication and cooperation if they're not at the Department of Justice level, but civil enforcement type prosecutions in the OFAC context, and thinking about how sort of more positive outcomes in the sanctions context might be achieved. But of course, like all the panels, will go beyond that, I am sure. Maya.
Thank you very much to everyone for asking me. First, a bit of a plug for globalsanctions.com. Sorry to do this, but there is a discount if anyone would like a subscription for anyone attending this conference. So check it out. Please tell me if we've got the US or any other law wrong. We've now tried to go global and cover all material on all sanctions regimes everywhere. So all feedback would be very warmly welcomed. So I am, as Andrew said, a barrister, a litigator, and so all kinds of aspects of the legal fallout of sanctions that we've been talking about come across my desk. I have a very strange and perhaps unique privilege of being able to act for all sides, because barristers don't exist in the US, but we are self-employed hired guns. So literally one day I will be acting for the government in the UK and the next day against them, obviously not where there's a direct conflict. But that does mean that I, have a privileged position of seeing things from all sides. Also, because of Brexit, I am now ridiculously an Irish barrister as well as an English barrister, and that means that I can continue to advise on European law and practice in the European Court of Justice, which only UK barristers can't do. So what I thought I would do is take the topic of targeted sanctions in particular, which we have been starting to talk about today, and some of the approach to issues of due process and fundamental rights that courts around the world have been looking at. This is a particularly interesting topic, I think, because it really brings into focus the basic tension that today has very interestingly addressed between sanctions as a foreign policy tool, which they very obviously are, and individual rights. So what happens when you take a highly political tool and you target certain individuals, companies, and people for particular restrictions. And I think where we end up is that with pretty different journeys there, the EU, the US, and the UK, and to some extent the UN, have all ended up in a pretty similar place and not a very satisfactory one. So that's going to be my overall theme. Just very briefly, I know various people have answered the question of what are sanctions, but just so that people are clear on what targeted sanctions are, these were the sanctions, as was outlined this morning, developed really in the 90s in response to a feeling that Iraq and other comprehensive sanctions had been seriously unfair on civilian populations. So there was an attempt to target the pain on, the bad actors whose behavior was intended to be changed. But actually, what are they? They are legal instruments. They're pretty similar, whether you're talking about US, EU, UK, or other, Canadian, other sanctions regimes. They basically do two things. They draw up lists of people and companies by name. And they, first of all, usually restrict travel. So they say, if you're on this list, you may not travel across our airspace unless you already live in that jurisdiction, in which case it's pretty complicated. But so if you're on an EU sanctions list, you basically can't travel to the EU without special permission or licensing. And they also impose what are usually referred to as asset freezing provisions, but they're really more than that. So they basically say everyone on this list, and in the case of UK and EU, but not US sanctions, confusingly, not everyone on the list, but also companies those people own and control, but which are not named. That's a hugely significant point I will come back to. May not access their funds and economic resources, extremely widely interpreted, in the jurisdiction where we're sanctioning you. So if this is the UK, you can't access them in the UK. If it's the EU, you can't access them in the EU. But also, it's a criminal offense, usually a criminal offense in most places, for anyone else to make funds or resources available to you or for your benefit. So it prevents people from paying you or engaging in any kind of economic relationship with you on pain of criminal and civil enforcement. And sometimes they have effectively an extraterritorial effect too, because if you are, for example, a British citizen on a UK sanctions list, you are affected by them the world over. So it's not only within the jurisdiction. If you're a citizen, which some on the list are, then they are effectively a worldwide freeze. So it really is quite a significant set of restrictions if you have funds or resources in the jurisdiction. And again, that's a big if, because like the US lists generally don't target US citizens. So these are sanctions on non-US persons, and the same is generally true of the EU and the UK list, but not universally true. So if you hold no assets and don't want to do business in the jurisdiction, you may not care at all. But if you live there or do business there or have bank accounts there or wish to travel there, it may be very significant. And then there are extremely complex issues about, well, if you're on a US sanctions list, but you do business in the EU, how does that affect you? And the answer is a lot, because any bank, most banks care deeply about US sanctions, and most companies and people care more about US sanctions than any other sanctions for some of the reasons that have been gone into today. But basically, the might of the dollar is such that no one wants to be cut off from the US financial system. And so there are difficult legal questions, which we can come on to if we have time, about what's the effect of a breach of US sanctions on someone else's legal regime. And I think one of the things that today hasn't come out so much yet is the complexity of these overlapping different regimes around the world from a legal perspective, which is pretty complicated. So with that introduction, when targeted sanctions were first designed and implemented in the 90s, so, somewhat surprisingly, there was very little by way of due process at all attached to them, because they were literally just names of people without any identifying information and without any reasons given for them being sanctioned. So there was a list of names. And the US made particularly wide use of these post 9/11 and persuaded the UN to so the US requested the UN post 9/11 to put a vast number of people on terrorist asset freezing lists without any reasons being given or any opportunity for those people to say anything about the fact that they'd been listed. And the White House legal counsel at the time, I think, was David Aufhauser, now at Williams and Connolly, who described that process as being, let's just round up the usual suspects and go freeze their assets. And that's basically what happened, and that's been recorded in lots of books. So you can see immediately that that is problematic from the point of view of the people whose assets were thereby worldwide frozen, because although we don't talk much about UN sanctions now, because the UN, frankly, has become quite a marginal player when it comes to sanctions because of China and Russia on the Security Council. If you're on a UN asset freeze list, that means effectively a worldwide freezing order on all of your assets. So this is not like what we would call a domestic asset freeze provision, where, you know, the courts are saying this person needs an asset freeze because you know, they're trying to dissipate their assets and there's a legal case against them. In that kind of case, you're talking about a limited pot of funds that you're worried about. This is all your assets everywhere if you're on one of these lists. So what happened when this kind of issue reached the courts is interesting. So there's a famous case for international lawyers. It's a famous case called Cardi, which I was lucky enough to have been involved in, which was in a way, the first case to put these issues into pretty stark reality, and actually had an incredibly far-reaching effect on this issue for reasons I'll come on to. So Yassine Cardi was on the post 9/11 terrorist UN list, and he discovered that his assets were frozen in the UK. And he brought proceedings in the UK against the Treasury in the UK and said, why am I on this list? No reasons have been given. I don't know why I'm on, and no one's notified me. The UK court said, we can't do anything about this. You have to go and ask the EU, because obviously UK was then an EU member state, and the actual decision freezing his assets was an EU decision. So he said, fine, the case was stayed. He went to the European court in Luxembourg and said, okay, please tell me why I'm on this list and unfreeze my assets. And the European court said, this is a UN decision, so we can't do anything about it. And in that litigation, the first time round, the European court said, because your listing derives from a United Nations Security Council resolution, which is sort of famously unreviewable by any court, it is immune from judicial review, because the EU member states have an international obligation to freeze your assets. So there's nothing that could be done, and we can't review that situation. In then the sort of famous appeal case, which came to stand, I suppose, for due process in this field, the Court of Justice, the higher court, said, actually, if the European Union is going to do something as draconian as implementing the UN Security Council resolution doing this, it has to use basic due process in doing so. And by that, it meant give reasons for a listing, give evidence underlying those reasons, and provide some form of judicial review, basically. And after that case, which caused some alarm, not least in the United States, because here was a subordinate court effectively, as they saw it, reviewing a UN Security Council resolution. And I will say there were 18 EU member states lining up against us in the European Court, saying this is the end of the international world order if you start doing this. After that, there was quite an interesting sort of dance, because the EU institutions tried to argue in every subsequent case that the Cardi principles of due process did not apply, for various different reasons. So first case, they said about country sanctions and not terrorist asset freezing, they said that was just terrorist asset freezing. And the court said, no, it applies across the board. Next case, they said that only applies to UN related sanctions and not EU autonomous sanctions. That was rejected. And then they said it was only related to allegations of wrongdoing like terrorism and not allegations that you, for example, are a minister in a government, and the court rejected that. So the basic result of that was that the EU built into its regulations some element of basic due process, i.e. a right to have reasons for a listing and so on. The really major impact actually of that case was that the United Nations, because they felt pressure from the European Court, put in place much better, in my view, due process for people on one UN list, the Al-Qaeda sanctions list, and they created the Office of the Ombudsperson to review the evidence for everyone on that list who wished to petition to be delisted. And the reason I think that is better due process than anyone I've ever heard of has ever had on these lists is that the Ombudsperson will meet with the person with the listed person, will spend a number of days actually eyeballing them, interviewing them, reviewing the evidence, and doing a report on whether they should be delisted. But every single other UN list has no process really at all for delistings of that kind. Why? Because there's been no CARDI equivalent for any other list. And that I don't understand. So all the lawyers, please find cases like CARDI, but for other UN lists, because I think it's the only thing that would ever persuade the UN or require the UN to extend that kind of process. Anyway, what then happened in the EU is that there were many cases where applicants were successful in challenging their targeted sanctions. And again, it was kind of regarded as a seriously bad thing, I think, certainly in Washington, D.C., because there were all these Iranian banks at that time. This was the height of Iran sanctions. So CARDI was sort of 2009-10. And very shortly afterwards, there were lots of Iranian banks and companies, oil companies, shipping lines, winning their cases. Why? Because their listings at that time were based on allegations of wrongdoing. So what was said about them was, you have supported nuclear proliferation. And they would say, well, how have we supported nuclear proliferation? And usually the EU Council would have either literally nothing on its file to justify what had been said, or something that was factually incorrect according to the banks. But usually at that time, literally an empty file. And so faced with an empty file, the court said, well, look, the bank wins. And so I think it's probably not an exaggeration to say, and I had this conversation earlier with Peter Harrell, that the view here was targeted sanctions may not survive this. I mean, I always thought that was a bit over the top, but that was generally the view, that this could be the end of targeted sanctions. However, what then happened was very smart by the US and the EU and now the UK, and has certainly not the end of targeted sanctions. In fact, it's sort of their heyday, I think, now, because what happened in response to all this litigation, and you could say it's the fault of the litigators for bringing these cases, was that the governments, so the US government, the EU government, said, well, actually, we can't sustain these listings based on misconduct. It's just too hard. We don't have the evidence. So let's change the goalposts and just sanction people for their status. So let's just say ministers in a government are the targets of sanctions, or former ministers in a government, or people who are involved in the energy sector. And let's make those the criteria for getting people on sanctions lists, and then they will be much harder to challenge. And they were absolutely right. It's much harder, of course, if you're a minister, to say I'm not a minister, and so on. And so there are a few other reasons, but that I think is the main reason why the tides then turned. Cases have become much harder to win for applicants. So where does all of this leave us? Well, first of all, there is an element of basic due process. It's quite hard, I think, to suggest that there isn't in all of these sanctions regimes, because now you are given a sort of short statement of the reasons why you are listed. My understanding in the US is that that's not actually sent to you. You are deemed to have notice of the fact that you have been designated because it's published. That's less due process than you get in the UK and the EU. But anyway, there are reasons there. You then have to ask for the evidence underlying the reasons. That can take many months to be sent to you, but in all of these jurisdictions, it is generally not what lawyers would describe as evidence. It's basically open source Google searches, it's articles, it's Wikipedia entries, sometimes it's NGO civil society reports, but it's basically, you know, hearsay saying, you know, this person is an associate of President Putin if we're coming on to Russia. Now, the US, again, is different because the EU and now the UK, which I'll come on to, rely basically entirely on open source material. I've not seen any case where any of them have said there is classified material that we want to rely on, and there are procedures to deal with that. The US, most of the time, I believe, you will receive a heavily redacted version of the record. And even in the court process, you will not ever see those what is behind the redactions, because the government is entitled to rely on classified material and never show it to the listed person. Now, the UK and the EU have a system where you are entitled to see what is called the gist of the case against you. So they don't have to show you the super secret stuff, but they do have to say, look, the basic allegation is X. And then you have a special security cleared advocate who is able to try their best to negotiate the fact that they're not able to take proper instructions on the allegations. But at least there is some attempt to deal with the unfairness of that aspect of the process. And you do have access to a court in all of these systems, unless you're in the UN, in which case you don't. So now we have UK sanctions. Why? Because of Brexit. So the UK always did all of its sanctions through the EU. When the Brexit process happened, or started to be debated even, the first piece of legislation to go through Parliament in the UK was the Sanctions and Anti-Money Laundering Act, because the government realized that they needed the power to carry on doing sanctioning. And this was not an area where we particularly wanted to take back control, as you remember Boris Johnson famously putting it, but because we want to be able to continue to do what the EU had done, but we needed the power domestically to be able to do that. So we now have our own statutory framework, which basically mirrors a lot of what the EU has done, but also is different in some respects. But it now enshrines that sort of basic due process. So the obligation to give reasons. In the UK system, you have to go through an administrative process before you can get to a court. You have to ask for a so-called ministerial review, ask the government to reconsider before you are allowed to go to court. The EU has the opposite, where you have to get to court within 2 months, by which time you won't have heard back from the administrative process. And the EU doesn't really have an administrative process to speak of at all. There's no one really who will engage with any arguments that you make. The US has a real administrative process, and I think Andrew, to some extent, will talk about that. But actually, one of the points I'll make at the end is I have a slightly rose-tinted view of the US system in some respects, and this is one of them, that there is at least some engagement with government on your arguments. The British government has an administrative process, but usually when you make representations, they use that opportunity to correct any errors, but add additional reasons and bolster their case against you. So it's a difficult decision whether to go through that process. But I think the key point here is that the approach of the courts and the powers of these different governments give us now a situation of almost unreviewable executive power. Now, that is a slight exaggeration. It's not really unreviewable, but it is unbelievably broad executive branch powers in this field. And the courts have taken a seriously backseat, rightly or wrongly, in all of these different jurisdictions, including the EU, I think, who are often, said to be the most sort of active court in this field. So what do I mean by that? Well, the traditional administrative law position in all our jurisdictions was what in the UK was called a judge over your shoulder. If you're a government decision maker, right, you've got a judge sitting there watching you. And if a decision you're taking is impinging on fundamental rights in a major way, then that requires traditionally a very serious amount of justification. what in our case law is called an exacting review of the interference with your fundamental rights and the justification. That doesn't really happen in the field of sanctions at all. The first key point is the one I made about what happened after Cardi, because the criteria for getting people on sanctions lists are incredibly broad. So my guess is there are many people in this room, including me, who are an involved person, which is what you need to be for the purposes certainly of UK sanctions. In other words, you could be added to a Russian sanctions list tomorrow. Why do I say that? Because the criteria include being associated with someone who was in business in the Russian economy. It's 9 sectors of the Russian economy, which is, now you probably all know someone who, for example, has, I don't know, been involved in litigation and paid by a Russian, let's say. That would be enough because you've received a financial benefit, you're associated with them because you know them. So somebody who was involved is enough in the past tense. So this is extremely broad. When it comes to court review, first of all, like the US position, actually in a judgment a couple of days ago, is that generally, what's it called, political question doctrine applies to make most decision-making simply unreviewable as a matter of jurisdiction in this field. The UK also, in a very recent case that I lost a couple of weeks ago, says that there is no jurisdiction for Human Rights Act, European Convention on Human Rights purposes, unless you have property within the UK or EU. So very much mirroring actually the US position on foreign non-US persons trying to bring these due process cases. But the key thing is also enormous levels of deference to the executive because this is seen as foreign policy and national security type decision-making. And the justification for that is either an institutional one, they are the democratically appropriate branch of government to be making those decisions, or it's a sort of institutional expertise one, but it really gives the government a huge margin. And that's in a circumstance in which, in any event, the thresholds of evidence are extremely low. And all the governments have to do is show that they have, it's worded differently, but it's the same thing, that they have reasonable grounds to suspect that somebody is involved in these incredibly broad categories. The UK is also more extreme because the leading judgment in this area, which has just been heard by our Supreme Court, so it's possible it will change, is that you don't actually have to look at the proportionality, i.e. basically the justification for each individual decision to designate someone. So someone comes to court, as Eugene Schvidler did in this case that's just gone to the Supreme Court. He's a US citizen, he's a British citizen, and he's on a UK sanctions list because he used to be the non-executive director of a company called Evraz, but he stepped down. And he used to be in business with Roman Abramovich, but he no longer is. So he is on a sanctions list which hits him worldwide, which is why he's not in the UK anymore, because of past things that he now cannot change. And the court said, we don't have to look at whether your designation could have the slightest impact on the war in Ukraine, because the whole point of targeted sanctions is the cumulative effect of hundreds and thousands of designations. And if it can be said that every little helps, then there it is. And that is the legal position at the moment. There's a subsequent judgment in a case brought by Angelica Khan, where the court went even further and said the whole policy here is to make innocent people suffer by being on sanctions lists so that President Putin will say, oh, that's really bad, I'm going to leave Ukraine because of all these people. So I am about to end, I promise, Andrew. So there are some successes in the EU, it's true, where people have challenged sanctions successfully, but they are, for reasons we can go into if anyone's interested, pretty marginal. So they will have successfully challenged a previous version of their listing, but they remain listed. And the EU has a practice which I have tried and failed to argue is not compatible with the rule of law, which is that you win a case in the European Court and you get relisted the next day with slightly different reasons. You're still on the list and you have no choice but to go back to court, which takes about 2 or 3 years, and argue your case again at vast expense. So final point on this, do we care about this or not? Well, and that is a genuine question. So if these were lists of basically bad guys who have done obviously bad things, to talk, the previous panel about heroic, noble sanctions, maybe. The problem with that argument, I think, is that although the headlines and the press releases, not just in the Trump era, by the way, we do it too, talk about Putin cronies and kleptocrats being put on these lists with great sort of headline catching attention. The fact is, the people on the lists mainly or include a lot of people like Eugene Schvidler who are business people who may or may not have resigned from their business positions. And there isn't that much distinction, I think, made between those who are Western facing and anti-Putin and those who are genuinely, no doubt there are lots of them who are genuinely, in favor of the war and Putin associates. But for those people who are not, the problem is one that Andrew's going to talk about, which is these regimes are all stick and no carrot. So there is zero incentive for anyone on these lists to change their behavior and do anything. Why do I say that? My last point. The reason is that it's very hard to know whether, this came out of an earlier panel, these sanctions can really be said to be about changing the behavior of the targets. Certainly, if you write to the government in the UK and say, what do I need to do to come off the list? I've divested all my Russian interests. What do you want me to do? You will not get an answer. There is no policy that says, here's what you need to do. A handful of people have been delisted, but with no public statement about why that is, or even private statement. So people don't know genuinely what they have to do to change. And in the case of people who are listed because of what they did in the past, it's very difficult to know what it is that they could do. And the answer probably is that this is about, as I think Peter Harrell put it this morning, it's really about signaling, which is, the government's favorite. It's about signaling disapproval, but using individual people to make that signal, and query what the signal really is, where you're targeting someone who has already done everything they can to change their behavior. Isn't the signal then that whatever you do, you're going to stay listed? And so there have been attempts to talk about having an off-ramp for people who can change. And I would, I know a bit about the US position, which I think is a more meaningful one than the UK and the EU. And the government has said, maybe if you donate to a fund for the reconstruction of Ukraine. So people have said, fine, I'll donate if you will confirm that you'll take me off the list. But that never happened. So the government have said, it's really strange. No one has donated to our fund. But the fact is they have never created an incentive for anyone to change their behavior. And so it will be really interesting to see whether the targeted sanctions are ones that President Putin even cares about. So my guess is that these will be the last sanctions to come off if the war in Ukraine ends, because I suspect that they may not be a serious part of his decision-making and yet have a very significant impact on some of the targets.
All right, thank you. Nathaniel, and then Andrew, and then hopefully we'll have time for audience Q&A and back and forth with folks on the panel.
Thank you so much. Thank you for the invitation. It's a great privilege to be here, and a particular honor to do so, particularly flanked by illustrious legal practitioners to my left and right. I'll come to the topic from a more ethical point of view, the humanitarian limits to sanctions. Naturally speaking about, we've been talking about the more, system level, political, economic, or world-making type of discussion about sanctions. So from that angle, talking about humanitarian limits might sound like fiddling at the margins, but it's important to keep in mind that hundreds of millions of individuals occupy those margins still. So there is a value to discussing those marginal movements. I'll quickly do three things. I'll try to recap the state of the law at the moment, and then do the political discourse, policy discourse by stakeholders. And then thirdly, I'll try to highlight some of the glaring gaps that we still see in the area of humanitarian limits to sanctions. So in the first point, in terms of what is the legal development that we have, I'm greatly aided in this regard. I think it was Joshua or others have spoken already about the December 2022, 20 and 23 forward legal reform that was going on. Started at the Security Council, but the US has been a leading actor, and then EU followed, UK followed as well. There's been a series of reforms that came up, well known as the humanitarian standing carve-outs. So these are supposed to be no longer ad hoc, but standing permanent humanitarian carve-outs for humanitarian activities. So the UN Resolution 2664 makes a carve-out for humanitarian assistance and for basic human needs. I had an occasion where I was where a U.S. The then U.S. Security Council deputy representative was speaking about how they came up with this basic human needs term. I think it's references other General Assembly resolutions that talk about that, and it was a deliberate terminology to encompass education, health, those kinds of extra humanitarian action activities. U.S. general licenses that soon followed in December 2022, I think are by far the ones that go really further from all of the other general humanitarian exemptions. They exempt humanitarian activities, food and agricultural commodities, medicine, including parts and services, software updates, etc. But also the most important aspect is they also include NGO activities in certain areas, and these areas include humanitarian projects but directly benefiting civilians, health services, assistance to vulnerable and displaced individuals, democracy building, peace building, DDR, education, non-commercial development projects directly benefiting civilians, and environmental and natural resource protection activities. I mean, I just run down a list, but it's just to give you a flavor that this is supposed to really go further ahead. And so far, the EU and UK exemptions are also not as coextensive as the US general license are. So in that regard, I'm sorry to strike a positive note that there is some positive move from the US side in really pushing ahead in terms of towards humanitarian activity. There's been quite an impetus around that time when Irish and US pen holders were leading the 2664 resolution. So I think there was enough strategizing to bandwagon on that and build a political momentum into translating that UN resolution into national resolutions. It's been interesting that the EU hasn't actually, for an actor that really prides itself for being a normative actor, not just a raw power like the US, that the EU has actually lagged behind in terms of substantively incorporating this humanitarian exemptions into its systems. The US general licenses notably still exclude those kind of activities if they are undertaken with the knowledge or reason to believe or reason to know that they benefit narco trafficking designated individuals. So given the discourse in the current government as well, I think this is something that's going to continue. There is a particular interest in this area to not really extend the benefit of humanitarian exemption. Even if you're an NGO operating in a narcotics, prevalent area, you still find significant constraints in terms of operation. So there's been a momentum since late 2022 in terms of expanding the space for humanitarian activities. Mind you, I keep using the word humanitarian activities, not just humanitarian actors, because none of these exemptions exempt humanitarian actors as carte blanche. They just exempt particular activities that those humanitarian entities engage in. Another thing I'll move on to is to give you a sense of the discourse that was going on between relevant stakeholders from private sector, civil society sector, but also more importantly from government side, OFAC, Treasury people from the EU, from the UK. I was part of a process, the AHSR process. It was a 2-year dialogue process that involved policymakers from across the Atlantic and relevant humanitarian actors in a sort of in a Chatham House rule discussion behind the scenes for quite a lengthy amount of time, trying to come up with what we termed model humanitarian checklist. Like, at least if you can, I mean, it sounds a bit stupid to reduce this concepts into checklists, but that's what are the things we keep constantly getting from, you know, sanctions units or governments. Okay, we get the point, but can you give us a short version of a checklist that we can just run through and then make sure that we're good? And then to arrive at that, we had to go through this 2-year process of dialogue with, you know, tri-sector groups, industrial representatives, etc. My point is not to list those checklists. The document is online available. Just a couple of observations of that process. And the first observation is that there is a tendency to recast established international obligations into code of conduct, soft law thing. When we talk about these things, that's been a constant battle. We constantly had to push back with, you know, government representatives wanting to re-articulate and reframe solid human rights, humanitarian law obligations into aspirational objectives that we may or may not achieve in adopting sanctions. So that's one struggle that people working in this area may find it. You're talking about, you know, the socioeconomic rights of people, and the previous panel talked about socioeconomic rights of people. I mean, academically, yes, it is an established concept in human rights law. Trying to translate that into sanctions units application, it becomes a very fuzzy, idealistic discussion. And in some aspects, also there is some thinking involved in terms of translating lofty ideals in human rights into contemporary applicable. For example, what does human rights, you know, human rights to basic socioeconomic rights, what do they mean in contemporary financial system? Do we recognize the right for banking? Do we recognize the right to basic financial system access to individuals in contemporary living? That's a challenge. The second one is not fully being on board with the idea that, you know, neutral humanitarian actors are really neutral. So governments really constantly want to push that neutrality is not a status. It's a claim that you prove case by case each time. And the humanitarian world pushes against that constantly. We shouldn't have to go through. I mean, you have already seen the ordeal of, from the previous panel, the ordeal of going through license applications and etc. So the humanitarian world says, do not send us through that route. There is enough grueling certification process that we go through to obtain our status as humanitarian actors. We don't have to prove our status each time on an ad hoc basis. And one of the, for example, governments want to humanitarian actors, okay, we'll cut your slack, but then you'd have some reporting obligations. You'd have to do some gatekeeping stuff for us. You're going to have to collect data about ultimate beneficiaries and send it back to us in humanitarian and say, this jeopardizes our impartiality. We don't want to be your actors on the ground. We don't want to be passing information about ultimate beneficiaries. Also, some of the kind of benefits we provide, they are humanitarian benefits. We provide them for everyone, regardless of who they are. So at some basic level, we shouldn't even be required to distinguish between ultimate beneficiaries, as long as we establish that the service that we're giving is humanitarian basic service. And that's the constant battle between the two sides. So in terms of ongoing channels, and this would be the third or last part of my discussion, in terms of, you know, the gaps that we still see, the first one would be there is still pockets of ad hoc exemption regimes. So this blanket general humanitarian exemption doesn't really cover all sanctions regimes across the boards. There's still pockets of ad hoc exemptions, and ad hoc exemptions practically do not work, because they do not work with business logic. You know, in areas that are completely devastated through sanction, businesses might have exited. Essential infrastructure might have been not existent. If you put in place, for example, in Syria, there's been earthquake and there was an ad hoc exemption built up immediately to respond to that earthquake. I mean, well and good, but the way multinational corporations or general financial institutions operate is not on a monthly basis or on a 6 monthly basis. They would have made their business analysis earlier on, decided to exit the market. They wouldn't come up if you come up with a 6 months ad hoc exemption. They're not going to come for 6 months and go. So this kind of ad hoc pockets still exist. They do not correspond with realities. Another dimension is there is element of humanitarian space or development space that is not captured by these formal exemption regulations, legal systems. For example, remittances, they're not individual remittances, they're not captured by these exemptions. And data after data has already shown us that people in those kinds of settings, what really sustains their life is not NGO money, it's remittances. But those kinds of extra humanitarian industrial complex kinds of flows, they're not captured by existing. I mean, this kind of is a residual effect from the post 9/11 attitude of this clandestine bona fide individual transactions as being particular menace, or charities as being particularly dangerous, etc., especially when they involve global South actors. So there is still a broader space of humanitarian intervention that is not captured. If you look at 2664, the UN resolution particularly, it's actually one of the worst in terms of recognizing the range of actors. It actually only recognizes UN-affiliated or government or multilaterally affiliated humanitarian activities. Even the US general license is far better than that because it actually recognizes any NGO work as long as it's within certain specified areas. The Security Council resolution only recognizes international organization recognized or bilaterally, multilaterally recognized kind of organ. So it only recognizes this organized or corporate type of humanitarian activity, not others. Another important issue is the expansion of dual good use sanctions in left, right, and center, and that is constantly capturing a lot of humanitarian goods, a lot of goods that are necessary for humanitarian intervention, increasingly be captured by this expansive sectoral sanctions. Sometimes we don't want to call them sectoral, they are sectoral. So one thing we need to understand is the development or humanitarian space is now as much part of the global financial logistics industrial complex as anything else. It requires massive freights, it requires finances, it requires insurances, it requires a lot of the typical business preconditions that we require, particularly big brand global philanthropy especially. So it's not really, you can't really extricate the humanitarian thing as an island in the midst of a devastated economic infrastructures, but particularly in regions or countries that are heavily sanctioned and have been living in heavy sanction for a sustained period of time, where the necessary business infrastructure has crumbled. It's no use to say, well, now we give you a license to go and work and operate in those contexts. And so that decoupling that is a challenge. The final point I want to raise is to what extent there is a political interest and impetus and investment by sanctioning states in being able to monitor, evaluate, capture the impact of their sanctions. I think that's an area of ongoing, inquiry and question. I don't think there is much interest in investing. I mean, we know sanctions units are stretched everywhere around the world, but the situation is much, darker when it comes to capturing the humanitarian impacts. There's chief sanctions economist position in the US that was announced, a year or 2 years ago, I think, whose remit is essentially capturing the economic consequences of sanctions. I mean, that goes certain extent in that direction. No other country has that kind of position. But generally, I think if you want to be conscious of the humanitarian catastrophes or the negative fallouts that your sanctions give rise to, you need to put or you need to invest in a structure that allows you to capture, that allows you to actually know what goes on. So that is the one glaring gap, I think. Yeah, I think I'll conclude here. Thank you.
Thank you very much, Nathaniel. I will go to Andrew.
All right, I am almost certain that on this panel, and maybe on all of the panels for the day, I'm the only person who is actually sanctioned. I was sanctioned by Russia in 2022. I did not receive adequate notice. I became alerted by my mother, who sent me a text telling me that she had seen this posted on a Kremlin website. My delisting petition remains pending with no response whatsoever. And this is really neither here nor there, except to say that I'll have some thoughts on how OFAC and US institutions can do better, but it could certainly be worse. I will also be very brief so we can get this to a discussion and to some Q&A. The themes I want to draw on first are really descriptive, what's happening in the United States right now, especially in the midst of an administration change. Within the Department of Justice in particular, there are some very public and well covered by the media shifts within the department that touch on things like corporate enforcement and national security. Notwithstanding the shifts in personnel, the shifts in emphasis and interest, I think it's safe to say that sanctions are going to remain a key priority and a key tool for this new administration. The disbanding of the task force that I ran when I was in the department, which focused on Russia, was immediately supplanted by a task force of precisely the same structure and precisely the same remit focused on Hamas and Hezbollah, and really focused on the October 7th attacks. So it's really, in my mind, a shift in interest geopolitically, not so much as an interest in the tool itself. That said, there are some moves afoot within the department to essentially undermine the ability to investigate what the department would call financial facilitators for sanctions evasion, teams that would otherwise be going after financial institutions, corporate actors, and the like. And so there's a little bit of speaking out of both sides of the mouth with DOJ right now, and happy to get into those things. What I have written about in advance of today, and look forward to working on with the law review, is the notion that there are cultural, bureaucratic, and statutory, and sometimes regulatory hurdles within the US sanctions apparatus that, as Maya said, make it quite easy to impose sanctions and make it politically toxic to entertain the delisting or licensing in anything like a robust manner. Notwithstanding the fact that OFAC, state, to some extent our Commerce Department, make the point that changes in behavior are the reason that sanctions are imposed to begin with. Notwithstanding that public sentiment or the stated sentiment, there are problems with notifications to Congress. There are immediate blowbacks from a political perspective that make it almost impossible for OFAC in particular to walk back sanctions, to delist individuals, and to engage in a negotiation for benefits to the United States, to our allies, to Ukraine, for example, in a way that would actually, I think, fulfill the promise that the sanctions program purports to have. I agree with Maya that there is more daylight here than in essentially any other sanctions regime that I'm aware of. But as some of the audience members and folks on the panels have said previously, the notion that you might, after the course of 18 months or 4 years, get some sort of relief from OFAC is enough of a disincentive to make it such that people generally don't even ask. That's something that I think can change and should change, frankly, if these sanctions regimes are supposed to be driving real tangible change. And the framework that I draw on, maybe somewhat parochially, is the framework that U.S. prosecutors use to build large, impactful transnational cases. The tagline really is that sometimes you have to make deals with bad people, and you need political cover to be able to do that. There are ways in which the Department of Justice has built a cooperation framework that give it that kind of political cover to engage in those sorts of discussions and to give people tangible benefits, even people who are politically disfavored, and sometimes extremely so, violent criminals, big fraudsters, et cetera. But there are real benefits to doing that in building out the bigger project for the Department of Justice. That's something that OFAC can and I think should emulate. The other place to look for this, and this will be the last point, is we have mostly focused on what I think of as what OFAC does, economic sanctions. In the US, often we lump in the notion within sanctions, the notion of export controls, which is run by our Commerce Department instead of the Treasury Department, and has different moral implications to the restrictions that it puts down. The Commerce Department is actually quite good at interfacing with people who want to come forward and explain what their business is, how they might come off of what's called the entity list instead of the designation list. And has, in my mind, a far broader impact on things like the ability of the Russian military to resupply itself than targeted sanctions under OFAC. I'll pause there.
All right. You're so brief, Andrew, that I have to jump in sooner than I thought, but you're gonna have an excellent paper coming out in the International Law Journal soon. So I'm just going to start with sort of a brief kind of lawyer's question for the lawyers up here, while folks in the audience are signaling that they might like the microphone to ask a question. So sort of picking up on Maya saying, hey, lawyers out there who do sanctions, why don't you bring CODI kind of cases against other UN Security Council sanctions regimes? So wondering if any of our panelists, all of our panelists, have thoughts on sort of promising areas of legal restriction on sanctions that could be explored more by lawyers that might not have been pressed as hard or as creatively as they might have been, but perhaps could be. Maybe that's an unfair question, but can I go to you first, Andrew, and come down the line if you have thoughts?
Sure. Within the US, historically, there has just not been a lot of success, to the point where there are not a lot of cases. There's just not a lot of case law out there because the early cases squashed a lot of this. That said, there are cases working through the courts right now where my sense is that there may be more purchase than had previously been the case. One area of that, it has to do with the due process rights around classified information and the ability to pierce the otherwise sort of black box of redactions that folks get when they ask for the designation package. There are clearly sensitivities around this, and unlike my sense of the UK or EU regimes, it's not just in the US, it is quite a rigorous process to be put on the list in most cases, and classified information does play a large role in that. But the due process restrictions are just so obvious and tangible. My sense is that there is some daylight that courts are beginning to be willing to explore there. And to, I think, a comment from an earlier panel on the impact of some recent Supreme Court cases that do away with much judicial deference to agency interpretations of their own statutes and regulations. There's almost certainly going to be more litigation around how OFAC reads its own rules with respect to general licenses and specific licenses in light of that Chevron deference falling away.
Nathaniel, if I may, you can reject my my supplementation here and just go with the original question. But one of the things I was interested in reading through your organization's checklist, and something that, you know, we've heard a little bit today, is thinking about the idea that there might be restrictions on sanctions coming from international humanitarian law, from international laws of war, which is, but so, you know, it's, if you want to go in that direction, or, you know, human rights law, your refugee law, whatever you're interested in, please.
Yeah, I mean, IHL is very toxic. You don't want to raise IHL as is for, you know, sanctions policymakers. The minute that kind of discourse is evoked, because it comes with the baggage of, you know, sanctions is a tool of war, it's a tool of coercion, and that is very actively resisted by the major sanctioning power. So I think that avenue is a no-go. We can use certain analogies from that. We can use certain equivalences and bring out certain types of reasoning out of that. I mean, someone has already mentioned about siege, prohibition of, in the context of siege, for example, or one key example is the prohibition of against civilian reprisal, and that we have in IHL. The IHL prohibits the generalized reprisal measure against the population. To what extent can we contextualize and interpret it in the context of a rather permitted economic activity, economic sanctions? That is an ongoing debate, but I think there's a possibility to make some kind of inroad in these discussions. It's very interesting that the EU, just as recent as about 4 years ago, 5 years ago, there were serious proposals in the EU to bring the question, you know, before IMF, that perhaps certain kinds of financial infrastructure that we have in the world should be, quote unquote, politically neutral. And at that time, the discourse was specifically about the SWIFT. And the EU at that time was very afraid that SWIFT was being utilized, instrumentalized by the US so much that they kind of were losing control and kind of would backfiring. And there was serious discussion by top level EU people to consider creating islands of financial infrastructure. So that could be the equivalent that we can come up with. Here is a civilian island, or let's call it a civilian objects, to use an IHL equivalent. The certain very basic, very elementary financial access routes should be politically neutral, should not be part of any party's sanctioning exercise. Those could be the kinds of, I mean, that pathway now seems a very remote possibility because the past 3 years have dramatically changed the discourse. But I don't think it's a lost cause, at least in terms of, you know, holding them to that kind of argument. It's possible to make those kinds of arguments. Like, there is a possibility to make certain types of islands, politically neutral islands in this interconnected global financial system for some people to survive within the financial means.
You also free, of course, to go whatever way you want, but there's, you know, sort of potentially interesting areas of legal challenge that sort of haven't come up yet today, you know, whether it's in BITS or WTO law or some other things, but, you know, of course, do what, you know, go where you'd like to go.
There are some BIT challenges, investment treaty challenges coming through. I mean, it does depend a bit what our Supreme Court say about this. Every little helps. You know, and more generally on that case, I think if they uphold what's been said before, delisting challenges are hard. I think there are some cases where you have to try and find a sort of hard-edged legal question. So there was one case I was discussing earlier with Josh where someone said that there was no power in the government to sanction someone for their speech. You know, someone who was producing what the government described as pro-Russia propaganda was sanctioned and tried to argue that there was simply no power to do that. He lost. But that kind of, anything that isn't a challenge to discretionary power has more hope of succeeding. I think that there may well be challenges to enforcement decisions in the sanctions sphere. So traditionally, the EU did basically no enforcement, in contrast to the US, which does a huge amount of very powerful enforcement. The EU does a lot of compliance. You know, people are remarkably compliant with sanctions, given how little public enforcement there is. But there will be, I think, enforcement decisions coming through, and I suspect that there may be more you know, grist for challenging those, possibly licensing decisions, although again, quite a broad discretion is given. Where there is a lot of litigation, as some of you here will know, is in the more commercial sphere. So there are lots of cases in arbitration and litigation about, the impact of sanctions on contractual relations. So you didn't pay because you were afraid of sanctions. You didn't pay in an English law contract because of US sanctions. What's the impact of that? There are lots and lots of those. And there, of course, you don't have the public law deference to government area. So much more potential for interesting arguments.
So, yeah.
Actually, your last comment was kind of the basis of my question insofar as sanctions issues come up in private litigation. I'm curious what you or any of the other panelists have seen in terms of courts encountering sanctioned regimes from other jurisdictions. So EU courts encountering US sanctions, or US courts encountering sanctioned regimes from other countries, or Western countries encountering Russian sanctioned regimes, whether courts are deferring to those regimes, furthering those regimes' purposes, or taking a more critical approach or a more narrow approach, and whether kind of the judiciary in that sense is advancing the goals of these sanctioned regimes or hindering them in the way they treat these cases.
Anyone? I don't know. Andrew, Maya, Nathaniel, anyone want to go first on this? Go ahead.
Yeah, okay. It just reminded me of a case from Austria, I suppose, Targa versus West Bank. I don't know if you might recall it, a year or 2 years ago, where it brought out the question, so the dispute between private contracting parties, but the extent to which this sanctions clauses in commercial disputes, to what extent can they be utilized? And the key question was, the bank relied on that clause to terminate its relationship. And the clause, what it essentially says is, when the bank has cause to believe that the relationship exposes it to regulatory default, meaning the sanctions exposure, then they can terminate the relationship. And the applicant's argument was, shouldn't that clause be exercised with reason? That shouldn't private actors be required, when they built in these clauses in contractual agreements, that suspicion shouldn't it also be reasonable? Because otherwise any contracting party could invoke that and say, I fear I would be exposed to sanctions because of certain type of unsubstantiated grounds. And I thought that could be an interesting commercial implication of sanctions in terms of parties.
Putting on sort of the DOJ hat for a second, the ability to go and enforce U.S. sanctions abroad is entirely a political question when you're going to courts outside of the United States. In the context of the Russian sanctions, the difference between February 2022 and post-February 2022 could not be a bigger sea change. In the lead up to the full-scale invasion, in cases that I ran as a prosecutor, we would go to the UK, we would go to France, go to Spain, and ask for cooperation in an investigation or an arrest or a seizure, and almost never get traction. The UK was polite enough to just not answer, but the EU generally said no, because they didn't have sufficient dual criminality is what they would say. And that would become a fight about what the relevant extradition and mutual legal assistance treaties have to say. Post-invasion, that changed entirely, purely because of the political winds. You see a handful of examples where I can think of a couple of cases in Germany where in export control situations, they're looking very minutely to see if precisely the same technology is barred in both jurisdictions. But generally in the Russian context, there's quite a bit of cooperation. But the way that you can keep an eye on the fact that this is ultimately a political question is totally different outside of the Russian context. In the Iranian context, for sure, in the Venezuelan context, in Cuba, obviously, good luck getting any sort of enforcement traction if you're a U.S. prosecutor outside of the U.S.
Did you want to say anything on this, or should we go to another question? Up to you.
Just very briefly,
Yeah.
so US sanctions come up a lot in UK courts, less EU courts because there isn't really a private law jurisdiction there. But and what happens is US lawyers, some in this room, are then experts on US law in the UK courts, and the issue is really what's the effect, or what does the US law say, and then what is the effect given the sanctions clause in the contract, or if there's no sanctions clause, if it's unlawful in foreign law that isn't the law of the contract. It depends very much on the situation. On counter sanctions, this is coming up a lot in the context of jurisdictional fights. So there have been a lot of anti-injunctions brought trying to enjoin proceedings in Russia, some very high-profile ones where there's just battles between different courts trying to injunct proceedings in each case. And then final point, to Andrew's point about Cuba is of course, sometimes the position is that it is unlawful in the EU to comply with US sanctions, notably on Iran, in this strange EU piece of legislation called the blocking regulation, which now has a UK version as well. And actually, Davika and I were talking about this earlier in the context of ICC sanctions. Query, might the EU make it unlawful to comply in the EU with US ICC sanctions? Who knows, but that would be an interesting move.
Thanks everybody for a fascinating panel. And so I'll just have three kind of rapid fire questions. So Maya, I remember around 2015, 2016, the EU actually developed a mechanism for reviewing classified information in the context of designations, but to my knowledge, it had never been used. I wonder if that's still the case, if you have any speculation as to why not. I think I have some speculations as well, but also if that wouldn't be a way to solve some of the due process issues, because then you could actually have something more like real evidence rather than this kind of hearsay that you get off of open source stuff. For Nathaniel, interesting to learn that the EU hasn't instituted the December carve-outs, but I wonder if how much in your sphere people talk about the material support statute in the US, because although OFAC exempted the sanctions regulations in those areas, material support still sits there and is potentially applied to almost all of that same activity and is still a real threat to humanitarian actors in that space. And finally, for Andrew, I'd love to hear more about making deals with bad people and what that looks like in the OFAC licensing context. Thanks.
Why don't we go reverse order?
Much of that is classified. So in the OFAC context, it's rare, few and far between. I would say more often the deal is to keep people off the list to begin with. So you need to sort of be in the universe of people who suspect that you might be about to get sanctions and be savvy enough to get in front of it and be connected enough to go and do that. You can sort of look at the list of people who seem really prominent and who are not on the sanctions list in the US and guess who that might be. But the upshot is just keep me off the list, right? Once on the list, the way that OFAC is arranged right now, the sorts of arguments that it requires under its regs, as you know, tend to be about jousting on the facts themselves. Like you're essentially required to go show that OFAC got it wrong, that you're not a bad guy, that you're not actually associated with this person or that thing. And the difference between that and what I think of as the more sort of prosecutorial mindset is in the DOJ cooperation world, it's a given that you did what you did, and we're still going to make a deal for some broader benefit. That is not something that I've seen OFAC engage.
And that's the move you're suggesting, basically.
Good question. Thanks, Josh. The EU, I think I should have clarified, the EU has transposed 2664, but it wasn't as quite extensive as the US did. So what it did was it applied them to the ones that actually implement Security Council sanctions and some of its autonomous sanctions regimes. And in those cases, it also made them not in a permanent sense, but renewable. So there's continuous discussion. And also the substantive basis is not defined as extensively as the US did in terms of listing all of these activities. It basically says basic human needs and humanitarian activities. Another way of saying, I apologize for bad-mouthing the EU. There is some humanitarian exemption. In fact, in one aspect that it is better than the US in that regard is it designated a special humanitarian contact focal point for humanitarian actors to get information, although that information constantly seems to be like a bouncing back. But anyway, there is that kind of gesture from the EU towards that. In terms of material support, I think the general, particularly with respect to counterterrorism sanctions regime, things are comparatively the same because material support is anyway under the counterterrorism sanctions regimes. They're still prohibited, even in the EU context as well. And one thing we shouldn't forget is the exemptions. I mean, all the big story I talked about, humanitarian exemption, it only concerns financial restrictions, asset freeze. And that's one of the big structural problems. It only loosens the financial support elements. So the only other free speech dimension, engagement dimension, they are not included even in the UN and in other exemption regimes. So that's a big structural problem.
So on closed procedures, there is, you're right, there was one developed. It's never been used. I think the reasons may be, first of all, the EU doesn't really have evidence gathering capability in the same way that the US does. It relies on, proposals from member states who obviously could, but my guess is that, but this may be wrong, that there aren't many cases where there is a classified file. I don't know whether that's true. But if there were, the problem with the system is it means sharing information with 27 other member states, or 26 others, I guess. And I suspect that the potential for it to leak is just too great if it really is classified material. And just final point, Andrew's point resonates very much with me on this idea of some form of face-to-face negotiation with the government. It's not one that the UK or EU engages in, to my knowledge. But to my mind, it could be a real PR hit for governments, but not that may be very politically naive. But why can't they say, look, this is fantastic. Look at the change behavior we've managed to create. This is targeted sanctions actually doing something. Look at all the people who have divested from Russia. Look at all the people who have done whatever it is that the governments want them to do. And it's that aspect I don't fully understand why this couldn't be seen as a governmental victory. And as Andrew said, actually bag some, give us information on who else we should be listing. There's all sorts of material that could be potentially extracted from designated people, but at the moment they're not being met with face to face to have those conversations at all.
Andrew, did your paper talks a little bit about some of the difficulties of doing this. Yeah.
Yeah, just in quick reaction to the last point on my side, there is, if I think in part today, there is a mostly cultural sense within OFAC and state here that we need the PR win. Like we have to have that in order to justify anything that we might be able to do. The problem, realistically, is that no one wants to be known as the guy who cooperated against the Kremlin. And so, well, you won't get those people coming in. What you need is, in order to make this work, a system that incentivizes a more subtle sort of cooperation regime, and one that removes the fact or the moment of cooperation from the moment of publicity.
Yeah, that was one of the, I thought, quite nice points that you're developing in the paper, which is that some of the efforts at reform to have more congressional oversight, reporting to Congress and all that stuff, that could end up hindering the ability to work with people because, the fact that you're talking about cooperating could be exposed much earlier. And so that then the political hit happens right away when the benefits haven't accrued yet from being able to say, we now actually have a deal. Anyway, read his paper when it comes out. I think Perry Betchke here has a question for us. Oh, is there another one before? All right. Sorry.
I was just curious, how pervasive is digital sanctions avoidance. You hear companies like Elliptic, Chain Analysis reporting on it regularly, and you hear about North Korea's, Lazarus Group hacking the system, to fund weapons of mass destruction. I was just curious how pervasive it is. Thank you.
So the North Korean situation is sort of different than Russia, Iran. There's in addition to there being sanctions that relate to that, it's also just fundamentally a massive industry of fraud that props up a lot of the economy. And cryptocurrency is certainly the sort of the asset of choice for the end point of that fraud. That said, I don't mean to suggest that is like the driver for the purpose for digital assets generally. And beyond the sort of North Korean hack and theft situation, it's not a massive point of transfer for sanctions evasion for a number of reasons. One is, I think, structurally, technologically, it's slower than people sort of think it might be. If you want to move $1 billion, crypto is not a great way to move $1 billion. There's just structural reasons why that's too expensive and too slow. And the volatility that exists is not a great place, I think, to park large amounts of wealth that you want to hide from a sanctions regime. So I would not expect that you're going to see, billionaires and oligarchs putting the sort of money that they put into real estate into crypto.
Thanks, Andrew. Perry Betschke from Berliner Corcoran and Rowe. And I think my comment relates to things that both Andrew and Maya have said. There's something that OFAC likes to say, and then lawyers like me like to say that OFAC said, which is that sanctions are not a punishment. They're meant to be an inducement to change behavior. But then when I listen to what you say, I'm wondering, do you think that that is actually an accurate statement of what OFAC does, and to some extent what the Europeans and UK does? Because I hear about things like you were sanctioned for something that you did in the past that you can't undo, and in some cases wasn't even wrong at the time that you did it. You were just a business executive in a company, a Russian company before the war. It's not like that's an inherently immoral thing for you to have been doing at that time. And then we hear also about procedural problems and delays and all of that of getting off the list. So it just makes me wonder, I mean, are sanctions an encouragement for change of behavior? Or are they punishment, or are they something else?
Anyone who wants to step up, feel free. In practice, they don't incentivize a change of behavior. There's no ability to engage in a way that would allow for somebody to demonstrate a true change of behavior. That's, I think, the current reality, regardless of what the rhetorical or sort of programmatic line is. And if that means that they are effectively punishment, then I think that's a totally fair way to read what's happening on the ground.
Yeah, I completely agree with that. I think the more difficult question is, why are they then there if they're not doing what they say they are doing? And I think the answer to that in part is, signaling. They're sending some kind of signal. The question, as Peter said this morning, is what actually is the signal, and is it being received in that way? Also, it is a tool of foreign policy, and to some extent, with targeted sanctions, governments have a very strong political drive to be seen to be doing something, and announcing the designation of large numbers of people at least fulfills that purpose. Whether there is, in fact, a more subtle calculation about the theory of change in any particular case, if you ask the government, they would say yes. And their written statements to court saying, here is how we think that targeting works, is afforded 100% deference by the judiciary. So certainly what they say is, here is why we've put this person on a list, and here is why we think that their behavior is going to change. So if there was someone from government here, they would strongly disagree, I think, but
Yeah, I mean, to Maya's point, and to maybe make a slightly more charitable view on it, one way in which we talk, or the DOJ and OFAC talk about affecting a change is not just you particular oligarch get your heart and mind right and join the side of the light and the good. It is, we actually want to have a negative impact on some aspect of a targeted economy. That is the change that we're talking about. And in some cases, what that means is if there's a particular business person or a particular business that is critical to chartering airplanes to nickel mines in Siberia, we're going to go after that person, and it doesn't matter if they profess a love of Ukraine and a distaste for the Putin regime.
Yeah, I think that was what Peter Harrell this morning called the degradation purpose of sanctions, which seems like a nice word to capture it.
Sure.
I think we probably need to wrap up. Yeah, am I getting?
We actually have time for one more.
That's the one.
Last question of the day. No, that was we have one more.
All right. Who do we have?
What opportunity does the situation in Syria, if I know it's too early, but there's regime change, and if there is that able to reestablish the civil society, what opportunities does it present? What will the institutional measures that could be taken? Are there lessons to be learned if that society is able to establish, if that regime is able to establish a civil society?
Nathaniel, do you want to have the honor of being our last speaker today?
Very quickly, because there's been a very lively discussion. As soon as the Syrian political situation dramatically changed in the sanctions world, there's been an active discussion. And for so much of the very high-spirited discussion about how to use sanctions in a very dynamic, responsive way, I think governments were perhaps understandably a bit muted in the immediate reaction as to whether and to what extent they would lift sanctions. And I think some governments still want to see certain kind of, I mean, there has been announced certain liftings, but not, given that Syria has been one of those countries that has been under near comprehensive sanction for an extended period of time, the amount of intervention it requires requires a significant political will. But I think the particular composition of the emerging Syrian government has made that task a bit difficult, in the sense that I think Western governments don't want to throw away all of the leverage in terms of what the future shape or trajectory of the Syrian government would look like if they preemptively restore or revoke sanctions. There's been a significant push from the humanitarian community that one way to make sure that this emergent government would not be aligned to the wrong kinds of actors around the world is to actually enable its economic survival immediately by restoring the economic pipelines, etc. So I think it would be more for government people to interject from a policy angle perspective, but there's both sides of the argument currently.
All right, I'm just going to preface this last comment with, it's like we're at a graduation. You say, please hold your applause till the end. So I want to thank our incredible panel here, all the other speakers at previous panels, our terrific audience, both here in person and on Zoom, Kaylee, Will, now Shravya, the International Law Journal. So now you're allowed to clap. Thank you. And I think probably our master of ceremonies, or maybe a new master of ceremonies, might have a final announcement about refreshments.
Hi, everyone. My name is Shravya Ralapalli, and I am the managing editor for the Fordham International Law Journal. Just a couple of concluding remarks and acknowledgements here on behalf of the journal. First, a huge thank you to Kaylee Marr for being the mastermind behind the symposium. What all of you are seeing today is just a mere fraction of the time, the months of effort, and the energy that she has invested into this. Listing out everything that she has done in service of today's event would require us to stay for the length of at least 2 more panels. But I think we're all excited for some refreshments, so I'll just say this. She has truly gone above and beyond, and even more amazingly, has kept her wit and sense of humor intact throughout the whole process. Thank you for everything, Kaylee, and a huge thank you also to the Marr family for your incredible support. We are very touched by your generosity and kindness, and we appreciate everything that you have done for this. Thank you to our speakers for enriching today's symposium with your legal and historical expertise and wisdom. We know many of you traveled across the world for this event, and so it's truly an honor for us to have you. A huge thank you to Professors Kent and Mintzner for their support as ILJ's faculty advisors, and in particular, Professor Kent, along with Professors Lee and Cohen, were the ones that came up with the idea for the symposium and helped bring together and moderate the panels that you saw today. And also thank you to Dean Bookman for her continued support of the journal as well. A shout out to the ILJ board and staff for their work, not just today, but throughout the whole academic year in advancing Fordham's contributions to international legal scholarship. Fordham ILJ is currently in its 48th year of publication, which is very exciting as we approach the 50-year mark. In that time, ILJ has grown to become one of the most competitive international law journals in the world and is consistently ranked in the top 10 of student-edited periodicals dedicated to the study of international law. We pride ourselves on publishing scholarship that covers a wide range of topics that are highly relevant to today's political landscape, such as economic sanctions. To that end, it is our privilege to have the opportunity to publish scholarship written by many of the speakers you heard today in our next publication, set to come out in the next couple of months. So if today's discussions sparked a newfound or a continued interest in economic sanctions, we encourage you to be on the lookout for our next book, which will cover the topics you heard today and may even incorporate some key insights from today's discussions. Continuing with my acknowledgements, thank you to Fordham Media Services and the Office of Public Programming for your endless help in putting the event together. And lastly, thank you to our attendees, both in person and online, for supporting in the symposium and tuning in. I'm going to turn it over to Kaylee now.
I'm sorry if I look disheveled. We're having a bit of a cookie crisis at the moment, having to do with refreshments that are about 10 minutes away. So I ask for your grace in putting up with a feisty bakery at the moment. But anyway, thank you guys so much, everybody online, all the speakers. What a phenomenal day. I hope we made you smarter. I know I am now smarter. And so with that said, I just really want to thank particularly the Law Journal. You know who you are, everybody. The organizing professors, Dean Bookman, what a massive effort on everybody's part. So thank you for attending. I hope you enjoyed it. And here's to next year.
Yeah. Thank you guys both for your time. That was great. I wasn't just buttering up. I think it's very